universal childcare in Scotland, something that no other government at Scottish or UK levels has ever done before.
Thank you. That concludes question time and brings us to the next item of business, which is Stage 3 proceedings on the Children and Young People Scotland Bill. Thank you. I have a point of order from Neil Bibby.
Presiding Officer, I wish to make a point of order. This morning, the Finance Committee considered the supplementary financial memorandum on the Children and Young People Bill. During this meeting, members were informed by Scottish Government officials that the Scottish Government is, and I quote, not in a position to offer a revised estimate for the capital costs of this bill. This is in direct contravention to the Standing Order 9.3.2, which states that a bill shall be accompanied by a financial memorandum which shall set out the best estimates of the administrative, compliance and other costs to which the provisions of the bill would give rise, best estimates of the timescales over which such costs would be expected to arise, and an indication of the margins of uncertainty in such estimates. I understand that the Finance Committee is very concerned at this failure and has written to the Minister asking for an urgent explanation. I would welcome your advice on the implications of what is a clear breach of the standing orders by the Scottish Government, what that means for the debate this afternoon, and whether this would set a precedent where 9.32 in the standing orders no longer applies.
Thank you very much, and I thank the member for some prior notification of this point of order. So, having given it consideration, the standing orders of the Parliament are clear that under Rule 9.12, the financial resolution was passed by the Parliament at Stage 1 of this bill, and a supplementary financial memorandum was lodged as required by Rule 9.78b as a result of amendments that were agreed to at Stage 2. Supplementary financial memorandums must set out the best estimates, as the member mentioned, of the administrative, compliance and other costs to which the provisions of the bill would give rise. Now, I appreciate from what the member has said that the member has concerns about the information that has been provided in the supplementary financial memorandum to the bill, and it is of course perfectly legitimate to then raise those points in debate. But it is also then up to members to what extent they take this into account in taking a position on amendments and the bill itself. The current rules do not require that the Parliament passes a resolution on a revised financial memorandum. The member, of course, does raise an interesting question with that point that he makes, and he might, in that case, like to write to our Procedures Committee, because, as he may know, they are currently reviewing the legislative processes in this Parliament. So that's the answer under the standing orders at the moment to the financial resolution, and members may, of course, wish to raise these points as matters of debate. That then brings us on to consideration of the business of the Stage 3 proceedings, and I'm going to allow a short pause for members to take their seats and to consider that they should have the bill as amended at Stage 2, which is Scottish Parliament Bill 27A, the marshalled list SP Bill 27A M to L, and the groupings SP Bill 27A to G. The division bell will sound and proceedings will be suspended for 5 minutes for the first division of the afternoon, and the period of voting for the first division then will be 30 seconds, and thereafter I will allow a voting period of 1 minute for the first division after a debate. Members who wish to speak in a debate on any group of amendments should press the request to speak buttons as soon as possible after the group is called, and I would be grateful if members would now refer to the marshalled list of amendments. And we are very tight for time this afternoon, can I just make that clear? I call Group 1, Duties of Scottish Ministers in relation to the rights of children, and I call Amendment 116 in the name of Jean Urquhart, which is grouped with other amendments as shown in the groupings, and I ask Jean Urquhart to move Amendment 116 and speak to all amendments in the group.
Thank you, Deputy Presiding Officer. The stated policy intention behind this bill is to contribute to Scotland being the best place for children to grow up, and I applaud that intention. It's vital to the sort of Scotland we would wish to create, which recognises the vital contribution children and young people play in our society and our communities, and which also recognises that in order for them to make that contribution, they deserve and require our respect, our protection and our nurturing. I welcome the provisions in Part 1 of this bill, but like many organisations and individuals working with and for children in Scotland, I'm disappointed that Part 1 does not go further. Accepting all of the amendments put forward today at Stage 3 would go some way to progressing our commitment to children's rights, and I believe that accepting Amendment 116 forms a key part of that commitment. My amendment seeks to place a duty on Scottish ministers to establish a body within 1 year of royal assent to examine the case for giving the UN Convention on the Rights of the Child legislative effect. I recognise that the Government has intimated that they believe full incorporation to be unnecessary and that the Committee's Stage 1 report raised questions over how this could be done in a meaningful way. And although I hear what the Committee have said about incorporating children's rights, I would ask why we need evidence to accept that children have rights the same as adults, which should be upheld and promoted in law. The same arguments were not made when the case was being made for the adoption of the ECHR, or when extending the Human Rights Act to apply to devolved matters during the passage of the Scotland Act. If we did not require evidence to apply human rights to our domestic law, why do we need it for children to have rights in law? There has been strong support from both the children's sector and the human rights sector for such a move. Incorporation of the UNCRC was supported by UNICEF, the Scottish Human Rights Commission, Scotland's Commissioner for Children and Young People, the NSPCC, Families Outside and Together. This amendment itself has the support of Children First, Bernardo's, Together, YouthLink Scotland, Scotland's Commissioner for Children and Young People and a number of academics across the legal and sociological disciplines. For such a move to be supported by such a wide range of interested organisations surely suggests it has merit. This bill should not mark the end of our journey in this process, but the beginning. We can commit today to explore how to incorporate children's rights into our legislative framework, to signal our intent to make our society truly a child-centred one, and to commit to recognising children as having rights in their own regard, which all of us should be willing and devoted to pursuing. As drafted, my amendment gives Scottish ministers considerable scope to determine how best to achieve this. Setting up a body, such as an independent commission, to examine the options would make the sort of statement I would hope we can all support. It wouldn't require Scottish ministers, nor indeed this Parliament, to commit to anything other than the establishment of an appropriate body and to consider its report. But even in doing this, we would be sending a clear signal about the importance we attach to children's rights and provide a clear message about the seriousness of our commitment to make Scotland the best place to grow up. I therefore hope that Scottish ministers, and indeed all MSPs from all political parties and none, will support Amendment 116. And I will move the amendment.
Many thanks. And I call on Liam MacArthur to speak to Amendment 117 and other amendments in the group, please.
Thank you, Deputy Presiding Officer. This bill represents the coming together of two pieces of proposed legislation, one of them a bill on children's rights. And as Jean Urquhart's already identified, the Government does appear to have largely lost sight of this specific aspect of what we should be trying to achieve. The Law Society and Faculty of Advocates both said the bill added little to what's already in place and in some respects diluted children's rights. Our committee concluded at Stage 1 that the duty on ministers was, quote, little more than a restatement of existing obligations. While improvements were introduced at Stage 2, the Children's Commissioner is clear that so far the opportunity has been missed to be ambitious for children's rights and to embed children's rights in Scotland's governance and public services. My amendments are an attempt to address this, not just in relation to this bill, but with respect to future legislation in this Parliament. Like others, I didn't feel the case was made for full incorporation of UNCRC, but do believe more can and should be done to incorporate key principles, notably Articles 3 and 12. The idea was proposed by Tam Bailey in his Stage 1 evidence and backed by a wide range of children's charities. Despite that, the Minister and her colleagues refused to support any of my amendments at Stage 2. Parliament, though, should have a further opportunity to consider these issues and take a view. My amendments 117 and 118 reflect what we have heard about the need to put children's rights and interests at the centre of this bill, make sure their voices and views are heard, and give proper effect to the principles that should underpin it. Sadly, the Minister's Amendment 93 won't do that, and while I have sympathy with Jean Urquhart's amendment, the important thing is to get substantive and meaningful changes into the bill now. At stage 2, I also sought to beef up the reporting requirements on ministers with regard to steps taken to comply with the duties placed upon them. All those amendments were rejected, but I am pleased that Neil Bibby has taken up the cudgels at stage 3, and I will be supporting his efforts. I'll be interested to hear Alison Johnson's comments regarding her amendments. I am instinctively sympathetic, but it is perhaps unfortunate that these were not lodged at stage 2 to enable more detailed consideration and, if necessary, refinement. As for my final 2 amendments here, these look to safeguard children's rights in terms of future legislation. Amendment 126 repeats one I lodged at stage 2 and would require child right impact assessments to be carried out on every relevant bill introduced to this Parliament. This still gives the Minister discretion about how widely it would apply, but would allow us to reflect the Education Committee's recommendation, follow the lead taken in Wales and deliver a cultural shift in the way we view children's rights. The Minister has argued that undertaking CRAs would be delivered through non-legislative means, but that its UNCRC action plan from 2008, the Government committed to trialling CRAs, since when not a single one has been carried out. Finally, Amendment 125 tries to skin the cat another way, placing a duty on ministers to make a statement or assessment of compatibility with the UNCRC, as currently happens with regard to the Human Rights Act. This approach works well in Australia, I understand, and I hope if Amendment 126 remains unpalatable to the Minister, 125 may be an acceptable alternative. Deputy Presiding Officer, on children's rights, this bill remains a missed opportunity. As the Children's Commissioner makes clear, without my amendments and others in this grouping, the bill, quote, will fall far short of matching the high ambition to make rights real, often stated by ministers. I urge Parliament to vote to put that right. Thank you.
Thank you. Minister Aileen Campbell now to speak to Amendment 93 and other amendments in the group, please.
Okay, thank you, Presiding Officer. And I welcome the opportunity to respond to the range of amendments focusing on Part 1 of the bill. And this bill will ensure children's rights properly influence and the design and delivery of policies, services by replacing new duties on ministers. Turning first to Amendment 116, which proposes the establishment of a new body to look at legal implementation of the UNCRC. This proposal seems similar to the suggestion by the Commissioner at stage 1 for a parliamentary inquiry to look at UNCRC incorporation, a suggestion that wasn't pursued by the Education and Culture Committee in its report. We already have robust structures for holding ministers to account around their approach to the UNCRC. We have the Scottish Parliament and its committees, we have the Children's Commissioner, and we have a national implementation group for children's rights. So I would suggest that another body is not what's required at this time, and even if it were, there is no need to legislate for its creation. UNCRC incorporation was the subject of a great deal of discussion at stage 1, with a range of views offered by key figures with expertise in children's rights and the law. The Education and Culture Committee carefully considered the arguments put forward and was not convinced of the merits of incorporation. As Professor Norrie said, I think that to incorporate the Convention into the domestic legal system of Scotland would be bad policy, bad practice and bad law. I say that primarily because the UNCRC was not drafted or worked to create directly enforceable legal rights into domestic legal systems. But we will absolutely continue to engage with partners about how we can strengthen children's rights through the fora that we already have in place, which I've outlined, and build on the strong foundations set out in this bill. And this is absolutely a good starting point to develop further the UNCRC. Now, I want to turn now to Amendment 117. A similar amendment was considered at stage 2. Now, as then, we have concerns around the introduction of the concept that children's interests should be a key consideration. The UNCRC clearly recognises that children's best interests should be a primary rather than a key consideration. That is the standard we should be working towards. However, it does not make sense to pursue such a broad-ranging principle through blanket duties on minister. To do so opens up the risk of unnecessary litigation which serves nobody's interests. Moving to Amendment 118. It makes sense to consider the proposal alongside my own Amendment 93, which also focuses on the views of children. Our amendment stems from a suggestion made by stakeholders that the Government should consider incorporating Article 12 of the UNCRC, recognising a child's right to be heard. Our position remains that implementation of Article 12 is not best achieved through a blanket duty. Instead, we require targeted changes tailored to individual circumstances. Nevertheless, we remain keen to explore how our commitment to Article 12 can be realised, and Amendment 93 is designed to ensure that children's views feature in ministerial decision-making. Amendment 118 goes further than my own by requiring ministers to actively seek the views of children in relation to all decisions. And I recognise the value of consulting with children and young people, but it has to be done in a meaningful way. My amendment addresses this point by offering flexibility around when to consult, and it's for that reason that I would encourage the Parliament to support my Amendment 93 as an alternative to Amendment 118. Amendments 119, 120 and 122 represent a radical departure from our current system for protecting children. They would impose a duty on ministers to take all measures to protect children from violence and ill-treatment. And I absolutely welcome the intention behind what is proposed and respect Alison Johnson's commitment to children and young people. This duty may be impractical and would be impossible to satisfy. Ministers can bring forward legislation and policies to protect children. However, we can't guarantee that a child will be safe from violence and neglect in the way that the amendment seems to require. Furthermore, the amendments fail to recognise the central role that many other bodies must play if we are to effectively protect children. Our system does not provide for Scottish ministers to work directly with individual children and their families on a day-to-day basis. Instead, it is founded first and foremost on a strong multi-agency working at a local level. It is an approach that continues to deliver an ever-improving system for supporting our most vulnerable children, as evidenced by the many inspections of children's services that have been undertaken over the years. These amendments cut across all that. They fail to recognise that the people best placed to support children are those who have most contact with them and their families. And our focus must be on strengthening those relationships, because that is what our children need. Getting it right for every child builds on that approach. Now, I've just described, and it's through the effective implementation of that model that we will best be able to ensure all children, including all those at risk of violence or ill-treatment, get the help and the support that they need at the time they need it. Amendment 121 seeks to recognise the important role that the UN Committee plays in shaping our approach to children's rights. And while it's important to recognise the excellent work that the committee does, the bill is not the best place for this. Furthermore, I'm not sure what practical difference would be achieved by the amendment. Any steps taken in response to recommendations from the committee would already be captured by our bill's existing reporting duties. Turning to Amendments 123 and 124, again that was debated at stage 2. There is now a well-established expectation that ministers will consult stakeholders as part of the policy development process. Accordingly, there is no need to identify every instance in which consultation is necessary and with which organisations. I'm sure we'd all recognise that when it comes to engaging children, our practice is perhaps not as well established, and that's why we took steps at stage 2 to introduce section 13A, which ensures that children will be consulted on ministers' UNCRC implementation plans. Amendment 124 places a requirement on ministers to consult every 3 years on the steps taken to secure better or further effect of the UNCRC. At stage 2, I made clear that I could not see the value of consulting on a list of steps which ministers had taken with a particular aim in mind. After all, that's quite different from producing a plan of future actions where there is scope for influencing that activity. That same scope simply doesn't exist in relation to a retrospective report. Amendments 125 would require ministers to prepare and publish a statement of UNCRC compatibility for all future bills. This would create a huge degree of overlap between the proposal and the Child's Right Impact Assessment proposed by Amendment 126 and create a system of unnecessary bureaucracy. And as I made clear at stage 2, the Scottish Government recognises the importance of assessing our decisions against the rights of children, and we are developing a Child's Right Impact Assessment for use across government. This is a direct consequence of the duty included at section 1.1 of the bill. Therefore, 125 and 126 are disproportionate and unnecessary. So, for all those reasons, we can't support any of... I'm just literally closing.
Liam MacArthur.
To the Minister for taking an intervention. I listened carefully to what she was saying. She seemed to be concerned that 125 overlapped with 126, which would make sense if she was going to accept either, but by the sounds of things she's going to accept neither. But more specifically, in terms of the UNCRC action plan published in 2008, as I made clear, it was indicated the government was committed to trialling CRIAs, since when we have not seen one in the intervening years. Can she perhaps indicate when we might see the first CRIA piloted under this action plan?
Minister.
Developing that, and we will develop that, and we'll make sure that that is something that we do achieve to make sure that we do make right shield for children and make sure that UNCRC is much more keenly felt through the government's wider agenda. Now, for all the reasons that I've outlined ahead of Liam MacArthur's intervention, we can't support the amendments in this group, and I do seek, though, however, the support of the Chamber for Groups 93. But I would add in that I do absolutely respect the role in which Liam MacArthur, Alison Johnson, Jean Urquhart, and the way in which they've set out some of their arguments today, and I hope that together we can work on achieving more on the UNCRC and work together to make rights real for children in Scotland.
Many thanks. Now call on Alison Johnson to speak to Amendment 119 and other amendments in the group.
Thank you, Presiding Officer. Articulating the potential impact of the United Nations Convention on the Rights of the Child on children's lives has at times been difficult to do through this bill. Some see the UNCRC articles as very technical in nature, but many of these articles relate directly and emphatically to real and practical improvements in children's lives. Article 19 of the UNCRC is one such example which requires states to take appropriate measures to protect children from all forms of abuse, neglect and violence. Successive Scottish governments have made progress to be proud of, but there is always much more to do. Too many children still live in fear of abuse, neglect and violence, missing out on their childhoods as a result. I note Liam MacArthur's comments regarding the arrival of my amendment, but I know that he agrees that we must continue to strive to do all that we can to give children the best start in life. And my amendment 119, which uses almost exactly the same language of Article 19, aims to make sure governments have to do exactly that, strive for the best and comply with the UNCRC. And the intention is to create an overarching national approach to protecting children from abuse, neglect and violence, and modernise criminal provisions in this area, which are now 76 years old. The obsolete parts of Section 12 of the Children's Act of 1937 have been repealed, but that's the statute our authorities continue to rely upon to protect children from harmful criminal acts of abuse, neglect and violence. And adopting Amendment 119 would provide a holistic framework within which to work to protect children. I note the Minister's concerns regarding the adoption of this article, but I hope the Minister can respond to the points about modernising the legislation and say how, if this amendment is not supported, the Government will progress the protections that protect children in Scotland. Thank you.
Many thanks. Now call on Neil Bibby to speak to Amendment 121 and other amendments in the group, please.
Thank you, Presiding Officer. I welcome the opportunity to speak to my amendments 121, 123 and 124, as well as the other amendments in the group. I join members from all parties in welcoming the general principle of raising awareness of children's rights, but it's clear that this section in the bill could and should be improved and go further. During the Education Committee's scrutiny of the bill, we heard a number of witnesses say that in reality this section of the bill fails to add anything new and lacks ambition. The Law Society of Scotland described the duty placed on ministers as a diluted version of existing obligations. It was also noted that the bill only requires ministers to consider the UNCRC, but not to act or explain those considerations. If this bill is to avoid becoming, as Liam MacArthur described it, a missed opportunity, I would urge members to support my amendments this afternoon, which would add a requirement on ministers to demonstrate how they have responded to general comments or recommendations made directly to the UK by the UN Committee on the Rights of the Child. This would bring the reporting duty more in line with the children's scheme included in the Rights of Children and Young People's measure in Wales, where a duty of due regard exists. This has widely been welcomed by those working with and for children in Wales. It is important that we have proper scrutiny of ministers' actions if we are to ensure that this bill is having the kind of impact we all want it to. With regard to the Amendment 116 in the name of Jean Urquhart, there has been a great deal of discussion and debate during the bill's passage through Parliament about the extent to which the UNCRC should be incorporated into law. This amendment would allow us to continue that discussion. It places on ministers a duty to establish a group to consider the merits of incorporating the UNCRC into law and report back. Any decision on the extent to which incorporation is appropriate will of course be a decision for Parliament and informed by the best available evidence. Finally, Presiding Officer, I am also supportive of the amendments in the name of Liam MacArthur and Alison Johnson. I would particularly bring members' attention to the importance of ensuring that the views of children likely to be affected by decisions are sought and that children's rights impact assessments are carried out on every relevant bill. I have spoken on a number of times in this chamber about the importance of listening to children and young people rather than just talking at them. and I am slightly disappointed that the Minister's amendment here does not go as far as Liam MacArthur's does. Presiding Officer, Amendments 116 to 126 and 93 would significantly strengthen what is widely regarded as a weak section of the bill, and I would urge members across the chamber to support these amendments if this bill is to match our ambition.
Many thanks. Now call on Liz Smith.
Thank you, Deputy Presiding Officer. I've listened very carefully over a lengthy period to what has been, I think, the most challenging, but nonetheless one of the most interesting aspects of the debate on the bill. As I mentioned on the very first day of Stage 1 evidence-taking, the main difficulty of Part 1 of the bill has all along been the need to assimilate very different legal perspectives on the bill, and most especially the need to come to a rational judgment about whether there was a need to incorporate UNCRC into Scots law. In turn, that meant examining whether there are sufficiently strong reasons in terms of Scottish ministers in the current situation in terms of protecting children, and whether in some cases we have not done enough to enhance the rights of children. In particular, there was a need to ensure that there was a very clear understanding on the duties of ministers and those which fall on local authorities and other bodies. At the end of this process, the Scottish Conservatives do not believe that there is a sufficiently strong case for full incorporation of UNCRC into Scots law, on account of the fact that some aspects of UNCRC are not fully compatible with our legal traditions. But we do believe that there has to be much more clarity over the rights of ministers, of children and their families, and just as importantly of local authorities and other professional bodies. So following these criteria, we will support Amendments 117, 118, 93, 121, 123 and 124, but not the other amendments in this group.
Many thanks. Now call on Joan McAlpine.
Thank you very much, Presiding Officer. I, like Liz Smith, listened to the evidence around this section of the bill as part of the Education Committee, and like the rest of the Education Committee, came to the conclusions that there was little evidence about how full incorporation of UNCRC would improve outcomes for children in Scotland. Paragraph 38 of the report's conclusions notes that UNCRC is implemented in Scotland in a number of ways already, and in fact Article 42 is incorporated into the bill itself, and it promotes it obliges ministers to promote public awareness of children's rights amongst children as well as parents, and that particular aspect of the bill has been welcomed by the Information Commissioner. The committee conclusion states that we are not persuaded of the case for full incorporation of UNCRC into Scots law. We agree that the benefits arising from incorporation of UNCRC could be realised from the improvement in policy and practice in implementing GIRFEG. And Liam MacArthur mentioned that Neil Bibby had taken up the cudgels at Stage 3. I find it quite strange that it's taken such a long time for him to reach this position, given that he was one of the members of the committee who signed up to these conclusions, which are fairly fulsome at the time. Thanks very much.
Thank you very much. Minister, would you like to respond to any of the points made in the debate since you spoke, or not? You don't have to by any measure.
Well, I can suggest that I think the points in which Joan McAlpine raised around the fact is that the committee didn't support fully the incorporation, and reflect again on Professor Ken Norrie's comments that he made in the bill, and also just about the technical difficulties to accept Alison Johnson's amendments as well. But a firm commitment there to ensure that we can work with everyone who's interested about making sure that we make rights real across Scotland, because this is about making sure that we do put Scotland on the best path towards becoming the best place to grow up, and making rights real is a key part of that. So I will make sure that we do work with others across the chamber to allow us to have that proper scrutiny, which I've set out in my opening speech is already there through the Parliament, the Education Committees and the Children's Commissioner. And by working together, I think we can make sure that we have a bill at the end of it that we're proud of as regards to UNCRC provision.
Many thanks. I now call on Jean Urquhart to wind up and press to withdraw her amendment.
Sorry, Presiding Officer. I suppose I want to return to the wording of this amendment and to reiterate what it would do and what it will not. It will require Scottish ministers to set up a body to consider whether the UNCRC should be given legislative effect. It doesn't state what sort of body, nor does it insist that UNCRC should be given legislative effect. It allows ministers and indeed MSPs to charge that body with exploring all the issues relating to this matter. The body will have to lay its report before Parliament and Scottish ministers will be expected to respond. At no point in this process is there a burden or responsibility or even an expectation on Scottish ministers and members of the Scottish Parliament to commit to giving legislative effect to the UNCRC. Clearly, I hope as someone who believes passionately in creating a rights-based society for all, that whether to do so is explored fully and that the conclusion is reached that this would be the appropriate thing to do. I hope too that the body provides advice on how and when to do so, but by committing ourselves to establishing the body today does not commit future governments nor parliaments to its recommendations. We will still be able to make that democratic decision as it should be. But I have made my views clear on why I think it's important for Scotland to incorporate the UNCRC into our legislative framework. But there are far greater politicians than me who called upon us all to do more for children. Our children are our greatest treasure and they are our future, and history will judge us by the difference we make in the everyday lives of children. And there are many reasons to follow the teachings and words of the late, great Nelson Mandela. Throughout his presidency and indeed his retirement, Mandela championed the cause of children, his love for and appreciation of children, their needs, rights and interests, and of society's duty and responsibility to protect and nurture them by being child-centred and furthering their rights. Provide us with more and indeed compelling reasons. I uphold my amendment.
I'm afraid I didn't hear what you said. Are you pressing or withdrawing your amendment?
No, I'm upholding my amendment. I'm pressing for my amendment.
You're pressing it, right. So the question is then that Amendment 116 be agreed to. Are we all agreed? No. We are not. There will therefore be a division shortly because there's a 5-minute gap now. Suspension, that's the word I was looking for. Thank you. We will now proceed with the division on Amendment 116. This is a 30-second division. Members should cast their votes now. The result of the vote on Amendment number 116 in the name of Jean Urquhart is yes 36, no 84. There were no abstentions. The amendment is therefore not agreed. I now call Amendment 117 in the name of Liam MacArthur, already debated with Amendment 116. Mr MacArthur, to move or not move? Moved. Thank you. So the question is that Amendment 117 be agreed to. Are we all agreed? We are not. There will therefore now be a 30-second division. Please press your buttons now. The result of the vote on amendment number 117 in the name of Liam MacArthur is yes 55, no 65. There were no abstentions and the amendment is therefore not agreed. I now call Amendment 118 in the name of Liam MacArthur, already debated with Amendment 116. Mr MacArthur, to move or not move? Moved. Thank you. There will therefore be a division. Please cast your vote.
Question.
Oh, I beg your pardon. The question is that Amendment 118 be agreed to. Are we all agreed? No. There will therefore be a division. Please cast your votes now. The result of the vote on amendment number 118 in the name of Liam MacArthur is yes 56, no 65. There were no abstentions and the amendment is therefore not agreed. We now move to Group 2, duties in relation to Article 7 of UN Convention on the Rights of Persons with Disabilities. I call Amendment 92 in the name of Siobhan McMahon, groups Amendment 94 to 100. Siobhan McMahon to move Amendment 92 and speak to all amendments in the group, please.
Thank you. As I said at stage 2 of the debate, the reason we require the addition of the United Nations Convention on the Rights of Persons with Disabilities is to give an additional assurance that disabled children's views are embedded in the bill and given due regard and consideration on all aspects of policy development. I understand that the Government are satisfied that the UNCRC requirements are sufficient to provide this, and at stage 2 the Minister stated that the rights set out under the UNCRC apply equally to all children, including disabled children. If this was indeed the case, I do not believe that the UN would have set out an additional assurance themselves with UNCRPD. More emphasis should be placed on ensuring that Children and Young People Bill makes adequate provision for the rights of disabled children to be realised. Embedding it into primary legislation would build a strong foundation for public authorities around Scotland to adjust their practice and procedures to reflect the national intention to uphold disabled children's rights. I also understand that the Scottish Government do not wish to highlight specific groups of children and are seeking to promote the notion of universality. However, given that the bill specifically mentions looked after children, I would argue that the precedent has already been set and it would be remiss of this bill not to mention disabled children in the way I propose. the Minister will be aware that my proposed amendments are supported by Alliance, Enable Scotland and Children First. Notwithstanding that there is a problem with the financial memorandum and that we on these benches have concerns over the financial support available for this bill, I urge the Ministers to support Amendment 92 and all other amendments in this group, and I move Amendment 92.
Thank you very much. Colin Liz Smith.
Thank you, Deputy Presiding Officer. As I mentioned at stage 2, I got a very great deal of sympathy for the intent behind these amendments, and I think Siobhan McMahon, by bringing them to stage 2, has allowed us to undertake further detailed and very important scrutiny of the rights issue. And I'm also grateful to the Health and Social Care Alliance Scotland for their very helpful briefing. Having sought other legal advice on the issue and revisited the lengthy and fairly complex debates that we had at the time of the ASL legislation, we remain nervous about identifying one specific group of young people with special needs without addressing the concerns of others. We will therefore not be supporting the amendments in this group, but we would like the Minister to provide further reassurance beyond that she gave at stage 2, that the rights of disabled children will not in any way be undermined or diluted when it comes to providing them with the appropriate levels of support.
Many thanks. Minister.
Thank you. Amendments 92, 94, 95, 96, 97, 98, 99 and 100 seek to place requirements on Scottish ministers and public bodies to take steps with the aim of furthering the rights set out under Article 7 of the United Nations Convention on the Rights of Persons with Disabilities. The proposals mirror a series of amendments lodged already by Siobhan McMahon at stage 2 of the bill process, and as at stage 2 I am happy to welcome the sentiment behind the amendments, and would also like to take this opportunity again to thank Siobhan McMahon for bringing this matter to the attention of the Chamber today. The rights set out under the UNCRC apply to all children, including disabled children. And regarding Siobhan's particular point, the UNCRC specifically recognises the importance of ensuring that disabled children are supported to access the same opportunities as their peers. Article 7 of the UNCRPD restates those very important principles. We are strong advocates of the UNCRPD, but it is important to remember that Part 1 of the bill seeks to promote a universal approach to protecting and promoting the rights of all children. It is an express recognition of our responsibilities to each and every one of our children, irrespective of their backgrounds or needs. So to begin to recognise some groups of children and not others would begin to dilute that notion of universality, and again echoing the points that Liz Smith as well had made in her remarks. But let me do state categorically, and I hope gives comfort to Siobhan and to Liz Smith, that we are not, even though we are not making explicit reference to disabled children, that does not in any way detract from the commitment we are making to them. And we will continue to work with all the groups that Siobhan McMahon mentioned, who are supportive of the intention behind these amendments. So while I am supportive of the intention, we can't support them, but we will continue to work with the groups who have been helpful in terms of drafting these amendments to ensure that we do get things right for children with disabilities.
Many thanks. And I call on Siobhan McMahon to wind up and press or withdraw her amendment.
Thank you. I appreciate the comments made by Liz Smith and the Minister, and I understand the concerns that Liz Smith has. We spoke a few minutes ago about those concerns and at stage 2 as well, so I do appreciate where you're coming from. However, I would suggest that given the third sector organisations who wish for this to happen, and the key principle of universality, as the Minister keeps going on about, is to make sure that everyone has the same rights and access to everything and education, and therefore when a disabled child has additional barriers to them, we should make provision for those needs, and that is the reason for those amendments, and therefore I move those amendments.
Many thanks. And so the question is that Amendment 92 be agreed to. Are we all agreed? We are not. There will therefore be a 1-minute division. Please vote now. Result of the vote on amendment number 92 in the name of Siobhan McMahon is yes 42, no 78. There are no abstentions and the amendment is therefore not agreed. I now call amendment 93 in the name of the Minister, already debated with amendment 116. Minister to move. Thank you. And so the question is that amendment 93 be agreed to. Are we all agreed? We are. I now call amendment 119 in the name of Alison Johnston, already debated with amendment 116. Alison Johnston to move.
Not move.
Not moved. Thank you. Does anyone... So I now call amendment 94 in the name of Siobhan McMahon, already debated with amendment 92. Siobhan McMahon to move or not move?
Not moved.
Not moved. Thank you. I now call amendment 120 in the name of Alison Johnston, already debated with amendment 116. Alison Johnston to move or not?
Not moved.
Thank you. So I now call amendment 121 in the name of Neil Bibby, already debated with amendment 116. Mr Bibby to move or not?
Moved.
Thank you. So the question is that amendment 121 be agreed to. Are we all agreed? No. We are not. There will therefore be a 30-second division. Please vote now. The result of the vote on amendment number 121 in the name of Neil Bibby is yes 55, no 65. There were no abstentions and the amendment is therefore not agreed. I now call amendment 95 in the name of Siobhan McMahon. Siobhan McMahon to move or not move?
Not moved.
Thank you. I now call amendment 122 in the name of Alison Johnston. Alison Johnston to move or not move?
Not move.
Thank you. I call amendment 123 in the name of Neil Bibby. Mr Bibby to move or not?
Move.
Thank you. The question is that amendment 123 be agreed to. Are we all agreed? We are not. There will therefore be a 30-second division. Please vote now. The result of the vote on amendment number 123 in the name of Neil Bibby is yes 55, no 65. There were no abstentions and the amendment is therefore not agreed. Now call amendment 124 in the name of Neil Bibby. Mr Bibby to move or not?
Move.
Thank you. The question is that amendment 124 be agreed to. Are we all agreed? We are not. There will therefore be a 30-second division. Please vote now. The result of the vote on amendment number 124 in the name of Neil Bibby is yes 55, no 65. There were no abstentions and the amendment is therefore not agreed. I now call amendment 125 in the name of Liam MacArthur. Mr MacArthur to move or not? Move. Thank you. So the question is that amendment 125 be agreed to. Are we all agreed? No. We are not. There will therefore be a division. Please cast your votes now. Result of the vote on amendment number 125 in the name of Liam MacArthur is yes 42, no 79. There were no abstentions and the amendment is therefore not agreed. Now call amendment 126 in the name of Liam MacArthur, already debated with amendment 116. Mr MacArthur, to move or not?
Moved.
Thank you. So the question is that amendment 126 be agreed to. Are we all agreed?
No.
We are not. There will therefore be a division. Please vote now. The result of the vote on amendment number 126 in the name of Liam MacArthur is yes 42, no 79. There were no abstentions and the amendment is therefore not agreed. Amendment 96. Siobhan McMahon, to move or not? Not moved. Thank you. Amendment 97 in the name of Siobhan McMahon? Not moved. Thank you. Amendment 98.
Moved.
Moved?
Yes.
Thank you. So the question is that Amendment 98 be agreed to. Are we all agreed? We are not. There will therefore be a division. Please cast your votes now. Result of the vote on amendment number 98 in the name of Siobhan McMahon is yes 42, no 79. There were no abstentions. The amendment is therefore not agreed. Call amendment 99. Siobhan McMahon, to move or not?
Not moved.
Thank you. Call amendment 100 and Siobhan McMahon, to move or not?
Not moved.
Thank you. And that which takes us to Group 3, on the meaning of children's service, inclusion of families of children with needs of a particular type. Call amendment 127 in the name of Siobhan McMahon, in a group on its own. Siobhan McMahon, to move to and speak to amendment 127, please.
Thank you. The aim of Amendment 127 is to ensure that family support services are reflected in children's services planning to inform local commissioning strategies. The amendment relates specifically to ensure that the policy aim of the bill translates into effective services which meets the needs of disabled children and young people and their families. This amendment has been brought forward by For Scotland's Disabled Children, a banner organisation for several charities and organisations working for and with disabled children and their families. They and I believe that without a clear duty within this bill, which ensures the specific need of this vulnerable group of children and their families are reflected in joint local planning and local commissioning processes, there is a real danger that opportunities to deliver innovative support for this group will be missed. I urge the Chamber to support this amendment and I move Amendment 127.
Thank you very much. Minister.
127 by Siobhan McMahon was raised at stage 2 and it has an absolutely good policy intention to ensure children's services planning covers support for the families of children with particular needs. And as I said at stage 2, we share the belief that children's services planning should include support for families in their caring roles for children with particular needs. This kind of support is already covered by the bill as currently drafted, and we will ensure that guidance makes this more explicit and work with others with an interest to develop this very important guidance. Nevertheless, as drafted, this amendment does not make clear what services for these families would be covered, and that could undermine the focus of this planning on children's services. So consequently, don't support Amendment 127. I understand the intention behind it and will continue to work with groups to ensure that the guidance makes provision much more explicit. Thank you.
Thank you very much. Siobhan McMahon, to wind up and press withdraw your amendment.
Okay. I welcome the Minister's comments and I appreciate that she will make it explicit in the guidance. However, I will be moving my amendment.
And so the question is that Amendment 127 be agreed to. Are we all agreed this will be a 1-minute division? Result of the vote on amendment number 127, the name of Siobhan McMahon, is yes 37, no 84. There were no abstentions, and the amendment is therefore not agreed. So that now takes us to Group 4, and I call Amendment 128 in the name of Siobhan McMahon, grouped with other amendments as shown in the groupings. Could you move your amendment and speak to all amendments in the group, please?
Thank you. The amendments in this group have been proposed in order to serve as a clear guide to public authorities that local commissioning strategies must reflect the needs of young people transitioning into adult life, services and support. For disabled young people, there is a further significant pressure point at the transition planning stage, where young people are moving from one set of eligibility criteria under the Additional Support for Learning framework to a completely different framework under social care. Many young people with less complex care needs may no longer qualify for a formal care plan, and so are likely to require access to softer community-based support services which currently may not exist or which are not accessible to disabled young people. It is therefore crucial that this bill place a duty on local authorities to develop and implement children and young people services plans as opposed to children's services plans. This would support the transition process and be of particular benefit to those young disabled people who have less complex support needs and for whom the Adult Social Care Assessment Framework may mean that they fall short of being assessed for a formal care plan as they move into adulthood and independent living. In relation to Amendment 179, this amendment would give Scottish Ministers the power to introduce a national mentoring scheme to support children and young people with a disability during the key transition from childhood to adulthood. As we know, children and young people with a disability often face significant barriers in accessing life chances, including employment and leisure opportunities and developing social contacts. This amendment would seek to address this and could significantly improve outcomes in these key areas for children and young people with a disability across Scotland. I urge the Minister and the Chamber to support the amendments in this group, and I move Amendment 128.
Many thanks. Liam MacArthur.
Thank you, Deputy Presiding Officer. Can I start by paying tribute to Siobhan McMahon, not just for moving these amendments, but those in the earlier groupings and the work she did through stage 2 and bringing those to the attention of the committee. I think, like Siobhan McMahon, I too have been concerned about some of the problems that can arise around the transition from a young person reaching the age of 18, moving to adulthood, and suddenly all the support around that young person disappears or starts to fragment. And I think while I'm conscious of the need to protect the rights of adults and adults with particular needs, I think the issues that she raises through these amendments are very pertinent indeed. In addition, I think the amendments 179 and 196, I think, that seek to provide a right to mentoring support for children and young people with a disability are well made, and I'm certainly happy to lend my support to those amendments too.
Many thanks. Minister.
Thank you. In relation to Amendments 128, 139 and 142 to 161, I said in response to the similar amendments that Siobhan McMahon raised at stage 2 that we believe widening the planning of services around children by including the needs of young people up to the age of 25 risks making such planning less meaningful. The services children need are not necessarily the same as those that young adults require. Conflating both within the same set of plans overcomplicates planning and doesn't necessarily serve both children, either children or young people. On Amendment 141, we recognise the difficulties associated with the transition from children's services to adult services, and that good transition planning is essential for those children whose needs require continuing support into adulthood. Planning for this absolutely should be covered by children's services plans, which is why the existing provisions of the bill already allow for this. And we will work with relevant stakeholders to ensure that transition planning in the guidance is there to support this part of the bill. With respect to Amendments 179 and 196, we can absolutely see the merit in a scheme providing mentors to disabled children to help ease their transition into adulthood and promote their well-being. Indeed, there is strong evidence that goal-oriented mentoring can help young people to achieve and help them become more confident in expressing their views. So to that end, I announced in December my intention to establish a national mentoring scheme initially focused on the children who would benefit most from such help, especially children looked after at home who are aged 8 to 14, before expanding to other groups of young people. And this scheme is non-statutory in nature and allows us to test how to apply it to improve outcomes. And while the scheme we are taking forward is not aimed directly at children with disability, it will still benefit a significant number of disabled children. So as the scheme develops, I'm open to discussing with Siobhan McMahon and others how we can target it further to help those most in need. So consequently, we don't believe that this amendment is necessary. And it's important to remember that not every child with a disability will need or indeed want a mentoring service. However, through the mentoring scheme, we can actively explore means by which they can be made more widely available to those children who will benefit. So it's for those reasons, and to reiterate, we don't support the amendments in this group, but happy to continue the dialogue around some of the intention behind it.
Many thanks. Siobhan McMahon to wind up and press to withdraw your amendment.
Thank you. Can I thank Liam MacArthur for his kind comments? I feel as if I am an honorary member of the Education Committee now, so thanks for welcoming me on that for the days that I've been there for the amendments, and for your support for the amendments, because I think genuinely it was I was trying my best to get a better bill. I think the Minister has recognised that in the transition service. However, I disagree with her. Of course, not all disabled children and young people are the same, but at the minute, young adults are getting lost in the system because there isn't a care plan for them, and these amendments seek to address that. So I will be pressing those amendments. On the mentoring scheme, absolutely believe the intention behind the scheme announced by the Minister in December is the right thing. Of course, I'll continue the dialogue with her to expand that, but I don't think that that prohibits us from voting for these amendments today, and therefore I'll press those as well. Thank you.
Many thanks. So the question is that Amendment 128 be agreed to. Are we all agreed? No. We are not. There will therefore be a 1-minute division. Please cast your votes now. The result of the vote on amendment number 128 in the name of Siobhan McMahon is yes 56, no 65. The amendment is therefore not agreed. Call amendment 129, Siobhan McMahon, to move or not move?
Not moved.
Thank you. So we now move to Group 5, and I call amendment 55 in the name of the Minister, grouped with amendments 56 to 68, 70 and 72 to 74. Minister, to move Amendment 55 and speak to all amendments in the group, please.
Thank you. I move Amendment 55 in my name. The amendments in this group are technical amendments to take into account the effect of recent legislative changes to the administrative boundaries of health board areas and ensure that the definition of relevant health board in Section 7.1 and associated references throughout Part 3 are consistent with that legislation. The text in Part 3 of the bill on introduction was drafted on the basis that local authority and health board boundaries are currently not aligned. As a result, to ensure the joint planning duties would cover each local authority area, the original provisions required local authorities to jointly plan with each health board that operated within local authority areas. However, in light of the recent decision to bring forward secondary legislation to adjust the boundaries of health board areas to ensure that they are aligned with those of local authority areas, amendments are now required to Part 3 of the bill. The National Health Service Variation of Areas of Health Boards, Scotland Order 2013, will make the changes to health board areas with effect from the 1st of April. Amendment 55 amends the definition of relevant health board in Section 7.1 to reflect those changes. Consequently, associated references in Part 3 of the bill should be amended from each or any relevant health board to the relevant health board or the health board. That is the effect of Amendments 56 to 68, 70 and 72 to 74. So I ask that the Chamber support the amendments in my name.
Many thanks. So the question is that Amendment 55 be agreed to. Are we all agreed? Yes. We are. I call Amendment 130 in the name of Siobhan McMahon. Siobhan McMahon, to move or not move?
Move.
Thank you. So the question is that Amendment 130 be agreed to. Are we all agreed? We are not. There will therefore be a division, a 1-minute division. Please cast your votes now. Thank you. The result of the vote on amendment number 130 in the name of Siobhan McMahon is yes 46, no 73. There were no abstentions and the amendment is therefore not agreed. I now call amendment 131 in the name of Siobhan McMahon to move or not move.
Not move.
Thank you. Call amendment 56 in the name of the Minister. Minister to move. Moved. Thank you. The question is that Amendment 56 be agreed to. Are we all agreed? Yes. Thank you. We are. Call Amendment 132 in the name of Siobhan McMahon. Move or not move?
Not move.
Thank you. Call Amendment 133. Siobhan McMahon to move or not?
Not move.
Thank you. Amendment 57 in the name of the Minister. Minister? Moved. Thank you. The question is that Amendment 57 be agreed to. Are we all agreed? Yes. Thank you. Call Amendment 58 in the name of the Minister. Minister to move. Moved. The question is that Amendment 58 be agreed to. Are we all agreed? Yes. Thank you. We are. Call Amendment 134 in the name of Siobhan McMahon to move or not?
Not move.
Thank you. Call Amendment 135 Siobhan McMahon to move or not?
Not move.
Thank you. Amendment 36.
136.
Call. I beg your pardon?
136.
I thought that's what I said. Call Amendment 136. Siobhan McMahon to move or not?
Not move.
Thank you. Amendment 137. Siobhan McMahon to move or not?
Not move.
Thank you. Amendment 138. Siobhan McMahon.
Not move.
Thank you. Amendment 139. Siobhan, move or not?
Not move.
Thank you. Which takes us to the end of Group 5 and the beginning, therefore, of Group 6 and the aim of children's service plans. I call Amendment 140 in the name of John Wilson in a group on its own. Mr Wilson to move and speak to Amendment 140.
Thank you, Presiding Officer. And I would firstly like to thank the Coalition of Care and Support Providers for suggesting this amendment. Section 9 of the bill sets out the aims of the Children's Services Plan, of which there are 4. The fourth one, subsection 923, says that children's services should be provided in the way that constitute the most efficient use of available resources. The amendment, if supported today, would now read, constitutes the best use of available resources. The reason for the amendment is that the present wording of the subsection is inconsistent with the statutory duty of best value, which all local authorities must have regard to when planning and delivering services under Section 1 of Local Government Act 2003. Maintaining a balance between the two principles of efficiency and effectiveness is central to the idea of best value. It is believed that by including only one of those two fundamental principles in the Children's Services section of this bill is inconsistent with this government policy and related legislation. It also sends a message to local authorities which may encourage emphasis on cost to the detriment of quality and effectiveness in children's services provisions. Indeed, Audit Scotland has repeatedly highlighted the importance of best value as the key to success for local authorities. Local authorities that place best value at the centre of all they do are well placed to deal with the challenges in 2012 and beyond. That was Audit Scotland in 2012. Audit Scotland has also raised concerns about the possibility of local authorities taking an overzealous approach to cost-cutting at the expense of service quality and provision. Therefore, I believe this amendment, while appearing to be a small issue in the context of the many significant issues that this bill deals with, is no less important because of the potential positive impact of good quality, effective children's services. And I think this is an opportunity to improve the drafting of this bill as it stands. Thank you.
Thank you. Minister.
I don't believe that the amendment is likely to make a significant difference to the way that the children's services plans are prepared. Local authorities remain bound by Section 1 of the Local Government in Scotland Act 2003, which set out the basic principles of best value. Local authorities could not develop children's services plans without taking account of best value, and we would ensure that this principle is clearly set out in the national guidance on how to prepare children's services plans. Nevertheless, we can see the attraction of providing greater consistency in the language of best value between different pieces of legislation. Best value remains a key principle at the heart of our children's services, and we support an amendment that further highlights the importance of that principle. Therefore, we do support John Wilson's amendment.
Thank you. Mr Wilson, to wind up and press withdraw your amendment.
Presiding Officer, I think the Minister has quite clearly stated they've accepted this amendment, and I will press the amendment.
So the question is that Amendment 140 be agreed to. Are we all agreed? Yes. We are not agreed. There will therefore be a division, and this will be a 1-minute division. Please cast your votes now. The result of the vote on amendment number 140 in the name of John Wilson is yes 101, no 19. There were no abstentions, and the amendment is therefore agreed. I call amendment 141 in the name of Siobhan McMahon, already debated with amendment 128. Siobhan McMahon, to move or not?
Move.
Thank you. So the question is that amendment 141 be agreed to. Are we all agreed? No. We are not. There will therefore be a division. Please cast your votes now. The result of the vote on amendment number 141 in the name of Siobhan McMahon is yes 44, no 74, with no abstentions, and the amendment is therefore not agreed. Now call amendment 142 in the name of Siobhan McMahon. Siobhan McMahon, to move or not?
Not move.
Not moved. Thank you. Call amendment 143 in the name of Siobhan McMahon. To move or not?
Not move.
Thank you. Amendment 59. Move or not? Oh, I beg your pardon. Minister, to move?
Moved.
Thank you so much. The question is that Amendment 59 be agreed to. Are we all agreed? Thank you. We are agreed. I now call Amendment 144, in the name of Siobhan McMahon, to move or not.
Not move.
Thank you. I now call Amendment 145, Siobhan, to move.
Not move.
Thank you. Amendment 60, in the name of the Minister, to move. Thank you. Question is that Amendment 60 be agreed to. Are we all agreed? We are. I now Amendment 146, Siobhan.
Not move.
Thank you. Not moved. Amendment 147.
Move.
Not moved. Thank you. Amendment 61, in the name of the Minister. Minister, to move.
Moved.
Thank you. Question is Amendment 61 be agreed to. Are we all agreed? We are. Thank you. Amendment 148, moved.
Not move.
Not moved. Thank you. Amendment 149, moved or not?
Not move.
Thank you. And call Amendments 62, 63 and 64, all in the name of the Minister and previously debated. And invite Minister to move the amendments 62 to 64 on block, please.
Moved on block.
Does any member object to these, a single question being put on Amendments 62 to 64? As no one does, the question is that Amendments 62 to 64 are agreed to. Are we all agreed? Yes. Thank you. Call Amendment 150, name Siobhan McMahon. Siobhan McMahon, move or not?
Not move.
Thank you. Amendment 151, name Siobhan McMahon, move or not?
Not move.
Thank you. Amendment 152, moved or not?
Not move.
Thank you. Amendment 153.
Not move.
Thank you. Amendment 154.
Not move.
Thank you. Amendment 155.
Not moved.
Thank you. Amendment 65 in the name of the Minister. Minister, to move on.
Moved.
Thank you. Question is that Amendment 65 be agreed to. Are we all agreed? Yes. We are. Amendment 156, Siobhan McMahon, to move or not?
Not move.
Thank you. Amendment 66, Minister, move or not?
Moved.
Thank you. Question is that Amendment 66 be agreed to. Are we all agreed? Yes. Could you just tell me again, are we agreed or not? Yes. We are. Thank you. Now call Amendment 157, Siobhan McMahon, to move or not?
Not move.
Thank you. Amendment 158, Siobhan McMahon.
Not move.
Thank you. Amendment 159, Siobhan McMahon.
Not moved.
Thank you. Amendment 67, Minister, move.
Moved.
Thank you. Question is that Amendment 67 be agreed to. Are we all agreed? Yes. We are. Thank you. Call Amendment 160, Siobhan McMahon, move or not?
Not move.
Thank you. Call Amendment 68, in the name of the Minister. Minister, to move, please. Thank you. Question is that Amendment 68 be agreed to. Are we all agreed? Yes. We are. Thank you. Which now takes us to Group 7. And I call Amendment 69 in the name of the Minister. Group Amendments 71, 75, 76, 83, 85 and 88. Minister, to move Amendment 69 and speak to all amendments in the group, please.
Thank you. I move Amendment 69 in my names. Amendments 69, 71, 75, 76, 83 and 85 amend the sections on guidance and directions in Parts 3, 4 and 5 of the Bill. These parts cover children's services planning, named person and the child's plan, respectively. The amendments make it clear that before issuing, revising or revoking guidance or directions under these parts, Scottish ministers, in addition to consulting any person to which the guidance or direction relates, must consult such other persons as they consider appropriate. It has always been the Scottish Government's intention to consult as widely as is required in respect of guidance and directions issued under these parts of the Bill, including with children, parents and the third sector organisations where that is appropriate. However, we consider that it is helpful to make it clear on the face of the Bill that consideration should be given as to who will be affected by the issue, revision or revocation of any set of guidance or any direction, which will then ensure that the necessary consultation is undertaken. The amendments also achieve drafting consistency across Parts 3 to 5 of the Bill in respect of the provisions about guidance and directions. Amendment 88 makes a minor drafting adjustment to Section 57 of the Bill so as to achieve drafting consistency between this section, which concerns guidance issues in respect of the corporate parenting duties in Part 7 and the sections on guidance in Parts 3 to 5.
Thank you. Jim Hume. Right. Minister, you won't be wishing to wind up, and in that case, the question is that Amendment 69 be agreed to. Are we all agreed? Yes. Thank you very much. I now call Amendments 70 to 74, all in the name of the Minister and previously debated Minister, to move Amendments 70 to 74 en bloc.
Moved en bloc.
And does any member object to a single question being put in Amendments 70 to 74? As it appears that no member does, the question is that Amendments 70 to 74 are agreed to. Are we all agreed? Yes. Thank you very much. I now call Amendment 161 in the name of Siobhan McMahon. Siobhan McMahon, to move or not?
Not move.
Thank you. And that now takes us to Group 8. And I call Amendment 1 in the name of Liz Smith, grouped with other amendments as shown in the groupings. Liz Smith, to move Amendment 1 and speak to all amendments in the group, please.
Thank you, Deputy Presiding Officer. From the very outset, the Conservatives have argued very strongly against the introduction of a named person for all 0 to 18-year-olds, and we will now do so again. We believe the policy is wrong in principle, that it does not have conclusive supporting evidence, and that it has not been properly costed, something which was unanimously agreed by the Finance Committee, whose convener Kenny Gibson said when addressing the Bill team that the savings that you are talking about over a short period are not realistic, and that would lead 2 or 3 years after the bill has been passed to significant funding shortfalls. And again this afternoon, we've seen concerns raised about the revised financial memorandum. Amendments 1 to 50 and then 162 to 164 seek to address 2 of the most fundamental flaws. Firstly, Amendments 1 to 50 would remove those aged 16 and above from the named person plans, something I know which has the unqualified support of both Labour and the Liberals, and I suspect some SNP members too. This is because even the most ardent supporters of the policy do not believe that it is workable beyond 16, because it is not compatible with many other aspects of Scots law which define an adult at age 16, and because many practitioners believe that there would be an additional confusion over the lines of accountability. Bill Alexander of Highland Council, one of the most ardent supporters, said, "I do not understand how my daughter, who is 17 and doing performing arts in Manchester, could have a named person. She will not need or want one." Professor Norrie said, "I would have been much more comfortable if the limit of the childhood was set at 16. The Scottish Government's response to these points at Stage 2 was, in my view, exceedingly weak. So I hope in the intervening time that they may have had a change of heart. We are talking here, Deputy Presiding Officer, about young adults, 16 and 17-year-olds, who are allowed to marry, they are free to leave school and able to enlist, and who are being told by this government that they are old enough to vote in the upcoming referendum, but seemingly not old enough to go about their business without being assigned a named person. That inherent contradiction speaks for itself. The second set of amendments, Amendments 162 to 164, seek to limit the function of the named person and create a route for parents to contest any decision that a named person is necessary. The reasoning behind this combines the very substantial concerns that have been raised by several groups and Aidan O'Neill QC that there will be scope for a legal challenge against the Scottish Government's proposals, particularly in terms of Article 8 of the European Convention on Human Rights, which safeguards the right to a private family life. Since Stage 2, we have listened very carefully to the concerns that a general opt-out could perhaps undermine the efforts to safeguard the welfare of our most vulnerable children. So consequently, Amendment 162 proposes to limit the functions of the named person policy to instances where there is a safety, legal, well-being or rights concern. Similarly, Amendments 163 and 164 place a duty on the service provider to inform parents, children and young people of a decision to appoint a named person and creates a provision for that judgment to be subject to appeal. Taken together, these amendments will ensure that the policy is based on need rather than imposed across the board. This point has been raised by a number of organisations, including several churches and parents' groups, many of whom have written to MSPs in the last few weeks to ask them to reconsider. Time after time, they are pointing out that the named person policy fails the criteria of what makes a good law, that it tips the balance away from parental and family responsibilities towards the state, that it is not properly costed, and that it will be open to legal challenge. For all these reasons, and for the sake of common sense, I ask the Chamber to support the amendments in my name, and I move Amendment 1.
Thank you very much. I have a number of members who wish to contribute to this group, so if they could be as brief as possible. I call Fiona MacLeod to be followed by Neil Bibby.
Officer, difficult to be brief on this, to be honest, given the amount of misinformation that's been going about over the named person. Perhaps first I should say that I'm speaking here because I used to be the chair of a Children's Panel Advisory Committee, and I used to be many years ago a researcher for the RSS PCC. So what is so important about the named person provision is that we're trying to provide a universal safety net for all young people in Scotland. And the point about universal access to this safety net is that it should always be proactive in supporting young people and not reactive when things have got bad in their lives. And the amount of misinformation we've had, I think, has been quite appalling. And Liz Smith referred to the emails we've had. I have to say, some of the emails I've received have bordered on the offensive, talking about state surveillance, 1930s Nazi Germany and Big Brother. And, I have to wonder about, is there an orchestration behind some of these emails? So, for me, given my background in child protection, it is most important that this is a universal service for all young people in Scotland. Those of us that are parents, most of us will bring up our children well, but we never know, never and can never foretell when we as parents and our children may suffer through bereavement, family breakup, illness, etc., when we will need instant access to a named person who knows our child, knows them well, and can provide that access to all the relevant services at the time and at a time of need. So, as with our Children's Hearing Service, as with GIRFEC, I believe that Scotland, with the named person, is actually looking at groundbreaking legislation here and groundbreaking work in child protection, and I would urge every member to support this.
Thank you. I now call Neil Bibby to be followed by Gill Patterson.
This is undoubtedly the most controversial part of the bill, and one that has to be properly debated and discussed, as we have done at some length on the Labour benches. There are, of course, strong feelings about this. There are some that believe this measure is absolutely necessary to identifying and protecting vulnerable children, and there are those who believe that this is not required and potentially could interfere in family life. As I have said before, in principle, I have no objection to putting a named person provision in the bill. But equally, like everyone, I would hope, I do not believe it is the state's role or job to bring up all children. I would welcome reassurances from the Minister to the concerns raised by parents over recent weeks. Like many colleagues, I want to see the best possible protection and support system for our children. However, critically, there are two key tests for the named person provision. The system has to work in practice, and this system needs to be properly resourced. And I believe the Minister and the Government have completely failed to address these two key concerns. Labour can't support all of the amendments in this group, but we will be fully supporting Liz Smith's amendments on reducing the age limit for children to have a named person from 18 to 16, as we did at stage 2. As Liz Smith said earlier, when Bill Alexander, the Director of Health and Social Care at Highland Council, gave evidence to the committee, I was extremely concerned when he questioned why a named person would be needed for most children who have left school. He said, I do not understand how my daughter, who is 17 and doing performing arts in Manchester, could have a named person. She will not need one nor want one. There is no doubt that some young people require additional support after leaving school, but the vast majority of young people will neither need nor want a named person. Members will know that Highland Council was the national pathfinder for implementing GIRFEC. And as a result, Bill Alexander is a highly respected person in this chamber. During the Stage 1 debate, a member said, Bill Alexander knows more about this subject than anybody else, and I have found what he says to be true. That member was the Cabinet Secretary, Mike Russell. Therefore, it is astonishing if the Scottish Government are going to proceed without listening to people such as Bill Alexander and opposition parties when they raise such issues. The second issue I want to raise is the issue of resources. My position is the same as the child protection charity, the NSPCC, who have said we support the intention behind the named person approach, which, if properly resourced, could increase the likelihood of early intervention for children and young people, thus improving their outcomes. The key phrase here is if properly resourced. During the Stage 1 debate, I raised on behalf of the Royal College of Nursing their evidence about the resourcing issues. The RCN said, using the Scottish Government's own estimate of health visiting hours required to deliver the named person role specifically, on top of the rest of the health visiting workload, the RCN estimates it would necessitate around an additional 450 health visitors to be recruited and trained. This was raised at stage 1. The Minister said she was listening, but no action. This was raised at stage 2. The Minister said she was listening, but no action. You have an opportunity to finish it. Okay, on you go.
Minister.
I wonder whether he had a chance to read what Edinburgh City Council said. The Council believes that the cost and any savings for children's rights, GIRFIC, early learning childcare and other proposals are accurately reflected based on our understanding of the requirements of legislation. Does he not agree with Edinburgh City Council, and does he not agree that that is, we've been listening to others to make sure that the estimates in our financial memorandum are absolutely the best that they can be to finance this absolutely thoroughly?
Neil Bevan.
Minister, with respect, you'll listen to whoever you want to listen to. You say you're listening, but you're not hearing the concerns of the RCN. This was raised at stage 1, stage 2. If you are serious about this policy, where are those extra health visitors? This is not to mention the resources required by local authorities and teachers to meet their named person responsibilities and providing training on an ongoing basis, not just a one-off. It's also still not clear how the named person role will be properly resourced and work during 12 weeks of school holidays. No wonder then the Finance Committee in its damning report on this bill said the committee has a number of concerns in relation to some of the costings within this financial memorandum and notes there is a lack of evidence to support the figures provided for some aspects of the bill. We believe the Scottish Government have failed to address the resource issues properly, and this is a policy that will not achieve its intended purpose unless it is. To be blunt, the Minister has said consistently that she has listened, but I don't think she has been hearing. She's not listened to opposition parties, to people like Bill Alexander and organisations such as the RCN. I, like many other members, can support the policy in principle, but I believe the Minister and the Scottish Government have failed the two key tests on addressing the practical and resource issues failed. And by failing those key tests, the Scottish Government risks failing Scotland's children.
Thank you. I call Gil Patterson, to be followed by Liam MacArthur.
Thanks very much, Presiding Officer. Can I restrict my comments to the named person in a school setting? What is proposed is to normalise what will be taking place in any well-run school today. It will give confidence to approach a person a child trusts. That's the head teacher. Not forgetting that the named person can be for the whole school complement, who will be there to listen and to advise. The first port of call, I would assume, would be the family, as it is now. They have no powers in bringing up a child, but in some very serious situations, and I think we know of these, they are graphic, they are worrying, and they are detrimental to children. And some of these incidents happen in the home. Then society doesn't expect us to intervene. They demand that we intervene. There's an expectation of intervention, and it should take place swiftly and by being well connected with the different authorities that are involved. Act swiftly, all in the sake of the child. The evidence and experience from Highlands that no person or family have raised any issues in this regard is there for all to see.
Thank you very much. I call Liam MacArthur, to be followed by Joan McAlpine.
Thank you, Deputy Presiding Officer. As Neil Bibby indicated, Part 4 of this bill, I think, on the named person has attracted the most attention, controversy and opposition since stage 1. After some initial misgivings, I have been persuaded through the process of the benefit that such a named person arrangement can deliver. That said, like a number of witnesses, I was concerned at the practical implications in terms of the way in which resources would be allocated and also the circumstances under which information would be shared, and we'll be coming to that in a later grouping. On the former, I think it's still not clear whether or not the focus on well-being of a child, as opposed to the narrower definition of welfare, will have the effect, in some cases, of seeing resources and attention diverted, with the risk that cases of genuine welfare concern are not picked up or picked up later than otherwise would have been the case. The serious criticisms made of the Bill's financial memorandum by this Parliament's Finance Committee, convened and vice-convened by government backbenchers, did nothing to allay those concerns. I'm also convinced that the task of implementation has not been made any easier by the insistence of the Scottish Government on making the named person provisions apply universally all the way up to the age of 18. At stage 1, we were told that applying the named person provision through the teenage years becomes increasingly problematic, no surprise to any of us who have or have had teenagers ourselves. Even Highland Council, the exemplar in delivery of GIRFIC and a pioneer of the named person approach, appears to have been unable to make this aspect of the named person approach work. And I think Neil Bibby and Liz Smith were quite right to quote Bill Alexander's evidence to us from his own personal experience, and we know the high regard in which Bill Alexander's views are held by the Education Secretary. So I would question whether insisting on a named person up to the age of 18 is either necessary or achievable. That being the case, why risk spending scarce resources trying to do what even the convener of the committee, from his own personal experience, acknowledged would be a formidable challenge? I therefore support the amendments in Liz Smith's name aimed at restricting the universal application of named person to those up to or beyond, limiting the universal application to children and young people up to the age of 16. And finally, I think this is an area crying out for post-legislative scrutiny. While Highland Council's experience has been persuasive, it should be recalled that this was done on a non-statutory basis. How named person operates on a statutory footing remains to be seen, but I think Parliament will want to be reassured that it does remain proportionate, and we may need to return to this in the coming years. Thank you.
Many thanks. I call Joan McAlpine to be followed by Kezia Dugdale.
Thank you, Presiding Officer. Labour's front bench say they support in principle the named person, and then Neil Bibby uses the phrase, "It's not the state's job to bring up children." I think that's not just speaking with forked tongue. It's pandering to the most hysterical misinterpretation of this proposal, and as such is profoundly irresponsible. We know that all the children's charities support the universal principle universally, but so interestingly do parents' charities. In the committee, when my colleague Colin Beattie questioned Claire Simpson of Parenting Across Scotland, he asked her if she agreed with the opponents of named person in that it would usurp the role of the parent. And Claire Simpson said, "I do not feel that's accurate at all. Parents' rights and responsibilities are firmly enshrined in law." And she went on to talk about a Mori poll that her organisation carried out, where they asked parents across Scotland if they knew where to turn when they felt they needed help and support in their parenting. 72% of parents across Scotland didn't know where to turn, and 84% of the parents in deprived areas didn't know where to turn. I think I'll listen to Claire Simpson before I listen to some of the rather hysterical arguments against named person, which is intended to protect the most vulnerable children in our society through applying the universal principle. Thanks very much.
Thank you. I call Kezia Dugdale to be followed by Claire Adamson.
Thank you, Presiding Officer. Honestly, I think Joan McAlpine could pick a fight with the Labour Party in an empty room. I think that's completely ridiculous.
Order, please. Order.
Makes up what we say.
We have two different sets of amendments here from Liz Smith. Those which reduce the maximum age of a named person from 18 to 16, which we can support, and those that seek to diminish the universality of the named person, which we cannot. That said, Presiding Officer, we've come to this conclusion and it's not been easy. We've always said that the principle is sound, but resourcing is an issue. Resourcing concerns are as strong as ever, and they're made by people who support the principle of a named person. The RCN are an example of that, EIS are another. And I would say to Fiona MacLeod, if there's a misconception around what the named person is and does, it's because the front bench of your government have failed to stand up and explain it in a way that is meaningful to parents. So can I ask the Minister again in her closing to very specifically reassure Parliament that no resources will move away from children who are in need to those who do not need support? And secondly, can I ask her, if this is not state interference in family life, and that's a concern parents are raising, and she has to listen to it, we have to give voice to those concerns. It's our duty as parliamentarians to do that. Can she tell us why parents who feel that their child is healthy, happy and succeeding should need a named person? That's a legitimate question from thousands of parents across the country. If she wants their support, she has to answer that simple question. We support what the government are doing, but she needs to do a much better better job of explaining exactly what this means to people right across the country.
Thank you. Claire Adamson.
Thank you, Presiding Officer. Mr Bibby had mentioned the evidence that was given by Bill Alexander at committee, and I do remember that evidence. I remember the discussion we had about it at committee afterwards too. He was talking about a daughter who had left school and gone on to university, and I would challenge anyone in this room to say that a university or a college place is not a supported place to be. People at university have student welfare associations, they have support there, there's pastoral care given to them by the universities. They are in a position of being supported. However, not all young school leavers go on to such an outcome. For some young people at 16 leaving school, they will be denied access to a named person just simply by the fact that they have left earlier. My own son is 16. If he stays on to 6 years, he will be in school until a month before his 18th birthday. And yet a 16-year-old who leaves the school system may go into a difficult working situation, may experience financial problems that they weren't expecting in a different type of lifestyle from what they were expecting on leaving school, and they should not be denied access to a named person because of that. And finally, Presiding Officer, we had a debate in this chamber about child sexual exploitation. It was an excellent debate on the committee report into this very issue. And there was unanimous support from across the chamber that there should be a named person for a young person going through the court process, any victim of child sexual exploitation. But I would suggest that the court process shouldn't be the beginning and the end of that named person support. If a named person was universally available to all young people, anyone who was a victim of child sex exploitation would have a named person to go to at the very beginning of that process. Thank you.
Many thanks. And I now call on Aileen Campbell.
The debate about the named person provisions has attracted a lot of comment, information and, as Fiona MacLeod set out in her remarks, misinformation. And so before I turn to the specifics of Liz Smith's amendments, I'd like to be absolutely clear about our intentions and how the provisions will help us achieve them. We want to ensure the best start and the best outcomes for our children. We want to ensure that children and families have somewhere to go if they need an extra bit of help, and that none are left without support. We want to promote an early intervention and prevention approach that is coordinated and that prevents problems escalating into crisis. We want to ensure, as far as possible, that no child slips through that net. A named person for every child will help us achieve all of that. It has to be for every child because we just don't know when that extra bit of help will be needed. It is a universal service, as Fiona MacLeod stated, a public good. And as Martin Crew, Director of Barnardo's Scotland, said, if we're to try and create a system where children don't fall through the gaps, it has to be a universal system. Unfortunately, children aren't born with an at-risk sign on their heads, so we have to have a system that does its very best not to allow children to slip through the gaps. And as Anne Houston, the Chief Executive of Children First, said following the serious case review about the tragic case of Daniel Pelkas, she said, deaths like Daniel Pelkas remind us why the principle behind the named person in the Children and Young People Bill is a sound one, as it aims to prevent children slipping through the net. The named person also provides parents, families and children with someone familiar that they can go to if they want a bit of advice or help navigate around other services. In Highlands, where the role is implemented, Bill Alexander, who has been commented upon earlier in this debate, said it operates effectively, enables agencies to respond more quickly to parents who raise concerns about their child's well-being. Mr Alexander also said we don't get complaints about the named person role being deployed. We get complaints when parents believe it has not been deployed. Now, we have consulted widely on the bill provisions. We have listened to parents and other groups, and they have been shaped. This bill has been shaped and honed by what people have told us was needed, and that includes parents and families, as well as charities and other organisations. And it was after listening to views and concerns, including those of parent groups, that we strengthened the information sharing provision at stage 2. And fundamentally, it was parents who told us they want this single point of contact and are fed up repeating the same stories to a number of different services. We listen to parents and will continue to listen to them because I've consistently said they are almost always the best people to support and protect their children. Now, I wish to clarify that ministers will use powers under the bill to issue guidance in relation to the named person service prior to commencement of the duties. The majority of children get all the love, the support and encouragement they need from their parents and their wider family, but it is impossible to say which child or family may at some stage need that extra support. If the named person can spot early signs that a child is experiencing difficulty, they can work with the parents and families to put in place the right support where required. Parents still have the right not to accept that advice. The only circumstances where parents would not be fully involved would be where to do so may place the child at risk of harm or danger or adversely affect the well-being of the child or young person. That will be the exception. Our guidance will be absolutely clear on these principles, and I will continue to work with parent and family groups in developing this statutory guidance. To undo this part of the bill, as the amendments suggest, and as Neil Bibby seems to want to do, is wrong and ill thought out, as it would remove the universal framework that supports early intervention and the better outcomes and well-being for our children that we all want to see. Amendments 1 to 50 specifically seek to remove support from young people and their families at the very time when they may be facing the challenges of transition to adult services and post-school services. As Jim Sweeney, Chief Executive of YouthLink Scotland, said, it is vitally important to support young people through this key transitional stage. Unfortunately, not all young people have parents who are willing or able to provide them with the support that they need at this difficult time, a period when they are making choices that will affect their future lives. Indeed, during the inquiry into decision-making on whether to take children into care, the Education and Culture Committee heard from many children and young people, including those over the age of 16, who reported their desire to have access to support services and the ability to go and speak to someone. Ms Smith's amendments fail to acknowledge this or to... I'll take an intervention from
Liam MacArthur.
I'm very grateful to the Minister taking an intervention. I've listened to what she said, and I think she's right in terms of the evidence we heard about the benefits of the named person. But I think, as Liz Smith and Neil Bibby indicated, the evidence from Bill Alexander did vary, and he was specifically highlighting the problems in having a named person for those in later teenage years. And therefore, it's not saying that a named person would not be available to those 16, 17 or 18, but the universality of that provision risks diverting resources away and undermining the very things that she's intent on achieving.
Minister, before I call you back, I'm afraid I have to say that as we're nearing the agreed time for the debate on this group, I'm exercising my powers under Rule 9.8.4ac to allow the debate on the group to continue beyond the time limit in order to avoid the debate being unreasonably curtailed. Minister.
Thank you. And I'll go on to make more points around this, because if this is to apply effectively, if it does apply effectively to children in their earliest years up to the age of 16, then this a principle of making sure that we can coordinate targeted support to children and young people aged 16 to 17-year-olds, that same principle holds true for this provision. Ms Smith's amendments fail to acknowledge this or to acknowledge that a young person needs to be able to access support if they have personal challenges, perhaps related to addiction, mental health issues, unemployment or homelessness.
Liz Smith.
Could I ask the Minister on that point, what is it that is preventing young people and their families from accessing that very important support now?
Minister.
Well, it's about making sure that that's coordinated in an effective way, having that single point of contact so somebody knows where to go to if they're not getting that support from their family, their friends or whatever. You know, that's why it has effectively worked well in the Highlands. That's why it has meant that we've had less inappropriate referrals to reporters, less inappropriate referrals to children's panels. It's why we've been able to better target support to those that are most vulnerable. Jim Sweeney, someone I think we should also listen to, has also pointed out that even if young people who leave school before they're 18 succeed in accessing a positive opportunity, such as a job or a further education place, they may need support to sustain these opportunities, as many young people drop out of courses or have difficulties in finding and keeping a job. Failing to find or keep a first job can have a scarring effect on the rest of the young person's life, leading to negative outcomes such as poor health and reduced life expectancy. It can also contribute to generational cycles of worklessness and poverty. Our aim in this bill is to provide better, slicker support for those who need it or where significant concerns emerge. We all recognise that young people aged 16 or over have varying degrees of need, skill and maturity, and that the majority of them will be able to reach their own decisions on issues affecting them. Many will not need to use the named person service and guidance, and the role should be delivered with flexibility, taking a light touch of approach when required. But no one knows what might happen in the next days, weeks or months. They may look to family and friends, but where they turn to public services for help, we should not be removing the support of their named person just because they have reached their 16th birthday, what the amendments seem to do and what Labour seem to want to support. Liz Smith has referred a number of times to a situation where a young couple aged 17 could be parents and could have contact with 3 named persons. What hasn't been acknowledged is the fact that many young parents do struggle to cope and can benefit from having a professional to turn to who can help them access the support they need. And she's suggesting that the way to streamline support for them is to take that support away altogether. More generally, Amendments 162 to 164 from Liz Smith fundamentally undermine the named person role and restrict their ability to encourage the early intervention and prevention approach which is needed if we are to prevent crises. Amendment 163 adds unnecessary bureaucracy to the named parent role, and in respect of 163, the proposed right of appeal to a sheriff, there are already procedures in place at a local level to deal with complaints about the exercise of the named person functions. We've also lodged Scottish Government amendments, which we'll debate later, to ensure that there is clear and accessible route for parents and families to go for independent consideration of complaints and determination of the issues where these local procedures are unsuccessful. Amendments 162A and 163A to 163F are dependent on Amendments 162 and 163 being accepted, and this group of amendments is similar to Amendments 1 to 50 above in that they remove references to young persons. What Liz Smith is suggesting is not supportive of a responsive, preventative and early intervention approach, but rather overly bureaucratic, resource-intensive, unnecessary and ultimately not in the best interest of our children and young people. And in terms of finance, and Neil Bibby's response to him, we have costed this, we are financing it. Health visitors' numbers have increased by over 14% since 2007. But as Joan McAlpine stated, we do have to wonder about Labour's full commitment to this policy, which has proven to be a success and has allowed services to be better targeted more effectively at our most vulnerable young people and children. So I do not support the amendments in Liz Smith's name.
Thank you. I now call on Liz Smith to wind up and indicate, please, if you intend to press or withdraw.
Thank you, Deputy Presiding Officer. Could I just repeat the fact that we have two fundamental objections to this aspect of the bill? We thoroughly object to the assertion that all children between 0 and 18 need to have a named person. And let me just go back on some of the evidence. It's been cited time and time again that Highland Region has been highly successful because of its named person policy. I don't doubt that Highland Region has been highly successful, but I can see no evidence whatsoever that it is to do with the named person policy as to other highly efficient aspects of GIRFIC, to their good leadership and to the way in which they organise their social services. They have a particular success rate on that, but I cannot find the evidence that it is to do with a named person. And that is something that was brought to this Parliament by the Finance Committee. Minister, you have alleged that it is fully costed and funded. I simply don't accept that. Nor did every single member of the Finance Committee who effectively laid your plans on this policy as though they had been put on the back of an envelope. It is very clear to me that there are serious implications for the lack of funding and costing of this. We have a situation where we have teachers and perhaps health visitors who are very concerned about the accountability that they will have in this, where the resources are coming from. And so I ask you to think about that point very carefully before it comes to the actual vote. Members have referred to all the evidence from parents that it's always been a case of parents supporting this policy. That is simply not true. The Scottish Parent-Teacher Council, for example, who did a very extensive survey on this, that was very clear. I think it was 83% of their parents did not accept it. So I think we have to be very careful on how we balance that evidence. But, Deputy Presiding Officer, I would like to press Amendment 1 in my name. We do have a very fundamental objection to this part of the bill.
Many thanks. The question then is that Amendment 1 be agreed to. Are we all agreed? Yes. Parliament is not agreed. There will be a division. It will be a 1-minute division. Please vote now. The result of the vote on amendment number 1 in the name of Liz Smith is yes 51, no 69. There were no abstentions. The amendment is therefore not agreed to. I now call amendment 2 in the name of Liz Smith, which has already been debated with amendment 1, and to ask Liz Smith to move or not move.
Not moved, Deputy Presiding Officer, and may I ask your permission not to move a number of consequentials in the group 1 to 50, which I think will save time.
Thank you very much. As Parliament will have heard, Liz Smith has indicated that she does not intend to move amendments 2 through to 50. We do, though, need to proceed through the marshalled list in order, and that's because any member can move any amendment on the marshalled list. However, to speed things up, where a number of the amendments that Liz Smith has indicated that she will not move appear consecutively on the marshalled list, I will simply read out the amendment number in order, and if anyone else wishes to move it, then they should shout out loudly. Silence will mean that the amendment is not moved. So, Amendment 3, Amendment 4, Amendment 5, 6, 7, 8, 9, 10, 11. That then brings us to Amendment 162 in the name of Liz Smith, which has already been debated with Amendment 1. Liz Smith, this was not an amendment that you indicated an intention not to move, so do you wish to move Amendment 162?
Yes, I do. Moved.
Okay, I also call Amendment 162A in the name of Liz Smith, which has already been debated with Amendment 1. Liz Smith, to move or not to move?
Moved.
Okay. The question then is that Amendment 162A be agreed to. Are we all agreed? Parliament is not agreed. There will be a division. This is a 30-second division. Please vote now. Order. The result of the vote on amendment number 162A in the name of Liz Smith is yes 41, no 79. There were no abstentions, and the amendment is therefore not agreed to. And I now call question number 162, and I ask if that is, are we all agreed to amendment number 162? Parliament is not agreed. Please now vote on amendment 162, a 30-second division. Order. The result of the vote on amendment number 162 in the name of Liz Smith is yes 15, no 106. There were no abstentions, and the amendment is therefore not agreed to. There is now another sequence of amendments that Liz Smith has indicated that she does not intend to move. So again, I will just read through them slowly, and if anyone else wishes to move them, please shout out when we come to that particular amendment. So, Amendment 12, 13, 14, 15, 16, 17, 18, 19. Could I have silence, please, because if there's any muttering, I'm likely to think that it's someone who wants to move the amendment. Amendment 20, 21, 22, 23 and 24. That then brings me to calling Amendment 163 in the name of Liz Smith, which has already been debated with Amendment 1. And I ask Liz Smith whether she wishes to move or not move.
Not moved.
That amendment is not moved. Unless anyone else wishes to move that amendment, I cannot then call Amendment 163A through to 163F, which are all in the name of Liz Smith and are all already debated with Amendment 1. I'm presuming, since I did not hear anyone moving Amendment 163, that no one wishes to. Therefore, 163 has not been moved, and we move on to Amendment 164. I now call Amendment 164 in the name of Liz Smith, which has already been debated with Amendment 1, and I ask Liz Smith to move or not to move.
Not moved.
It has not been moved. And since no one else has moved it, we now come to another sequence of amendments that Liz Smith has indicated that she does not intend to move. So again, I'm just going to read through them slowly. I would ask for silence, because if anyone does wish to move them, I have to be able to hear that. Amendment 25, 26, 27, 28, 29, 30, 31, 32, 33, 34, 35 and 36. That then brings us to Group 9, information sharing, requirement to obtain informed consent where information concerned is confidential. And I call Amendment 165 in the name of Liam MacArthur, which has been grouped with Amendments 166 to 171. And I ask Liam MacArthur to move Amendment 165 and to speak to all amendments in the group, please.
Thank you, Deputy Presiding Officer. The Minister and Committee colleagues will be aware that this is an issue I've been pursuing since stage 1, and I recognise the progress that has been made since then, notably through a series of amendments lodged by the Minister at stage 2. Sections 26 and 27 came in for fairly pointed criticism, not least from Professor Norrie, who was quoted earlier by the Minister, who gave the committee every encouragement to dump both sections over the side, lock, stock and barrel. However tempting this might have been, we opted for a different approach, and as a result, sharing of information about a child or young person can only take place where it is, quote, proportionate and relevant. Moreover, it can happen only with regard to the views of the child. Welcome though this is, and I acknowledge the steps taken by the Minister at stage 2, evidence received by the committee makes clear that this does not require the consent of the child before information can be shared. As a result, there is a risk that a child's right to privacy under Article 16 of the UNCRC and Article 8 of the ECHR could be compromised. The Minister will point to the advice from the Information Commissioner's Office suggesting that data protection rules are not breached where information is shared about a child about whom there are wellbeing concerns, even if consent has not been sought. But as Clan Child Law and the BMA point out, if no attempt is made to seek the child or the parent's consent before confidential information is shared, quote, there is a significant risk that children and young people will be reluctant to access and engage with confidential services. They go on to confirm that a child or young person's right to privacy is not respected in the absence of a requirement to seek consent. My amendments in this grouping acknowledge the need for exceptions to be made where the information holder considers that to seek consent would be likely to adversely affect the well-being of the child or young person, and would require guidance to be drawn up on how confidential information should be shared in such circumstances. However, these amendments reflect the approach already taken, I understand, in relation to the Health Service, and I think the absence of a more explicit reference to the need for informed and explicit consent to be sought weakens the bill and opens it up to justify criticism. I look forward to the comments from the Minister and other colleagues and move Amendment 165 in my name.
Thank you. And I call Stuart Maxwell.
Thank you, Presiding Officer. Information sharing was discussed extensively during Stage 1 evidence-taking by the Education and Culture Committee. Concerns were indeed raised by some witnesses, as Liam MacArthur has very fairly said, and indeed the committee itself raised these matters in its Stage 1 report. the committee again had the chance to discuss and debate information sharing at stage 2, and we did so extensively again. In my view, this part of the bill was indeed improved by amendments passed at stage 2, and the bill is now, I believe, both robust and balanced in this area. In addition, the Minister committed to publishing full guidance on the implementation of the information sharing provisions. But turning directly to the amendments in Liam MacArthur's name in this group on the issue of confidentiality. Of course, confidentiality should be respected at all times. However, Liam MacArthur, I think he does recognise, and I think he was very careful in the way he spoke, but he must recognise that there is an expectation that there would be discussions with the child and that their views would be taken into account before a decision was made to share information. Breaching confidentiality is not a decision that would ever be taken lightly, but sometimes it is necessary in order to promote, support or indeed safeguard a child's well-being. My real concern is that if these amendments were agreed to, then it would interfere in the very intention of the bill regarding safeguarding a child's well-being. Now, I know that's not the intention of Liam MacArthur, and I know that he's doing his best to achieve what is a very difficult balance in this area. However, I'm sure Liam MacArthur is aware that in many of the most tragic cases that we're aware of in recent years, the lack of information sharing has been identified as one of the key factors in the tragedy, and therefore I cannot support amendments that in any way could possibly result in either confusing or slowing down appropriate information sharing. Thank you.
Thank you, President Officer. I rise to support Liam MacArthur's amendments in two parts. First of all, the amendments look to increase the amount of rights that children themselves have. And I think that's very important, given that a very long time ago we actually had two bills, one of which was the Rights of Children and Young People Bill. And I think involving them and giving consent to their own data wherever possible is absolutely the correct approach. Of course, the other aspect of Liam MacArthur's amendments is that it will give parents the right to be consulted where information about their child is proposed to be shared by organisations where it isn't specifically about that parent. I think that's very sensible, and that's why these benches will be supporting Liam MacArthur's amendments.
Liz Smith. Very briefly, Presiding Officer, I'm also grateful to Liam MacArthur for bringing forward these amendments which strike at the heart of the concerns of the data sharing aspect of the bill. Notwithstanding the comments made by Stuart Maxwell, which I think were very well intentioned, there is no doubt that this does remain a controversial part of the bill, and as things stand, there is still some scope for the sharing of data to be misused or abused, and not just in relation to the named person policy. Many professionals on the ground are concerned about where their responsibilities lie and therefore where the accountability will lie, especially when it comes to a dispute or even a general disagreement between themselves, a family and a named person. So we will be supporting these amendments.
Jo McAlpine.
Thank you very much. I agree with Stuart Maxwell in that I respect the way Liam MacArthur put his arguments across, and he'll know that in the committee I also did have concerns about some of the provisions of the bill and raised the issue that was raised by LGBT Youth Scotland, who were concerned about the privacy of young gay teenagers. But I'm confident that, that the guidance will address those concerns, and I'm also confident that, given the amount of attention that we've paid to this issue, that professionals will act appropriately. And the other aspect of this is in terms of parents' confidentiality. And again, I had some concerns in terms of how proportionate that would be in terms of sharing information about the well-being of children which wasn't threatened. But you know, I think you've got to balance these things and look at what's best for vulnerable children. And I'm confident that the guidance will address the concerns that I had and the concerns that other people had. And more importantly, if you look at this in the wider context, every inquiry into a child's death has concluded that information sharing was not robust. And I think that, on balance, the concerns of people like myself and others, you know, we should put them aside and trust that professionals will make the correct judgments and protect the most vulnerable, and that's why I won't be supporting the amendment.
Minister.
We have listened very carefully to the arguments in support of the amendments in this group, and we share many of the sentiments expressed. We have to ensure that appropriate information is shared when there is a reason to do so. We also have to ensure that we seek to respect the views of the child and their right to privacy in terms of data protection and ECHR legislation, as well as seeking to promote, support and safeguard their well-being. In this context, the amendments seek to achieve a careful balance in what are complex provisions of the bill. But I would like to set out why we believe the current bill provisions, as we amended them at stage 2, as Stuart Maxwell and Joan McAlpine pointed out, that those amendments best reflect an appropriate balance in sharing information, promote good practice and meet the important aims set out by Liam MacArthur. Amendments 165, 166 and 168 seek to ensure that informed and explicit consent is obtained prior to the sharing of confidential information under Section 26. They provide that the information holder should take account of the child's age and maturity when seeking consent. An exception to the duty to seek consent is made if the information holder considers that it would adversely affect the child or young person's well-being to do so. The amendments rightly recognise that information which is confidential should not be routinely shared, that the child's views about the information being shared are important, and that sharing or not sharing information can have a serious effect on the child. The information sharing provisions in the bill, as amended at stage 2, already provide for careful consideration to be given to issues of confidentiality, the views of the child or young person, and the impact of information sharing on their well-being. These amendments are more limited in scope than the current bill provisions, in that they do not extend to sections 23 and 38, which also require information sharing. Amendments 169 and 171 seek to remove sections 26(8) and 38(3). They therefore remove the protections we introduced at stage 2 to make it explicit that where there is legal prohibition or restriction on sharing information, that it cannot be ignored. These amendments do not include an amendment to the corresponding provision in section 23, which we included in our stage 2 amendments. And while the bill's provisions refer to a duty of confidentiality, these amendments simply refer to confidential information without any definition, leaving room for potential confusion. Amendments 167 and 170 seek to ensure that guidance published in respect of Part 4 of the bill contains advice on how to proceed when consent to the sharing of confidential information cannot be obtained, and that information holders must proceed in accordance with this guidance. Section 28 of the bill already allows for guidance to be issued in relation to the exercise of all functions conferred by Part 4. That includes the information sharing duties. Section 28 also requires all persons exercising those functions to have regard to the guidance. These amendments, we believe, therefore, are unnecessary. The bill is clear that practitioners need to consider carefully what information must be shared when and with whom. The bill provisions support early intervention. That's why it's crucial for the named person to be aware of all concerns about a child's well-being. We have listened to the views of stakeholders, specifically in the health sector, who found confusion and at times conflict when operating under a duty of confidentiality, even when they knew that it would be in the best interests of the child to share information. Section 26(8), as amended, therefore, permits them to share information, but only after considering all of the other tests in Section 26. Sections 23(7) and 26(8) also make it clear that the bill does not permit a breach of any other legal restrictions on the disclosure of information. Now, of course, we know that the child's views are important, and that's why we brought forward amendments to all the information sharing provisions at stage 2 to ensure that the child's views are obtained wherever possible. As stipulated in Section 28, guidance will reinforce these important principles, which recognise the importance of taking the child's views into account, and also recognise that sharing information about a child's well-being can do harm as well as good. The amendment to further specify that guidance should be followed is not required and will add nothing to the existing provisions. Amendments 165 to 171 seek to go too far when a child's well-being is at risk and would potentially prevent information from being shared appropriately. Stuart Maxwell has already pointed out that, as we know, every inquiry into a child's death in the last few decades has shown that information sharing, or the lack of it, has been a key factor. What is proposed complicates and will potentially confuse the intention behind the bill, which is to ensure that appropriate and proportionate information gets to the named person well before crisis. So therefore, we do strongly oppose all of the amendments in this group, not because we don't respect the principles that Liam MacArthur has outlined that they seek to promote, but because we strongly believe the bill already provides for those important principles that Liam MacArthur laid out is respected.
Thank you. Can I ask Liam MacArthur to wind up and indicate whether you wish to press or withdraw your amendment?
Thank you, President Officer. Can I start by thanking Kezia Dugdale and Liz Smith for their comments and support. Can I also thank Joan McAlpine, whose, I think, interest and pursuit of this issue through stage 2, particularly in relation to the concerns raised by LGBT, very much were ones I was sympathetic to and supported. And can I thank Stuart Maxwell for what I thought was a fairly accurate explanation of the journey the committee went through and the evidence that we took. I think he's right to highlight the concern that we don't want to do anything here that would either create confusion or slow down the process. But I think, as I said in my earlier remarks, there's equally a risk that we slow down the process through children, young people, their parents and guardians not engaging with confidential services because of the concern around a lack of explicit consent. The presumption of consent, with the exemption that seeking consent would not be sought when it's likely to adversely affect the well-being of the child or the young person, I think strikes the right balance. And I think picking up the point that the Minister and I think Joan McAlpine made would also leave scope for professional judgment of those tasked with making enormously difficult decisions about the circumstances in sharing confidential information. But I think these amendments are important in giving further confidence to children, young people, their parents and guardians that what we put in place is proportionate, is robust, allows the latitude for the exchange of information in the correct circumstances. And on that basis, notwithstanding the comments made by the Minister and other colleagues, I'll be pressing the amendment in my name.
The question is that Amendment 165 be agreed to. Are we all agreed? No. We are not agreed. This is a 1-minute vote. Members should cast their votes now. Thank you. The result of the vote on Amendment number 165 in the name of Leah MacArthur is as follows. Yes, 55. No, 65. There were no abstentions. The amendment is therefore not agreed to. The next, Amendment number 37 in the name of Liz Smith. Ms Smith has already indicated she is not moving it. Does anybody else wish to do so? The question is, I now call Amendment number 166 in the name of Leah MacArthur. It's already been debated with Amendment number 165. Mr MacArthur, to move or not move?
Moved.
Mr MacArthur has indicated that we move, so we move to a vote. I call Amendment number... The question is Amendment number 166 in the name of Leah MacArthur be agreed to. Are we all agreed? No. We are not agreed. We move to a vote. Members should cast their votes now. The result of the vote on Amendment number 166 in the name of Leah MacArthur is as follows. Yes, 44. No, 76. There were no abstentions. The amendment is therefore not agreed to. I now call Amendment number 167 in the name of Leah MacArthur, which has already been debated, with Amendment number 165. Leah MacArthur, to move or not move?
Moved.
The question is that Amendment number 167 be agreed to. Are we all agreed? No. The Parliament is not agreed. We move to vote. Members should cast their votes now. The result of the vote on amendment number 167 in the name of Liam MacArthur is as follows: yes 42, no 78. There were no abstentions. The amendment is therefore not agreed to. I call amendment number 168 in the name of Liam MacArthur, already debated with amendment number 165. Liam MacArthur to move or not move?
On the basis I'm losing support by amendment, not moved.
Not moved. I now call amendment number 168 in the name of, amendment number 38 in the name of Liz Smith. Ms Smith has indicated she has not moved this amendment. Does anybody else wish to do so? Nope. Amendment number 39. Liz Smith has indicated she has not moved an amendment. Does anybody else wish to do so? No. I now call amendment number 169 in the name of Liam MacArthur, already debated with amendment number 165. Liam MacArthur to move or not move?
Not moved.
It's not moved. I now call amendment number 170 in the name of Liam MacArthur, which has already been debated with amendment number 165. Liam MacArthur to move or not moved?
Not moved.
It's not moved. I now call amendment number 75 in the name of the Minister, already debated with amendment number 69. Minister to move formally.
Moved.
The question is that amendment number 75 be agreed to. Are we all agreed? The amendment number 75 is agreed to. I now call amendment number 76 in the name of the Minister, already debated with amendment number 69. Minister to move formally.
Moved.
The question is that amendment number 76 be agreed to. Are we all agreed? That is agreed. Before I move on to the next group, which is Group 10, I invite any member to move a motion without notice under Rule 985A to extend the next time limit by up to 30 minutes to allow proceedings on amendments to be concluded and to allow discussion. Thank you. Can I ask that the Parliament agrees to extend? Thank you. We now move to group number 10. I call amendments number 101 in the name of the Minister, grouped with amendments 102, 112 and 113. Minister, move amendment 101 and speak to all the other amendments in the group.
Thank you. I move amendment 101 in my name. The Scottish Government is committed to clear, quick and accessible routes for the consideration of complaints if there are any disagreements about the exercise of the named person or child's plan functions. We are also committed to ensuring that a mechanism for this is in place in advance of the commencement of the GIRFEC duties currently scheduled for 2016 as set out in the financial memorandum. However, we do not want to add unnecessary complexity to the complaints landscape where there are existing mechanisms to enable people to challenge decisions or roles in public services. The Scottish Public Service Ombudsman, the independent body which handles complaints about devolved public services in Scotland, highlighted in evidence to the committee the difficulties sometimes caused by the complexity of complaints processes. Amendment 101 enables ministers to propose provisions for dealing with complaints in respect of the named person duties in Part 4. It will also enable ministers to propose changes to other legislation if required in order to provide an accessible and consistent an avenue as possible for complaints handling in relation to the named person duties. Amendment 102 allows the Scottish ministers to make equivalent provision in respect of the child's plan duties in Part 5. Amendments 112 and 113 propose that order-making powers are subject to affirmative procedure. This is considered appropriate so that Parliament has the opportunity to scrutinise, to debate and, if satisfied, to affirm the detailed proposals before they can come into force. I am very grateful to Liz Smith for her help and her input into discussions on these amendments and for the useful meeting that we had following the Stage 2 committee sessions. And I hope we can continue to work together as we develop the detail of those proposals. Processes already exist for the consideration of complaints at local level, and we would expect disagreement about the duties in Parts 4 and 5 to be resolved at this level, if at all possible. If this isn't possible, we want to ensure that there is a clear and accessible route for parents and families to go for independent consideration of complaints and determination of the issue. The order-making power will enable us to ensure that all matters that should be subject to a complaint and independent investigation are covered. This will be a key focus of our planned consultation as we take into account stakeholder views on the detail of what is required. We will also continue our discussions and work with the SPSO to ensure we avoid duplication and do not add unnecessary complexity to the complaints landscape. And as we develop the detail, we also need to take into account the current wider consideration of complaints in social work, where we are also keen that the system should meet the needs of service users. We don't want to preempt the outcome of that work by putting detail for the GIRFIC provisions on the face of this bill now. We are therefore proposing these order-making powers to give the flexibility required to take into account related developments elsewhere. This will also enable us to engage further with stakeholders, especially parents and families, which will inform the development of these proposals. So, as I said previously, we are committed to having a clear and accessible system for the consideration of complaints in place in advance of commencement of the GIRFIC duties. The order-making power proposed will enable us to achieve that. Therefore, we seek your support, the Chamber's support for those amendments in my name.
Thank you. I now call Liz Smith.
Thank you, Presiding Officer. As the Minister has indicated, at stage 2 I put forward 3 amendments which sought to introduce provisions for the resolution of disputes regarding the need, content and management of a child's plan. After hearing the responses from the Minister, I decided not to press these amendments at stage 2 on the grounds that she was similarly committed to introducing a clear route of redress for families, parents and children. I appreciate that sentiment and I was grateful to her for some engagement. She knows from my email of the 5th of February that whilst I am content with the spirit of the Scottish Government's amendments 101, 102, 112 and 113, I do still have some concerns about whether there will be a sufficiently robust appeals process in place as distinct from just a complaints process. So before accepting these amendments in full, I would be grateful if she could just guarantee that she will consider the matter further and also engage with the Muir-Maxwell Trust, who have been extremely diligent in addressing this particular issue. Likewise, it would be very helpful if the Minister could indicate the time frame for consultation on the new mechanism and how its independence will be assured.
Liam MacArthur.
Thank you, President Officer. As I indicated earlier, after initial misgivings, I've been persuaded by the case for the development of a system of named persons. That said, I don't think it requires a crystal ball to see that there are likely to be points at which the way this operates in practice is not going to be acceptable to those involved, including children, young people and their parents or guardians. Indeed, I raised similar concerns about the lack of an appeals process with regard to child plan provisions set out in Part 5 of this bill. But it was the efforts of Liz Smith at stage 2 that secured the concession from the Minister in relation to Part 4, and I congratulate her on that not inconsiderable achievement given the fate of every other opposition amendment at stage 2. Nevertheless, I can only give a cautious welcome at this stage to the move by the Minister in Amendments 101 and 102 to take order-making powers that would allow a complaints procedure to be introduced for both Parts 4 and Part 5. I think, as Liz Smith suggests, the Muir-Maxwell Trusts I think make some interesting observations in this respect. They suggest that what is set out looks a little tick box with the cards loaded against the child and or their parents. They also question the need or justification for time limits, and this is something that I have some sympathy with, as any case would presumably be dealt with on its merits. The Minister will have seen the Muir-Maxwell Trust briefing and the call for a firm commitment to continue working with the Trust and others to create an appeals system that is fair and genuinely works for all, especially for children and young people with profound learning disabilities. And I assume that this is something the Minister will confirm that she's happy to do. Thank you.
Can I thank the Minister for taking on board the comments that, and the discussion that took place in the Education and Culture Committee, particularly at stage 2 in relation to the amendments that Liz Smith mentioned earlier. I'm delighted that the Minister has moved on this and brought forward these amendments, which are most welcome. And I think we all look forward to the consultation process to ensure we do get a complaints procedure that is both transparent and a speedy process to be in place as soon as possible. Thank you.
Can I call on the Minister to wind up?
Thank you, Presiding Officer, and I'm grateful to Liz Smith for her engagement in this and for not pressing at stage 2 to allow us to work together on what we proposed and what we set out in stage 3. And I'm also grateful to Liam MacArthur and to Stuart Maxwell as well for their comments. I've said that the implementation of GIRFIC won't happen until 2016, so we'll be able to work until then to ensure that before that's implemented there will be robust complaints procedures in place. We will commit to working with the Muir Trust as well, the Muir-Maxwell Trust, in order to ensure that we've got and managed to capture all views, and not least as well the views of parents and families as we develop this approach in terms of raising complaints. And we'll also make sure that we can
use the affirmative procedure within the bill to allow Parliament to wider scrutinise this too. So hopefully the spirit by which we've approached this and the continued commitment to engage with parliamentarians and other interest groups will ensure that we have, while at the point in which GIRFIC comes into action, a robust process by which families can take forward any concerns that they have.
Thank you. That ends that group. The question is that amendment number 101 be agreed to. Are we all agreed? We are agreed. I intend to suspend for 10 minutes to allow a very short comfort break. I'm given a 2-minute warning that we'll be resuming. We are just about to resume. Could members please take their seats? We're ready to go, aren't we?
We should really be going well in about 30 seconds. You should be.
Minister will be resuming in 30 seconds. We now move to Group 11, the meaning of relevant and listed authorities, etc. I call Amendment number 77 in the name of the Minister, grouped with other amendments as shown in the groupings. Minister, move Amendment number 77 and speak to all amendments in the group.
Okay, I move Amendment 77 in my name. Amendments 77 and 86 specify that the Commissioner for Children and Young People in Scotland and post-16 education bodies are not relevant authorities for the purposes of Section 29 in relation to directions on the named person functions and Section 40 in relation to directions on child's plan functions. The amendments remove these bodies from being subject to ministerial direction because it conflicts with their established status as independent from ministers, the Scottish Government and Parliament. Conceivably, bodies to be added to Schedules 2 and 2A in the future may have similar concerns about their independent status and being subject to ministerial direction, and so the changes proposed by Amendments 77 and 86 allow the duty to comply with ministerial directions to be disapplied in relation to these bodies, should it be appropriate. Amendments 90 and 91 provide that these order-making powers should be subject to affirmative action. Procedure. Sorry, Presiding Officer. Sorry, I thought you were querying something. Okay, apologies. Amendments 78, 79, 80, 81, 82 and 84 are minor technical amendments which are made in consequence of Amendments 77 and 86. Amendment 87 is a minor technical amendment to Section 51 to provide that the definition of corporate parents of the purposes of Part 7 is made subject to subsection 3A as well as subsection 3. This is made in consequence of subsection 3A being added at stage 2 to provide that the Children's Commissioner and post-16 education bodies are not corporate parents for the purposes of section 58 of the bill, thereby exempting them from the powers of ministerial direction as set out in that section. These bodies are, however, corporate parents for all purposes in Part 7.
Amendments 198, 199 and 200 would have the effect of removing the Children's Commissioner from Schedules 2A and 3 respectively, effectively removing the requirement for him to provide information and assistance in respect of the named person and child's plan functions and to take on corporate parenting responsibility. Amendments 77A, 86A and 176 seek to remove the references to the Children's Commissioner in the provisions about directions in Parts 4, 5 and 7 in consequence of Amendments 198, 199 and 200. We don't support these amendments in Liam MacArthur's name, and I want to explain why. We introduced an amendment at stage 2 to remove the requirement that the Children's Commissioner and his officers must comply with ministerial directions relating to Part 7 corporate parenting responsibility on the grounds that it conflicted with their established independence from ministers and the Parliament. We have, for similar reasons, introduced Stage 3 amendments to disapply ministerial direction-making power in respect of the Children's Commissioner in Parts 4 and 5. However, to remove the Children's Commissioner from Schedules 2 to A3 completely would go too far. If the Children's Commissioner holds relevant information about a child which meets the test introduced to Section 26 of the Bill at Stage 2 and which is not already known to the named person, then our policy intention is that this information should be shared. These provisions are designed to promote, support and safeguard children's well-being. Sharing relevant and proportionate information relating to the well-being concerns with the named person need not compromise the Commissioner's ability to exercise his functions, including any investigatory function. The duties to help the named person in terms of Section 25 and to provide information, advice or assistance in relation to a child's plan under Section 38 do not apply where it would be incompatible with any of the Children's Commissioner's duties or would unduly prejudice the exercise of any of his functions. This would give the Commissioner a safeguard if he feels that his position would be compromised in providing or the requested information, advice or assistance. With respect to Liam MacArthur's Amendments 176 and 200, I acknowledge his concerns about the role of the Children's Commissioner and his proposal to remove him as a corporate parent. Our Stage 2 amendment to disapply the Section 58 ministerial direction-making power met the substance of the concerns by the Commissioner at that time, but importantly retained the Commissioner as a corporate parent with the same broad duties as the wider public sector. The Children's Commissioner is a leading advocate of the rights of the children in Scotland and already plays a key role towards improving outcomes for looked-after children. It therefore sits uncomfortably that we should not consider a special exemption for the Commissioner when his role is so important towards this aim. So, in summary, we can't support the amendments in Mr MacArthur's name. I do, however, ask the Parliament to support the amendments in this group in my name.
Thank you. I now call Liam MacArthur to move amendment number 77E and the other amendments in the group.
Thank you, Presiding Officer. The Minister's already set out in relation to our amendments 77, 86, etc. the steps the Government is taking to remove the Children's Commissioner from the list of relevant and listed authorities, effectively thereby, as she said, lifting the threat of ministerial powers of direction. I welcome this move very much and following on from the earlier steps taken by the Minister at Stage 2. However, concerns do still remain, concerns that arise from the continued inclusion of the office in Schedules 2, 2A and 3, which could result, according to the Commissioner, in, quote, unprecedented executive interference with the model that Parliament chose and reaffirmed for bodies such as the Commissioner. The schedules would inevitably involve the Commissioner in a network of close institutional relationship with statutory children's services providers, and on the face of this, this might appear desirable, but there is the chance that such providers could be the subject of investigation by the Commissioner, in which case the perception of independence could be compromised. This problem would be all the more acute where the Commissioner would have a duty to share information about individual children with statutory services acting as named persons, as the Minister acknowledged. The Commissioner explains, and I quote, "It is only a question of time until the Commissioner will be required under this duty to disclose sensitive information about a child complainant to the service provider under investigation, which also provides the named person service to that child, thereby giving the service provider a degree of power over the Commissioner in terms of the investigation, precisely what Parliament sought to avoid by choosing the institutional set-up of the 2003 Act. In addition, it is pointed out that inclusion of Schedules 2A and 3 of the Bill would appear to require the Commissioner's Office to actively participate in care planning for individual children, something that quite demonstrably would be inappropriate, not least given the importance of maintaining and being seen to maintain a level of independence. In conclusion, without my amendments 198, 199, 200, as well as the other consequential changes, we could end up needlessly limiting the effectiveness of the Commissioner and his office. In so doing, I think we risk closing off avenues of complaint and appeal open to some of the most vulnerable children and young people in our society. That is not the intention, but I fear it could be the effect, and urge Parliament to support my amendments. Thank you.
Thank you. I now call the Minister to wind up.
Thank you. I believe that our amendments strike a good balance between respecting the role of the Children's Commissioner and understanding his position, and that he wants to maintain the independence that he requires. In respect of Schedules 2 and 2A, I've already explained the need to retain the Commissioner in these schedules, since in order to fully achieve our policy of getting it right for every child, we need to ensure that all of those who hold relevant information about children's well-being can share it. However, I am confident that the safeguards that I have referred to, which recognises the circumstances in which it would not be appropriate to share information, should give the Commissioner the reassurance that he requires, so that his independence and investigations are certainly not compromised. In respect of Schedule 3, we don't consider that a special exemption from the corporate parenting duties would be appropriate, given the Commissioner's key role in achieving those aims of Part 7. We consider that the disapplication of the duty to comply with directions, which we have already achieved in respect of Part 7 and which we are now proposing in respect of Parts 4 and 5, strike the right balance between protecting the independence, as I have already said, of the Children's Commissioner and ensuring that important policy aims of this bill in respect of promoting, supporting and safeguarding children's well-being are met. We would hope that the Children's Commissioner, in recognition of the very unique position that he holds, would want to engage with other services to address issues relating to the well-being of children wherever they arise, and would be keen to play a part in improving outcomes for looked-after children. So this would seem to be in the best interest of the child involved, and the bill as drafted, and as we are proposing to amend it now, would not require the Commissioner to act in any way that was inconsistent with the proper exercise of his functions. Therefore, we ask the Chamber to support the amendments in my name and not the amendments in Liam MacArthur's groups, because we do believe we have achieved the right balance and we have protected the Commissioner's role in respect of his functions.
Thank you. Liam MacArthur to wind up on Amendment 78 and to indicate whether you wish to press or withdraw.
Am I winding up on this grouping? I mean, I've heard what the Ministers had to say in relation to my amendments. I still think there is an issue of, if not a compromising of the independence, a perception of the compromising of independence, and therefore I will be pressing my amendments. Thank you.
I'm sorry, Ms MacArthur, could you confirm whether you're withdrawing or pressing?
I'm pressing.
Thank you. The question is that amendment number 77A be agreed to. Are we all agreed? We are not agreed. Members should cast their votes now. The result of the vote on amendment number 77A in the name of Liam MacArthur is as follows: yes 51, no 64. There were no abstentions. The amendment is therefore not agreed to. The next question is that amendment number 77 be agreed to. Are we all agreed? Are we all agreed? We are all agreed. We now come to another sequence of amendments that Liz Smith has indicated that she does not intend to move. So again, I will read them one by one. Amendment number 40. Amendment number 40. It's not been moved. Amendment number 41. Not moved. Amendment number 42. Not moved. Amendment number 43. Not moved. I now call amendment number 78 in the name of the Minister, which has already been debated with amendment number 77. Minister, to move formally.
Moved.
The question is that amendment number 78 be agreed to. Are we all agreed? And now the final sequence of amendments that Liz Smith has previously indicated does not intend to move. Amendment number 44, not moved. Amendment number 45, not moved. Amendment number 46, not moved. Amendment number 47, not moved. And amendment number 48, not moved. I now call amendment number 79 in the name of the Minister, which has already been debated, with amendment number 77, Minister, to move formally.
Moved.
The question is that amendment number 79 be agreed to. Are we all agreed? We are agreed. I'll call amendment number 80 in the name of the Minister, which has already been debated, with amendment number 77, Minister, to move formally.
Moved.
The question is that amendment number 80 be agreed to. Are we all agreed? We are agreed. Call amendment number 171 in the name of Liam MacArthur, already debated, with amendment number 165. Mr MacArthur, move or not move?
Not moved.
Not moved. I now call amendments number 81 to 85 and 82, all in the name... 102. Sorry, I'll repeat that. I call amendments 81 to 85 and 102, all in the name of the Minister and all previously debated. I invite the Minister to move amendments number 81 to 85 and 102 en bloc. If any member objects to a single question being put on amendments 81 to 85 and 102, can you make it known now? No member objects. The question is that amendments number 81 to 85 and 102 are agreed to. Are we all agreed? We are all agreed. I now call amendment number 86 in the name of the Minister, which has already been debated, with amendment number 77. Minister, to move formally.
Moved.
I now call amendment number 86A in the name of Lee MacArthur, already debated, with amendment number 77. Lee MacArthur, to move or not move?
Moved.
It has been moved. The question is that amendment number 86A be agreed to. Are we all agreed? We are not agreed. Members should cast their votes now. The result of the vote on amendment number 86A in the name of Liam MacArthur is as follows: yes 53, no 63. There were no abstentions. The amendment is therefore not agreed to. The next question is that amendment number 86 be agreed to. Are we all agreed? We are agreed. We now move to Group 12, which is provision of early learning and childcare. Point of order, Kezia Dugdale.
Thank you very much, President Officer. I raise a point of order under 9.3.2 and do so as this is the first aspect of the bill which involves capital costs. Can I ask you, President Officer, to look again at 9.3.2, first raised by the distinguished convener of the Finance Committee, and can I draw your attention to his letter to the Minister earlier today? The committee is very concerned that a best estimate has not been provided for the capital costs as required by Rule 9.3.2 of the Parliament's standing orders. Furthermore, President Officer, can I draw your attention to the financial memorandum of the bill, in particular page 5, paragraph 13, which states very clearly under the childcare section that capital costs have not been explicitly estimated. It says it is not possible to provide an accurate estimate of the level of infrastructure investment required at this stage. Further work will be required to explore the need for any additional capital funding. Given that we are being asked to essentially sign a blank cheque this afternoon, can I ask whether there is scope within standing orders to suspend business until the Government are able to offer an explanation and indeed an apology? To proceed without an explanation, we believe, is discourteous to Parliament and impacts on our duties as parliamentarians to scrutinise and vote on what is before us.
I thank you, Ms Dugdale, and I thank you for giving me prior notice of the point of order. As was said earlier today, when a very similar point of order was raised, under Rule 9.12, a financial resolution was passed by this Parliament at stage 1 of the bill. A supplementary financial memorandum was lodged as required by Rule 9.78b. As a result of that, amendments were agreed to at stage 2. I am also aware that the Finance Committee and the distinguished convener took advice on the financial memorandum this morning, and that in the light of this scrutiny, the convener has written to the Minister raising concerns about the information in the supplementary financial memorandum. The convener has also invited the Minister to give further evidence to the committee. As was said this morning by the Deputy Presiding Officer, the standing orders make it clear that a financial memorandum must be passed as it has been done. A supplementary memorandum has been set forward in relation to the amendments. I understand the point that the member makes, and it is of course open to any member to write to the Standing Orders and Procedures Committee to ask whether this is something that may be looked at in the future. But for the moment, a financial resolution has been passed and it meets with the standing orders of this Parliament. I now call amendment number 51 in the name of Liz Smith, grouped with other amendments as shown in the groupings. Liz Smith to move amendment number 51 and speak to all amendments in the group.
Thank you, Presiding Officer. I wonder if I could, just before moving this amendment, just seek clarification as to whether you are indicating that there will be further evidence to be taken prior to us voting on these amendments.
This is entirely a matter for the committee and the Minister. Liz Smith.
When it comes to the question of nursery provision, Presiding Officer, I brought forward amendments designed to end the practice of birthday discrimination in our nurseries, which sees children born between September the 1st and the 29th of February receive significantly less provision than those born at other times in the year. And that was acknowledged by Angela Constance when she responded to a question from Malcolm Chisholm this afternoon. I think it was question 13 in education session. This anomaly derives from the Scottish Government's practice of funding nursery provision from the term after a child turns 3, and this, as Reform Scotland has shown, means that nursery provision can vary by up to 317 hours or by more than £1,000 within the cost of nursery partnership provision. A child born between 1st of March and the 31st of August is entitled to the 2 full years nursery provision before beginning school, but a child born between the 1st of September and the 31st of December will only get 18 months provision, and a child born between the 1st of January and the 28th of February receives just 15 months. Self-evidently, this situation is grossly unfair, and amendments 51 to 54 would rectify this by introducing a fixed start point for all children, as is common practice with primary schools. This would end the present shortcoming and would place nursery provision on an equal basis. Both the Liberal Democrats and Labour supported the plans at stage 2, but for some reason SNP members seem intent on blocking this measure, despite their commitment to what they describe as transformational policies to support young children. At stage 2, Colin Beattie spoke of 30,000 additional 2-year-olds entering the system. That is wrong. Amendments 51 to 54 would not extend childcare to new groups. Instead, they would ensure equality of access across the board by accelerating the uptake. And of course, this will incur a cost. We're very well aware of that, but that's something that the Conservatives have not shied away from. But we would much prefer to see this policy in place rather than the universal free school meals policy, for example. Furthermore, at stage 2, the Minister argued that the amendments were unnecessary because the commencement dates can be set via secondary legislation. She did not, however, make any commitment to make this change. Indeed, the SNP has said on the record that it does not have any plans to make these changes, so that is why amendments 51 to 54 are necessary. The status quo is simply unacceptable. Presiding Officer, in removing an unwelcome anomaly from nursery system, amendments 51 to 54 would place all children on that equal footing. I think that's an entirely reasonable suggestion, and I hope the Scottish Government will accept these amendments. So I move Amendment 51 in my name.
Many thanks. And I ask the Minister to speak to Amendment 103 and the other amendments in the group, please.
Thank you very much, Presiding Officer. Amendments 51, 52 and 53 would, through moving to a system of all children receiving 2 years of funded early learning and childcare, result in significant numbers of children taking up their entitlements, some from the age of 2.5. Amendment 54 would make the order-making power in Amendment 51 subject to the affirmative parliamentary procedure. While we accept the need for building on the provisions within the bill, the priority at this stage must be to build additional hours and flexibility into our high-quality universal provision, increasing the entitlement to around 16 hours a week, and, as we expand, to focus on our more vulnerable 2-year-olds. We have demonstrated our commitment to do this through the additional 2-year-olds announced by the First Minister on the 7th of January. These amendments are unnecessary, as any further expansion or changes to commencement dates for entitlement to early learning and childcare for 2- or 3-year-olds can be achieved through secondary legislation made under the bill. In terms of the start dates for 3-year-olds taking up the funded entitlement, local authorities can and do deliver provision beyond the minimum number of hours and minimum eligible children. A number of local authorities, therefore, already start children from their 3rd birthday or the month after their 3rd birthday, where they have the capacity to do so. The youngest children, those born in January or February, who may get less provision when they are 3, will continue to be entitled to an additional year after they are 4, where parents wish. In addition, increasing entitlements to 2-year-olds will result in a significant decrease in the numbers of children who will be impacted by the issue of 3rd birthday start dates. We share the ambitions within Amendments 172, 173 and 174 to deliver early learning and childcare to significantly more 2-year-olds in greater need. We know that children from more disadvantaged backgrounds benefit most from high-quality early learning and childcare. And we were absolutely delighted when the First Minister announced on the 7th of January that we will increase the entitlement to those 2-year-olds set out in Amendments 172, 173 and 174 from August 2015. I'm pleased that Neil Bibby agrees with our timescales, but we do not need amendments to the bill to do this. I've said that this bill is a starting point and that we will continue to expand entitlement through secondary legislation where it is affordable. We've demonstrated our commitment to this approach by allocating consequential funding that was confirmed to us in December last year. Amendments 115A and 197 also seek to ensure that those 2-year-olds who would be eligible by virtue of free school lunches criteria, whom Neil Bibby wanted added in the face of the bill, are commenced separately or in or by August 2015. Amendments 172, 173, 174, 115A and 197 are all unnecessary, as we have made clear our commitment to commence children by virtue of free school lunch criteria through secondary legislation for implementation from August next year. These amendments overcomplicate the issue by introducing additional children and dates onto the face of the bill. There are clear advantages to defining children through secondary legislation, as we always wanted and always set out to do, especially through affirmative procedure agreed at stage 2, affording an appropriate level of parliamentary scrutiny and discussion, indeed more discussion than would be possible through an amendment at stage 2 or 3. The purpose of Amendments 103, 105 and 114 is to make sure that arrangements for stopping early learning and childcare in relation to starting school are the same for all children. Currently, children whose 5th birthdays are in September to December and so are not quite 5 in August when they are eligible to start school can be deferred for a year by their parents, so they are over 5 when they start school. However, they are not automatically entitled to an additional year of early learning and childcare. Children whose birthdays are in January and February and would only be around 4.5 if they started school the August before when first eligible can be deferred by their parents for a year, so they are over 5 when they start school, and they are also entitled to an additional year of early learning and childcare. These starting and stopping arrangements are all set out in secondary legislation, and this will be replaced by new secondary legislation enabled by the bill at section 43 2C2. The children who are defined on the face of the bill, 2-year-olds who are looked after under a kinship care order or have a parent-appointed guardian, have their start dates set out on the face of the bill. They are not, however, currently covered by secondary legislation enabled by the bill at 43 2C2 and therefore have no stopping dates. For all children born in September to December, regardless of whether they are specified on the face of the bill or through secondary legislation, whose parents or carers decide to defer entry to a school for a year until after they are 5, there is scope for an additional year of early learning and childcare at the discretion of the local authority. This would be based on the needs of the child and informed by appropriate professional assessment, which could include educational psychologists and early year staff or teachers. This is a technical amendment to enable the same end dates to be specified by secondary legislation made under the bill for those children specified on the face of the bill, along with all other children specified by secondary legislation under the bill. This will ensure consistent arrangements for all children and is important in determining their eligibility for an additional year of early learning childcare before starting school. Amendment 104 provides that children who have guardians appointed under Section 7 of the Children's Scotland Act 95, guardians appointed as such in a parent's will or similar, are also eligible for funded early learning and childcare provision from the age of 2. This is to bring them in line with children who have guardians appointed by the court under Section 11 of the 95 Act. Those children were deemed at Stage 2 to be subject to a kinship care order and therefore eligible for funded early learning and childcare from the age of 2. This amendment will ensure that those 2-year-old children who have a guardian, no matter how that guardian became appointed, will be eligible for funded early learning and childcare. Now, the purpose of Amendment 115 is to commence non-substantive provisions in Sections 43.2 through to 43.4 of the Bill, which defines the children eligible for early learning and childcare provision, and commences the power to make secondary legislation to describe further eligible children, including when their entitlement starts and stops. We have worked closely with our key delivery partners on our policy intentions as regards defining eligible children, and we have used the opportunity of consequential funding confirmed in December to announce further eligible children to be defined through secondary legislation. And I am pleased that my amendment recommended by the Delegate Powers and Law Reform Committee to make this order-making power subject to affirmative procedure was agreed, allowing greater parliamentary scrutiny. It is essential that we set out who these eligible preschool children are at the earliest opportunity to enable local authorities to plan and work towards implementation. I know that we share the same ambitions with local authorities and key stakeholders to contribute to Scotland's social and economic development, improve attainment, support parents to find or sustain employment, and first and foremost see our young children happy and benefiting from early learning and childcare. I am grateful to local authorities and all our delivery partners for the tremendous amount of work underway in planning and preparing for the delivery of early learning and childcare provisions, and I want to continue with the pace and engagement on those aspects of provision which are subject to secondary legislation. This bill signals the first step in our ambition to transform childcare and to do more for children in their earliest years. We have set out our ambitions in the White Paper to do even more and help families more ably balance work and life. Therefore, I ask the Parliament to support the amendments in my name and that we don't support the amendments in Liz Smith and Neil Bibby's amendments in this group.
Thank you. And I call Neil Bibby to speak to Amendment 172 and to other amendments in the group.
Thank you, Presiding Officer. I welcome the opportunity to speak to my amendments 172, 173, 174, 115A and 197, which are quite simple. They put the Scottish Government's recent commitments on early learning and childcare for 2-year-olds on the face of the bill and are supported by Children in Scotland, Save the Children and many other organisations. We all know the importance of providing quality childcare. It helps a child's learning and development, helps put money in the pockets of families, targeted at the poorest, it helps to reduce child poverty, and it's good for the economy generally. As members will know, Labour and other opposition parties have pushed for an extension in early learning and childcare for 2-year-olds, and we welcome that from next year another 15,000 vulnerable 2-year-olds will now get early years provision that weren't going to get it previously. That is not as many as we would have liked, but welcome all the same. But you'll forgive me for being a bit sceptical, Presiding Officer. I want to ensure that the Scottish Government can't go back on their word and cut it back at a later date. Why would they do that, you may ask? Well, let's not forget Fiona Hislop and the SNP government cutting back nursery for vulnerable 2-year-olds when they first came to power in 2007. So they do have form on this issue. That's why I want to see it on the face of the bill. The original childcare entitlements to 3% of 2-year-olds were on the face of the bill, so why not go further and put the additional 2-year-olds on it as well? I'm not sure why the government does not support its own policy in the bill and puts its recent stated childcare commitments on the face of the bill. If the Minister refuses, would she therefore confirm that, as it stands, other than looked after 2-year-olds, there will be no commitment to childcare on the face of the bill? So far, Labour and other... Yes, certainly.
Minister. From the very start that we would subsequently extend and expand childcare through secondary legislation. That has been made clear from the very start in this bill process.
Neil Bibby.
Well, as I said earlier, I'm concerned because this is from the government that cut back nursery provision for 2-year-olds when they first came to power. So far, Labour and other opposition parties have put forward dozens of amendments to this bill, and unfortunately, not one of them, I believe, has been supported by a single SNP member or the Scottish Government. I would therefore be quite surprised that the SNP Government are therefore not supporting their own childcare policy to be on the face of the bill which I am proposing today. Perhaps that shouldn't be surprising, as at Stage 2 the SNP members of the Education Committee also voted against their own childcare policy in the White Paper of 600 hours of early learning and childcare for half of Scotland's 2-year-olds. We said this bill was unambitious on childcare, and it still is, even in spite of the partial U-turn we saw last month from the SNP government. As of September this year, 40% of 2-year-olds in England will get nursery provision. Only 15% of 2-year-olds in Scotland will, and even when it goes up to 27%, the SNP government will still be lagging behind England. The SNP keeps saying they need independence for childcare, despite having done next to nothing over the past 7 years. Labour has supported, does support and will continue to support more childcare under devolution. The SNP could go further now on childcare, but have chosen not to this year and every other year they've been in power. This bill really is a missed opportunity. This is the childcare bill with next to no childcare commitments written in it. The least the SNP government could do is put their recent stated commitments on the face of the bill.
Thank you. I have several members who wish to speak. I call Christian Allard to be followed by Liam MacArthur.
Thank you, Presiding Officer. I would like to speak in support of the amendments put forward by the Minister for Children and Young People. I listened very carefully to the Minister, and this is a very welcome clarification of what children are entitled to. I wish it had been as clear and easy when I was a single working parent many years ago. On Friday, for example, the committee, Equal Opportunities Committee, I will go and visit Dad's Care, a father's group in Aberdeen, and I will welcome this clarification on this amendment and explain to them that we need this kind of amendments in this bill to make sure that it's as clear as possible. On this misamendment, I noted that the Minister said we will be using secondary legislation, same thing for Niels Baby amendment. I share the ambition of Niels Baby, but I disagree with his point. I think we are going in the right direction, and I think the Scottish Government and this Parliament has been at the forefront of childcare. If you take, for example, this morning, I was at a committee talking about Scotland's future. We only heard about currency. It's refreshing that this afternoon in this Parliament we are spending all afternoon and even the evening speaking about Scotland's future. Scotland's future in childcare. This Parliament, this Government will follow it. Is the reason I support the amendment of the Minister.
Thank you. Call Liam MacArthur to be followed by George Adam.
Thank you, Deputy Presiding Officer. For nearly 2 years, my esteemed colleague Willie Rennie has repeatedly and consistently made the case for a major expansion of free nursery and childcare provision for 2-year-olds in this country, starting with those from the poorest backgrounds. Initially, these calls were rejected by ministers who said this was not the government's priority. Then we were told that any such expansion would require the powers of independence. Finally, last month, we had a change of tack from the First Minister. Let's call it a Plan B, confirmed in the budget a fortnight ago, and again I put on record my welcome and that of my party for that move. While the 27% of 2-year-olds who stand to benefit from this extension in provision by the summer of next year falls short of the 40% covered south of the border this summer, it is nevertheless a major advance on what was originally proposed and could bring real benefits to some of the most disadvantaged 2-year-olds in our country. That will only be the case, however, if adequate capital funding is put in place. And the Minister has regularly questioned what is being delivered now in England and Wales, where adequate capital funding has been allocated. But given the events in the Finance Committee earlier today, she may be better advised to focus more attention on what it is that is being delivered in Scotland and how. Understandably, there is a desire and ambition amongst all of us to go further, reflected in the amendments in this grouping. Liz Smith's amendments seek to address an anomaly first highlighted by Reform Scotland in the way the additional early learning and childcare provisions in this bill would benefit some children but not others. At stage 2, similar amendments were rejected by the Government, though not, it must be said, on any point of principle. In the absence of any such principled objection, I would urge the Minister to think again, accept these changes and provide a more level playing field. Neil Bibby's amendments seek to go considerably further. Obviously, the Government has so far insisted that these are neither possible or in some cases desirable, but given recent dramatic changes in their policy over provision for 2-year-olds, it is perhaps all of us keeping the Minister's feet to the fire. Deputy Presiding Officer, we all accept that this bill is simply a step along the way to delivering our longer-term ambitions in relation to early learning and childcare. We all wish to go further although only some of us recognise that this doesn't require breaking up from the rest of the UK, but rather learning, if and where appropriate, from where they are actually doing things rather better. Thank you.
Thank you. George Adam.
Thank you, Presiding Officer. This is an aspirational and ambitious bill, and in particular the 600 hours provision of nursery care can make a difference in young people's lives. It offers the flexibility of the nursery provision for families and people to be able to actually work around, and it will affect initially 120,000 young people as well. One of the things as well in January, as the Minister has already mentioned, that the First Minister actually mentioned that we would extend it to 2-year-olds of workless households, and that's going to benefit another 8,800 children, 15% of all 2-year-olds. As the Minister quite rightly says, this is a starting point, it's a beginning, and for us to make that transformational change, to make that difference, we obviously have to have the powers of independence in order to gain the 1,140 hours that families need, because this will release and enable more people to get back to work, to help them, families, to actually make a difference in their own lives, and particularly for women within the family situation as well. Although I take on points, Christian Allard's points that he mentioned in his part as well. So that's part of the reason why I'm backing this, because it's ambitious, it's aspirational for the people of Scotland. But the other thing as well, the amendments, particularly from Mr Bibby, Amendment 115A, 172, 173, 174, 197, they have already been mentioned that they could be used for secondary legislation. So I would say at this stage, Mr Bibby's contribution would have more credibility if the Labour Party hadn't actually voted for the budget only a couple of weeks ago. When you look at that, that was included in this. So now to come here at this stage and actually to start talking about these type of things, you are completely lost and with nowhere to go. But that, Presiding Officer, that with the individual concerned is nothing unusual for me to understand that particular situation. But in closing, Presiding Officer, this is a very important part of this bill. It obviously is ambitious. It's building the foundation for the type of Scotland that we all want, and ensuring that Scotland can be the best place in the world for children to grow up in.
Thank you. And very briefly, Joan McAlpine.
Thanks very much, Presiding Officer. I will be very brief. I felt it would be wrong to let this part of the bill pass without talking about the quality of childcare, and particularly the quality of the training of childcare workers. And that's why I think that we should be very, very pleased that Professor Iram Siraj is leading a Scottish childcare review into the training of early learning teaching. And it means that the legislation that's passed today, not only is it very ambitious and will increase the amount of free childcare for 3- and 4-year-olds and vulnerable 2-year-olds, but also it will ensure that that care is of the very best quality, and I think that's something we should all be pleased about.
Thank you very much. Now I ask Liz Smith to wind up and indicate if you intend to press or withdraw.
Thank you, Deputy Presiding Officer. Can I just add the Conservatives' very strong support to the improvements in childcare. There is no doubt at all that there is very substantial evidence about the benefits of providing that childcare when it comes to the health and well-being, as well as the educational side of things. So we're very supportive of that, although I think it is deeply regrettable that it's always part of a referendum debate, because it's quite clear that the Scottish Government has these powers already. If they are really truly aspirational and wanting to have a transformational policy, then I hope they will agree to the amendments that would end the birthday discrimination when it comes to nursery provision. So, Deputy Presiding Officer, I will push Amendment 51.
Thank you very much. The question then is that Amendment 51 be agreed to. Are we all agreed? Parliament is not agreed. There will be a division. This will be a 1-minute division. Please vote now. The result of the vote on amendment number 51 in the name of Liz Smith is yes 52, no 65. There were no abstentions. The amendment is therefore not agreed to. I now call amendment 103 in the name of the Minister, and that has already been debated with amendment 51, and I ask the Minister to move formally.
Moved.
Thank you. The question then is that amendment 103 be agreed to. Are we all agreed? We are. I call amendment 172 in the name of Neil Bibby, already debated with amendment 51, and I ask Neil Bibby to move or not move.
Move.
The member has moved. Therefore, the question is that amendment 172 be agreed to. Are we all agreed? Parliament is not agreed. There will be a division. This will be a 30-second division. Please vote now. The result of the vote on amendment number 172 in the name of Neil Bibby is as follows. Yes 37, no 80. There were no abstentions, and the amendment is therefore not agreed to. I now call amendment 104 in the name of the Minister, which has already been debated with amendment 51, and I ask the Minister to move formally.
Moved.
The question then is that amendment 104 be agreed to. Are we all agreed? We are. I now call amendment 173 in the name of Neil Bibby, which has already been debated with amendment 51, and I ask Neil Bibby to move or not move.
Move.
The member has moved the amendment. The question therefore is that amendment 173 be agreed to. Are we all agreed? Parliament is not agreed. There will be a 30-second division. Please vote now. The result of the vote on amendment number 173 in the name of Neil Bibby is yes 36, no 79. There were no abstentions. The amendment is therefore not agreed to. And I now call amendment 105 in the name of the Minister, which has already been debated with amendment 51, and I ask the Minister to move formally.
Moved.
Thank you. The question is then that amendment 105 be agreed to. Are we all agreed? We are agreed. I now call amendment 174 in the name of Neil Bibby, which has already been debated with amendment 51, and I ask Neil Bibby to move or not to move.
Move.
The member has moved. Therefore, the question is that amendment 174 be agreed to. Are we all agreed? Parliament is not agreed. There will be a 30-second division. Please vote now. The result of the vote on amendment number 174 in the name of Neil Bibby is yes 37, no 78. There were no abstentions. The amendment is therefore not agreed. I now call amendment 52 in the name of Liz Smith, which has already been debated with amendment 51, and I ask Liz Smith to move or not to move.
Not moved.
Amendment is not moved. I therefore call amendment 53 in the name of Liz Smith, already debated with amendment 51, and I ask Liz Smith to move or not move.
Not moved.
Amendment has not been moved. That therefore brings us to Group 13, which is duty to provide a mandatory amount of out-of-school care, and I call amendment 175 in the name of Neil Bibby in a group on its own, and I ask Neil Bibby to move and speak to amendment 175, please.
Thank you, Presiding Officer. I've spoken already this afternoon about some areas of the bill that need strengthening, but Amendment 175, which I'm happy to speak to and move, seeks to address an area that was initially absent altogether from the face of the bill. Improving access, availability and affordability of out-of-school childcare is crucial in developing a model that supports children and helps parents. My Labour colleagues and I have consistently raised this issue in the Chamber and in the Education Committee. 175, I believe, is an important amendment because it seeks to address this by enabling ministers to specify a minimum amount of out-of-school care when resources allow, similar to the bill's current provision for preschool. We all know that councils are suffering significantly as a result of budget cuts. While they want to improve childcare, they need the funds to do that, and there is an increasing concern that out-of-school care and holiday care are vulnerable to those budget pressures. Currently, Scottish children are already at a disadvantage compared to English children when it comes to out-of-school care. There is an existing duty on local authorities in England to secure for working parents sufficient childcare for children up to the age of 14. There is therefore a strong case for putting the provision for childcare of school-aged children on a statutory footing in Scotland. There is no doubting the importance of childcare for the early years, but working parents working 9 till 5 or in some cases until 8 o'clock need help with care for school-aged children as well. This amendment has the support of a number of children's organisations, and it would allow this or future governments who may place a greater priority on out-of-school childcare than the current administration the opportunity to introduce a minimum amount of out-of-school care and increase its availability when resources allow. We have already seen a proposal from Ed Miliband and the UK Labour Party to introduce a primary school guarantee of childcare from 8 AM to 6 PM, and I would ask the SNP government to seriously consider what its policies and plans are in relation to childcare for primary school aged children. Finally, Presiding Officer, Claire Adamson's amendment at stage 2, I'm just closing, Claire Adamson's amendment at stage 2 was welcome in that it at least ensure the bill finally mentions out-of-school care, but what it doesn't do is provide anything particularly new, and I suspect that local authorities already plan and consult alongside parents. It does not change the fact that although the bill may at least now mention out-of-school care, it will do very little to improve it. That is why I would urge members to support Amendment 175 and ensure that the bill has sufficient ambition to allow us to improve out-of-school care for families across Scotland and ensure the bill is not regarded as a missed opportunity.
Thank you. Cara Hilton.
Thank you, Presiding Officer. I'd like to speak in support of Amendment 175 in the name of Neil Bibby on out-of-school care. We all welcome the commitment in the bill to finally deliver 600 hours early education and childcare. It's welcome news to mums, dads and carers across Scotland. But the reality is childcare issues don't end when your preschooler starts school. In fact, it's when your children start school that things become more complicated. I've got 3 young children myself. 2 of them are now at primary school. Thankfully, most schools in my constituency in Dunfermline have the benefit of an out-of-school club providing wraparound care during both term time and school holidays. Without this fantastic facility run by Fife Council, I can't imagine how I'd organise my childcare. But many parents simply don't have the option of wraparound childcare, and it's extremely disappointing that the Children and Young People's Bill doesn't address this crucial issue for parents of school-aged children. Because the reality is not every local authority sees out-of-school care as a priority. And order, please. Many schools don't have out-of-school provision at all, and even when they do, the hours are too restrictive or there are long waiting lists. For mums and dads, you may laugh, but for mums and dads across Scotland, the challenge of juggling working hours around the school day is like a full-time job in itself. It's a daily obstacle course for many parents, and for many it's just too full of hurdles. They've got no choice but to stay at home. It's not just about fitting working hours into the school day. Try fitting 12 weeks school holiday a year into an average 5 weeks annual leave entitlement. When some employers are going out of their way to offer more family-friendly hours and school-run contracts, there's simply not the jobs out there that allow parents to fit work around the school day, never mind around the school term. So it's absolutely vital that we remember childcare isn't just about babies and toddlers and preschoolers. It's about school children too. At UK level, as Neil mentioned, Ed Miliband has pledged to guarantee wraparound childcare for primary school children should Labour win next year. Here, the Scottish Government have promised parents a childcare revolution should Scotland vote yes, yet you're making no promises now to deliver a better deal for parents of school children, either now or after the referendum. Yes or no, we've got the power to lead the way. Give mums and dads the right to out-of-school childcare now. This amendment will ensure that mums and dads in Scotland are better able to combine work and family life. It will be a boost to our families, a boost to our economy and a boost to equality. It will make life less of a juggle for working parents.
Order in the chamber,
please. Support the amendment.
Briefly, Bruce Crawford.
To follow up on Cara Hilton's contribution to this debate today in terms of where we are, I just find it quite astonishing. We've just had that contribution and the way it's been delivered with such passion, I'll concede, just a week after the member votes to close Pitcorthy School in her own constituency, despite the fact that she campaigned for that all the way through the by-election in Dunfermline. It's absolute hypocrisy.
Minister. Order, please. Order. Ms Hilton, please resume your seat. Ms Hilton, please resume your seat. Minister.
Thank you, Presiding Officer. The Scottish Government has consistently indicated that the provisions in the bill are a first but significant step towards developing a system of childcare that meets the needs of all children.
Order in the chamber, please. We can't hear the Minister responding to this part of the debate. Minister.
This is a first step towards developing a system of childcare that meets the needs of all children, parents and families. Out-of-school care and holiday care is essential to the well-being of our children and support for families to work and provide economic security for their children. The resource implications of introducing statutory requirements for the provision of out-of-school care are hugely significant. The priority at this stage is to build additional hours and flexibility into our high-quality universal early learning and childcare provision, increasing the entitlement to around 16 hours a week and to focus initial expansion on our most vulnerable twos. However, I am aware that the need for high-quality childcare doesn't end when a child hits the age of primary school, and that is why the Government is also driving forward a range of measures to improve our out-of-school care. I announced that our early years task force would look to review our out-of-school care provision and recommend what more could be done. I supported amendments at stage 2 to broaden the requirement of local authorities to consult on their duties and power to deliver and support out-of-school care. This will contribute to those longer-term aims to develop comprehensive systems of early learning and childcare and out-of-school care. It will also enable local authorities to coordinate consultation and planning of all mandatory provision of early learning and childcare alongside non-mandatory provision which local authorities have the powers to deliver or support. This will inform delivery expansion or support for delivery of out-of-school care by local authorities. And we have also provided funding to and regularly engage with key organisations who can support or deliver out-of-school care, most particularly Scotland's Scottish Out-of-School Care Network and the Scottish Childminding Association. The range of actions I have outlined which the Scottish Government are driving forward now to increase and improve early learning and childcare, the steps which we are taking in relation to out-of-school care and the need to prioritise resources to make the biggest impacts. We are taking action now to make sure that we can do our best to support families. And regarding whether or not we need independence for our transformational aim of childcare, we have no access to the increased revenues that will be generated by enabling more parents to get back into work. We don't get that tax increase. If we were to emulate what they do in Sweden, that would generate £700 million worth of revenue that we could then reinvest back into childcare. We can't do that because we have one arm tied behind our back. That's why we need independence, and that's why our aspirations are set out in the White Paper.
Order. Mr McIntosh, a point of order. Could I have Mr McIntosh, could you move your microphone up? Perhaps we'll hear your point of order.
Thank you very much. Can I ask, Presiding Officer, if it is in order, after a member has made one of the most powerful, passionate and eloquent contributions to this debate,
Order till I hear this point of order, please. Order.
To have another member, particularly a former Minister for Parliamentary Business, make a rebuttal which has nothing to do with the amendment but is a personal and entirely inaccurate attack on that member.
Order. I chose to call Mr Crawford to make a contribution to that point in this debate. He made his contribution. I did not thereafter hear any point of order from Cara Hilton. I cannot call a member back to make any point in the chamber. I therefore ask Ms Hilton to resume her seat at that point. It's not a point of order, Mr McIntosh. It may well be a debating point, but you know it is not a point of order. I now call Neil Bibby to wind up this part of the debate and indicate if you intend to press or withdraw.
Thank you, Presiding Officer. As I said in my opening comments, out-of-school care is important to families. Clearly not that important to Bruce Crawford because he completely neglected to mention it in his contribution. We have consistently said that, and despite its obvious importance, childcare should not just be about the early years. It is regrettable that the White Paper says absolutely nothing about out-of-school childcare, and until very recently the bill said nothing either. This is a gaping hole and a glaring omission in the SNP's childcare policies. Labour gets that this is a real issue for families. Cara Hilton gets this is a real issue for working families. That's why Cara Hilton won the Dunfermline by-election by 3,000 votes back in October. That's why we continue to raise out-of-school care as an issue. That's why we want to do something about it, and that's why I'll be pressing this amendment.
Question is that Amendment 175 be agreed to. Are we all agreed?
Yes.
Parliament is not agreed. This will be a 1-minute division. Please vote now. The result of the vote on amendment number 175 in the name of Neil Bibby is yes 37, no 78. There was one abstention. The amendment is therefore not agreed to. I now call amendment 87 in the name of the Minister, already debated with amendment 77, and I ask the Minister to move formally.
Moved.
The question then is that amendment 87 be agreed to. Are we all agreed? Parliament is agreed. I call amendment 176 in the name of Liam MacArthur, already debated with amendment 77, and I ask Liam MacArthur to move or not to move.
Moved.
The amendment has been moved. The question then is that amendment 176 be agreed to. Are we all agreed? Parliament is not agreed. This is a 32nd division. Please vote now. The result of the vote on amendment number 176 in the name of Liam MacArthur is yes 53, no 63. There were no abstentions. The amendment is therefore not agreed to. I call amendment 88 in the name of the Minister, already debated with amendment 69, and I ask the Minister to move formally.
Moved.
The question then is that amendment 88 be agreed to. Are we all agreed? Parliament is agreed. That then brings us to Group 14, Sibling Contact, Duty on Local Authority in relation to looked after children. And I call Amendment 177 in the name of Jane Baxter in a group on its own, and I ask Jane Baxter to move and speak to Amendment 177, please.
Thank you, Deputy Presiding Officer. As the Minister knows, the issue of sibling contact is one which I raised at stage 2 of this bill. Unfortunately, too many looked after children are separated from their siblings when accommodated out with the parental home. If sibling contact is not prioritised with the local authority, then siblings can lose contact with each other entirely, leading to a loss in a crucial close family relationship. Section 17 of the 1995 Children's Scotland Act already places a duty on local authorities with regard to promoting contact between looked after children and those adults with parental responsibilities. This amendment would extend that to cover contact between looked after children and their separated siblings. Unfortunately, at the current time, if a local authority does not choose to prioritise such contact between looked after children and their siblings, then there is little or no way that this can be challenged by those looked after children. I am grateful to Clan Child Law, the Community Law Advice Network, which exists to provide specialist legal advice to children and young people, for drawing the submission to our existing provisions for some of the most vulnerable young people to my attention. I hope that the amendment before us today will be supported as we try to take on board the Minister's comments in relation to sibling contact and the duties on corporate parents by narrowing the focus of the amendment to just local authorities. I move Amendment 177 and look forward to hearing from the Minister.
Thank you very much, but I do have one request to speak. I want to ascertain that the member does wish to contribute to this part of the debate. Cara Hilton? No. Okay, in which case I call the Minister.
Thank you, Presiding Officer. With respect to Jane Baxter's Amendment 177, I'd really genuinely like to thank her for bringing this important issue to stage 3. And I recognise that promoting and facilitating sibling contact is a good idea in principle, but only where it's in the best interest of the children involved. We need to remember that in scenarios like where we're dealing with the interest of two children, the looked after child and the sibling, this raises two concerns about how this measure could work in practice. Firstly, the amendment seems to focus only on the assumed best interest of the looked after child, and we need to recognise that the sibling may have good reason for not wanting to maintain contact with the looked after child, and it seems wrong in principle to impose a duty to promote contact in circumstances where that contact may not be wanted. Further, where siblings are not resident together, there may be good reason for that, in particular on welfare grounds, and it would seem to contradict such professional decision-making to use the law to force a local authority to facilitate such contact when this might not be in the best interests of one or both children. Secondly, the amendment seems incomplete. For the amendment to work effectively, someone needs to be under an obligation to keep the local authority informed of any changes of address for the sibling, and this will require amending Section 18 of the 95 Act. Nevertheless, absolutely the intention behind this amendment is a laudable one. Looked after children should usually have the opportunity to maintain contact with their siblings, and I suggest that local authorities should be encouraged to facilitate that where the children concerned want it and where it is appropriate. And I'd be very happy to consider how we can further improve our guidance and good practice on what can be done to ensure appropriate and good quality contact between siblings in the interest of all the children that we have in question. Finally, it's important to note that there has been little consultation on this proposal, and many stakeholders would have a view on this, so it would be good to be able to embrace those views from those stakeholders, including the views that have been expressed consistently by Jane Baxter, to make sure that we can have good quality guidance to ensure that we can enable contact between siblings that is beneficial for both the looked after child and the sibling.
Thank you. Now call Jane Baxter to wind up and indicate if you wish to press or withdraw.
Thank you, Deputy Presiding Officer. I'm disappointed that the Minister has indicated she will not be supporting this amendment and will not be able to pass this today. However, I am grateful to her for taking the time to provide the reasoning behind this difficult decision. So I welcome her comments and I hope she will look into the matter further, and I'd urge her to meet with Clan Child Law and other experts in this area to look at ways that sibling contact between looked after children can be secured. So I will not be pressing Amendment 177.
Thank you. The member is not pressing. Does anyone object to the member withdrawing that amendment? No. In which case we move to Group 15, Aftercare and Continuing Care Minor Amendments. And I call Amendment 89 in the name of the Minister, which is grouped with Amendment 178. And I ask the Minister to move Amendment 89 and speak to both amendments in the group, please.
Thank you, Presiding Officer. I move Amendment 89 in my name. Amendment 89 is a minor technical amendment to repeal the opening words of Section 32, which are now redundant given the provision to repeal subsection 3 of Section 30 made at Section 63B of the Bill. Amendment 178 has been brought forward in response to a recommendation of the Delegated Powers and Law Reform Committee in the report on the Bill as amended at Stage 2. It seeks to amend new Section 26A of the Children's Scotland Act 95 as inserted by new Section 60A of the Bill, which relates to the duty of local authorities to provide continuing care. This section was added to the Bill at Stage 2 with the full support of the Education and Culture Committee. It seeks to amend new Section 26A to require ministers to consult with each local authority and such other persons as they consider appropriate before making an order under the various powers in that section. And we fully agree with the Delegated Powers and Law Reform Committee's comments after Stage 2 that the subject matter is of such importance that prior consultation with affected persons should be required before the powers in Section 26A are exercised. In this regard, ministers have already committed to setting up a working group consisting of sectoral representatives, service providers, young people, local authorities and other relevant stakeholders to develop the detail of the policy of continuing care and how the new duty will roll out over the coming years. However, in addition to this commitment, we are content to include an explicit requirement for ministers to consult local authorities and such other persons as they consider appropriate before they exercise the delegated powers. In addition to the planned working group to develop the proposals in detail, this consultation requirement will ensure that all those with an interest are formally consulted before any order is made. Therefore, we would ask you to support the amendments in this group. But more generally, Presiding Officer, in relation to the provisions within this bill for Scotland's looked after care leavers, we have created, with the support of Parliament, I hope, an approach that I believe will have long-lasting benefits to this group of young people that need our support. This bill is a product of young care leavers' courage and diligence in terms of articulating how this bill should deliver for them. And I'm proud that we have worked across the chamber to enable us to deliver that today in this bill.
Thank you, Kezia Dugdale.
Thank you very much, Presiding Officer. I said at Stage 1 of this bill that there had been 17 reports in the lifetime of this Parliament about the experiences of kids in care, and a care leaver called Ashley had told me that each and every one of them read like an apology note, an apology for the lack of action. We have made significant progress throughout the passage of this bill, and it is a vastly better bill for care leavers as a consequence. And I want to pay tribute to all the care leavers in particular who've actively been involved in the political process over the weeks and months that we've been through. I think for many of them we've lit a political fire which will see them ensure that no child will have the life experience that they did again in this Parliament. Can I make sure that we draw attention to Amendment 178? And the Minister's already done this around the duty to consult. I think this is absolutely critical if we are to build on the work she has done today with regards to kids in care, because ultimately the care leaver sector are looking for a right to return to care until the age of 25. If that's ever going to be realised in Scotland, if that's ever going to be a possibility, we have to do it in conjunction with local authorities, who are, of course, at the forefront of service delivery and the transition in and out of care. So can I thank her for that amendment, recognise that although we've made significant progress, there is a long way to go yet, and hope that she will commit to further action around kids who live in care across Scotland. Thank you.
Thank you. Liam MacArthur.
Thank you, Deputy Presiding Officer. I would simply echo Kezia Dugdale's comments. I think this bill at Stage 1 reflected a real advance in terms of aftercare for those going through the care system. But during the Stage 1 debate, I think across the chamber there was a feeling that more could and should be done. I think the evidence that the committee took from Who Cares Scotland, Aberlour, Bernardo's and, as Kezia Dugdale rightly identified, from those with direct experience of the care system, I think provided compelling evidence on the basis on which, thankfully, the Minister has been able to act at Stage 2. And I think at this stage it is an aspect of the bill about which this Parliament and indeed particularly the Education Committee, who's dedicated best part of 2 years to issues in this area, can feel most justifiably proud.
Many thanks, and I now ask the Minister to wind up.
Thank you, Presiding Officer. Yeah, and I appreciate the comments that both Kezia Dugdale and Liam MacArthur have made, and I do think we have a bill that we can be proud of in terms of what it delivers for our looked after young care leavers. Others have described it, not necessarily from government. I think it was Who Cares that described this provision within the bill as potentially making Scotland world leading in terms of how we look after our young looked after care leavers. And there will be a working group to ensure that we can get the extension of
provisions of support for young looked-after care leavers. That working group will include young looked-after children themselves. And I particularly want to echo what Kezia has said in terms of the role that looked-after care leavers have played in terms of developing this provision within the bill. They have left a lasting legacy for future generations of looked-after children, and they should feel very proud about what they've managed to achieve within this bill. These are absolutely our bairns, and we need to do what we can for this group of young children and young care leavers, and we are very proud that we're able to help them and future generations to have better outcomes in life.
Thank you. And can I remind all members to use full names, please? The question is that Amendment 89 be agreed to. Are we all agreed? We are agreed. I now call Amendment 178 in the name of the Minister, which has already been debated with Amendment 89, and I ask the Minister to move formally.
Moved.
Thank you. The question is that Amendment 178 be agreed to. Are we all agreed? Parliament is agreed. That then brings us to the next group, which is Group 16, Kinship Care Assistance, Eligibility and Assistance to be Provided. I call Amendment 180 in the name of Jane Baxter, which is grouped with other amendments as shown in the groupings, and I ask Jane Baxter to move Amendments 180 and 180A and speak to all amendments in the group, please.
Thank you, Deputy Presiding Officer. There is no doubt that the landscape for kinship care in Scotland has changed significantly since 2007. We have seen legislation introduced to provide support for kinship care families, but it is clear that we need to do more. In speaking to the amendments laid out in the group before us, it is probably helpful to highlight that these follow three main strands. The intention behind Amendments 180 and 206 is to end the postcode lottery of funding which faces kinship carers across the country. There can be no justification for the extent and degree of variance in kinship care allowances paid by local authorities across Scotland. As anyone who went out this lunchtime to speak with kinship carers will know, the current funding available to people to support them in their vital role of supporting, caring and nurturing many of our children and young people is a hugely complicated, confusing and variable system. And in mentioning the lunchtime event, I'd like to put on record my thanks to the Scottish Kinship Care Alliance and Children First for the huge amount of work which they have put in throughout the passage of this bill to try to improve the situation for kinship carers in Scotland. Amendments 180B and 202 through to 205 seek to extend the availability of financial support for kinship carers to those who are still caring for a young person over the age of 16 but not yet reached 18. The other amendments in this group seek to change the eligibility criteria as defined in 64 subsection 4, as we are concerned that this presents a too restrictive definition of the eligibility of the children who end up being looked after by kinship carers. And finally, Amendment 206 seeks to address those who continue to care for looked after children. Yes, the Minister has powers to set the levels of kinship care allowances for these carers, but currently does not choose to do so. This amendment would seek to end that postcode lottery of funding and ensure there is a minimum rate of financial support for formal kinship carers, no matter where they live. The costs of supporting children in foster care, residential care, formal and informal kinship care vary enormously. Kinship carers often see themselves as a poor relation in the funding and support available to them in their crucial role in caring for children in our society. In debating these amendments today, it is worth noting that it is extremely disappointing that the Scottish Government's financial review of kinship care has not been published in time for this bill. It promised to bring before the Parliament during the passage of this bill the outcome of its financial review of kinship care. It has failed to do so. I sincerely hope that when it is published and the regulations are being drawn up by the Minister, that there is significant and careful consultation with kinship carers and organisations with an interest in this area. I look forward to hearing a response from the Minister to these amendments and will welcome any commitments she can give to supporting kinship carers in the future. I move Amendments 180 and 180A.
Thank you. Call Bob Doris to be followed by Liz Smith.
Presiding Officer, I see outstanding work that kinship carers do across Glasgow on a long-term and enduring basis consistently in the region I represent. I've always sought to work across parties to advance their rights and entitlement. Indeed, I acknowledge that Glasgow City Council, who previously paid no kinship care allowance, began to do so following constructive representations from myself. However, it can be a postcode lottery across Scotland, and I believe that is wrong. Amendment 206 and associated amendments seeks to address this problem in relation to looked after children. However, given that there is an independent financial review, as previously mentioned, which is intending to build inconsistency and fairness into the system, I'm unsure as to why, at this time, this amendment should be put on the face of the bill. I also hope the Minister can give us an update in relation to that financial review, and I very much hope it will specify minimum rates and also be age-related. I also want to comment on Amendment 180 and other related amendments there, which seeks to specify minimum payments for those in a kinship care order. I'll seek to make 3 possible brief points, if I can. Firstly, kinship care orders are progress, as some local authorities offer no support at all when a child loses looked after status. This changes that. This gives these children a statutory footing for the first time within the system. Secondly, young people in kinship care orders will have varying levels of need, some more informal than others. Some have moved from the looked after process onto a kinship care order, and therefore I remain unconvinced that, as a rule, there should be exactly the same levels of support and a national rate. However, whilst I can't accept 180 today, I should, in my third point, ask the Scottish Government to ensure there are no unintended consequences from kinship care orders, in particular in relation to those that are currently getting payments around Section 11 orders or guardianship under Section 7 of the 1995 Act. And perhaps that's one for another day for the Minister to examine that matter. In summing up, Presiding Officer, in my experience in working with the Minister on this matter, none of this has been intended to cut any support for kinship carers. That impression that has been given has been completely and fundamentally wrong. This improves the support of kinship carers, puts it on a further statutory footing. And I would just like to say one final thing. In the future, and this Parliament can't do it just now, I think kinship care payments should be a benefit integrated with a wider social security and benefit system. But today, this Parliament doesn't have that power. I hope after September that fundamentally changes.
Liz Smith.
Could I just add the very strong support of the Scottish Conservatives to many of the amendments that have been lodged by Jane Baxter. I think there are several issues about kinship care where in previous times we have let them down by not providing the care and support that they require. Just to take up the point which I think was made very sensibly by Bob Doris, I think there is a need to get rid of the postcode lottery, particularly when it comes to a minimum rate of support. I entirely accept that you don't want to pay everybody absolutely the same, because I think that raises issues about just the effectiveness of that. So, broadly speaking, we will support Jane Baxter's amendment, but not in the section which I think has the question about the eligibility definition, where I think there might be some unintended consequences of that. Thank you.
Many thanks, Minister.
Thank you. Amendment 180, as further amended by Amendment 180B, seeks to provide that kinship care assistance is the provision of financial assistance at a minimum rate and additional assistance of such description as ministers specify by order. This assistance would be payable to those applying for or who have a kinship care order and to guardians appointed under Section 7 of the Children's Scotland Act 95 in relation to children who have not yet attained the age of 16, as well as those who have attained the age of 16 but are not the age of 18. It also introduces an order-making power which would require ministers to specify the minimum rate of financial support payable and which would require the date to be the same across all authorities in Scotland. Such an order could also allow for the rates rise depending on the age of the child. We think that Amendment 206 is seeking to achieve a similar effect to Amendment 180, which is to amend the Adoption and Children's Scotland Act 2007 to require the Scottish ministers to make regulations specifying a minimum rate of financial support to be provided across all local authorities in relation to looked after children in formal kinship care arrangements placed by authorities with qualifying persons as defined in Part 10 of the Bill. We accept that there is concern among stakeholders that there is currently a wide variation of allowances paid to formal kinship carers across the 32 local authorities. As a result of this, some feel that a similar situation may arise for families with a kinship care order or for those seeking to obtain one. And we are sympathetic to their concerns and agree that there is merit in providing a financial assistance to holders of a kinship care order where it is required. And the bill already provides for this. Kinship care assistance will cover a wide range of types of support, reflecting the fact that financial assistance is not the only type of assistance that kinship carers and the children they care for need. Section 66, subsections 1b and 3a provide ministers with an order-making power to allow provisions to be made about the payment of financial support
and when or how much such assistance is to be provided. We therefore don't consider that any additional powers are required over and above the current bill provisions.
Dugdale.
I recognise that this area is very, very complicated, and given that, I think it was important that the Minister promised that a financial review of kinship care would be published during the passage of the bill. That hasn't happened. Can you explain why you haven't kept your own promise and published that during this process?
The reason we have the financial review is because we absolutely understand and have sympathy with the concerns that have been expressed to us around the 32 different varieties of kinship care financial assistance packages that kinship carers get, and that's why we have the review. And it is a complex and very time-consuming piece of work, and its complexity is added to by the interaction with benefits. And we are currently reviewing the support available to both formal and informal kinship carers with a view to reducing those inconsistencies and improving fairness across Scotland, and will ensure Parliament is made aware of its publication.
Sorry, Presiding Officer, I really don't mean to labour the point, but you did promise that we would have this information as we considered these issues, and you've not kept that promise. But I think we deserve an explanation as to why that's not the case.
Minister.
I've explained that we intend to publish the kinship care review, the financial review, because we're absolutely determined to make sure that the inconsistencies expressed by kinship carers is not felt, and we can properly and adequately deal with it. And I've explained the complexities of that, and that we would want to make sure that we get this absolutely right. And I think it's in the best interest of kinship carers that we get this absolutely right indeed. Now, going on to amendments 180A, 180B, 181, 82, 83, 84, 85, 86, 87 and 90, they all seek to ensure that kinship care assistance should be provided to qualifying persons in relation to all children, and not just those who are eligible in terms of the test currently provided for in section 64(4). However, the circumstances of those children who are looked after by kinship carers and guardians will vary widely, and we believe that kinship care assistance should only be targeted at and available for those children in informal kinship care arrangements who are at risk of becoming looked after if kinship care assistance is not provided by the local authority. The remaining amendments seek to extend the requirement on local authorities to provide kinship care assistance to qualifying persons in relation to children who have attained the age of 16 but not the age of 18. Kinship care orders subsist only until the child reaches the age of 16, and at that point it is possible that the child who was formerly the subject of a kinship care order may leave the carer's home and their care. Given this, and given the fact that a child who was subject to a kinship care order or who has a guardian is still eligible to receive assistance themselves until they are 18, we don't consider it appropriate or necessary to extend the entitlements in this way. Now, we will continue to work with all those advocating on behalf of kinship carers as implementation progresses, and we're grateful to all those who have had an input into the bill, the Alliance, Children First, CAS and Mentor, and many more who have articulated very strongly the need for us to make sure that we get support for kinship carers absolutely right. And indeed, the Cabinet Secretary met today with the Kinship Care Alliance. We have consistently valued the work the kinship carers do, which is why the kinship care order provides additional assistance to kinship carers who may never have received such support before. It improves supports for them, and I hope that commitment can give comfort to Bob Doris and the points that he makes and has made eloquently and has consistently made through the course of not just this Parliament but the last one.
Thank you very much. I now ask Jane Baxter to wind up and indicate if you intend to press or withdraw 180A.
Thank you. I'm disappointed that the Minister will not support the amendments before us in Group 16. As the Minister will be aware, there is considerable concern among many kinship carers about the changes being brought forward in this section of the bill. Should my amendments not pass this afternoon, I repeat again my hopes that there will be a thorough engagement with kinship carers and their representative organisations when the regulations are drawn up by the Scottish Government. I'm also keen to see the outcome of the financial review of kinship care with interest, and again put on record my disappointment that this has not been published in time for this final stage of the bill. I press Amendment 180A.
Many thanks. The question then is that Amendment 180A be agreed to. Are we all agreed? Parliament is not agreed. There will be a division. This is a 1-minute division. Please vote now. The result of the vote on amendment number 180A in the name of Jane Baxter is yes 41, no 78. There were no abstentions. The amendment is therefore not agreed to. I now call amendment 180B in the name of Jane Baxter, which has already been debated with amendment 180, and I ask Jane Baxter to move or not move.
Move.
The member has moved the amendment. The question then is that amendment 180B be agreed to. Are we all agreed? No. Parliament is not agreed. There will be a division. This will be a 30-second division. Please vote now. The result of the vote on amendment number 180B in the name of Jane Baxter is yes 56, no 63. There were no abstentions. The amendment is therefore not agreed to. Can I now ask Jane Baxter to press or withdraw amendment 180?
Press.
The member has pressed the amendment. Therefore, the question is that amendment 180 be agreed to. Are we all agreed? Parliament is not agreed. This will be a 30-second division. Please vote now. The result of the vote on amendment number 180 in the name of Jane Baxter is yes 56, no 63. There were no abstentions and the amendment is therefore not agreed to. I now call amendment 181 in the name of Jane Baxter, already debated with amendment 180, and ask Jane Baxter to move or not move.
Move.
The member has moved. The question therefore is that amendment 181 be agreed to. Are we all agreed? Parliament is not agreed. There will be a 30-second division. Please vote now. The result of the vote on amendment number 181 in the name of Jane Baxter is yes 41, no 78. There were no abstentions. The amendment is therefore not agreed. I now call amendment 202 in the name of Jane Baxter, which has already been debated with amendment 180, and I ask Jane Baxter to move or not move.
Move.
The member has moved that amendment, and I also now call amendment 202A in the name of Jane Baxter, already debated with amendment 180, and ask Jane Baxter to move or not move.
Move.
That is not moved. The question therefore is that amendment 202 be agreed to. Are we all agreed? No. Parliament is not agreed. This is a 30-second division. Please vote now. The result of the vote on amendment number 202 in the name of Jane Baxter is yes 46, no 72. There were no abstentions. The amendment is therefore not agreed to. I now call amendment 182 in the name of Jane Baxter, which has already been debated with amendment 180, and I ask Jane Baxter to move or not to move.
Not move.
That member has not moved. I therefore call amendment 183 in the name of Jane Baxter, already debated with amendment 180, and I ask Jane Baxter to move or not move.
Not move.
Not moved. I now call amendment 203 in the name of Jane Baxter, already debated with amendment 180, and I ask Jane Baxter to move or not move.
Move.
The member has moved that amendment. I also call amendment 203A in the name of Jane Baxter, already debated with amendment 180, and I ask Jane Baxter to move or not move.
Not move.
It's not moved. Therefore, the question is that amendment 203 be agreed to. Are we all agreed? Parliament is not agreed. This is a 32nd division. Please vote now. The result of the vote on amendment number 203 in the name of Jane Baxter is yes 46, no 73. There were no abstentions. The amendment is therefore not agreed to. I call amendment 184 in the name of Jane Baxter, already debated with amendment 180, and I ask Jane Baxter to move or not move.
Not move.
Not moved. I therefore call amendment 185 in the name of Jane Baxter, already debated with amendment 180. Jane Baxter, move or not move.
Not move.
Not moved. Call amendment 204 in the name of Jane Baxter, already debated with amendment 180. Jane Baxter to move or not move?
Not move.
Not moved. In that case, I now call amendment 186 in the name of Jane Baxter, already debated with amendment 180. Move or not move?
Not move.
Not moved. I now call amendment 205 in the name of Jane Baxter, already debated with amendment 180, and I ask Jane Baxter to move or not move.
Not move.
Not moved. Therefore, I now call amendment 187 in the name of Jane Baxter, already debated with amendment 180. Jane Baxter to move or not move.
Not move.
Not moved. I now call amendment 188 in the name of Jane Baxter, already debated with amendment 180. Move or not move.
Move.
Not moved. I now call amendment 189, already debated with amendment 180. Jane Baxter, move or not move?
Not move.
Not moved. That brings us to amendment 190 in the name of Jane Baxter. To move or not move?
Not move.
Not moved. And I now call amendment 206 in the name of Jane Baxter, already debated with amendment 180. Jane Baxter, to move or not move?
Move.
That amendment has been moved. The question therefore is that amendment 206 be agreed to. Are we all agreed? Parliament is not agreed. This is a 32nd division. Please vote now. The result of the vote on amendment number 206 in the name of Jane Baxter is yes 46, no 73. There were no abstentions. The amendment is therefore not agreed to. And that then brings us to Group 17, school closures. And I call amendment 191 in the name of Liam MacArthur, grouped with amendments 106 to 111. And I ask Liam MacArthur to move amendment 191 and to speak to all amendments in the group, please.
Thank you, Deputy Presiding Officer. And as I've done previously when we debated this issue, I start by declaring an interest as the father of a son at a primary school identified for closure in the recent past. That experience graphically brought home to me the impact even the threat of a school closure can have on pupils, staff, parents and indeed the wider community. It can, of course, bring communities closer together, but it's not a strategy I would recommend. Can I also acknowledge the evidence we received from a wide variety of sources, not least the redoubtable Sandy Longmuir and, of course, the Sutherland Commission, all of which I think has helped in identifying areas where current legislation, policy and practice can and need to be improved. Some of those improvements were introduced at stage 2, but the amendments in this grouping, all of which I support, make further important changes that will, I believe, prove beneficial and address some of the key outstanding concerns. Can I also acknowledge the approach taken by the Education Secretary in relation to this part of the bill and observe that it is the only section where opposition amendments have not just been accepted by the Government but actually actively sought. My Amendment 191 addresses long-standing concerns that Section 5 of the 2010 Act is ineffective in requiring an education authority to act to correct inaccuracies or omissions that are discovered in its proposal paper for a school closure. The amendment requires an education authority to be more transparent in its consideration of allegations that there is an inaccuracy or omission, and if there is, it requires the authority to take action where this relates to a material consideration relevant to the decision. If nothing else, this should help remove the perception that authorities can dismiss legitimate concerns and makes it clearer that all allegations of inaccuracy or omission must be investigated and reported upon. I would hope, as a result, the confidence communities have in the process might be more readily safeguarded. If communities continue to be dissatisfied with the authority's response under Section 5, they can make further representations to the authority, and these representations must be included in the consultation report prepared by that authority. My amendment, therefore, means the whole process is more transparent in terms of how an authority deals with allegations of omissions and inaccuracies, and will make it easier for those raising allegations, if not ultimately corrected by the authority, to raise their concerns with ministers in seeking to have a proposal called in for consideration by a school closure review panel. I still do have some reservations about how this call-in process and referral to the panel might operate, but recognise that the battle over that was perhaps fought and lost at stage 2. As I say, I don't think any of us would pretend that these and earlier changes will remove the controversy or anxiety created by the threat of a rural school closure. However, by improving the process, making it more transparent and balanced, while also providing appropriate support at key stages, I think we should be confident that we can keep that upheaval to a minimum and also limit the number of cases that are ultimately required to be called in for review. And I think that would certainly seem to be a measure of success, and I'm happy to move the Amendment 191 in my name. Thank you.
Thank you very much. I now call the Cabinet Secretary to speak to Amendment 106 and other amendments in the group, please.
Thank you, Deputy Presiding Officer. Like Liam MacArthur, I have a long-standing involvement in this issue. It has not been without its difficulty and sometimes not without its controversy. But I have a very strong view that the health of rural communities is, to a greater or less extent, closely attached to the health of the services that are provided, and one of the core services is a rural school. And those of us who know rural Scotland well and who represent rural constituencies know the great importance that these rural schools have and the many benefits that they bring to pupils. I am not arguing, I have never argued, and this chamber would never argue, that rural schools do not sometimes have to close. Often rural schools close themselves in terms of population changes. But if there is to be community confidence in the process of school closure, then it has to be transparent, it has to be open, and it has to provide a level playing field for all the partners involved. Now, the 2010 Act, which was passed unanimously by this chamber, was a big step forward, but it has not operated quite how this Parliament intended. The establishment of the Rural Schools Commission, and I pay tribute to COSLA for the partnership that resulted in that Rural Schools Commission, did sterling work, and all the members worked very hard to look at this issue in the round, and I pay tribute to them and to Sheriff David Sutherland, who chaired the Rural Schools Commission. And I think it is a tribute to their work that 36 out of the 37 recommendations were accepted by the Scottish Government and are being implemented by the Scottish Government. That is a pretty good average in any commission. In fact, it's quite a remarkably good average. So I want to say at the outset today that this has been a contentious area which we may be moving towards completing the Parliament's role after a difficult period, and I hope it will be treated in that way and supported across the Chamber. As well as the Government Amendments 106, 107, 109, 110 and 111, I welcome, as Liam MacArthur said, and actively support amendments at 191 and 108 from Liam MacArthur and Liz Smith. I think it is important we can join together and finish the job the Parliament started unanimously under the Schools Consultation Scotland Act 2010. The Government Amendments, Presiding Officer, 106 and 107 are minor drafting changes to the amendments made to the 2010 Act at Stage 2. Amendments 109 and 110 address a similar issue to that of Liz Smith's amendment in this group, Amendment 108. All three amendments seek to improve the transparency of local authorities' decision-making. First, Amendment 109 requires an authority, when explaining its proposal paper why it considers, in the light of the assessments it is to carry out, that implementation of the proposal to close a rural school would be the most appropriate response to the reasons for the proposal. It has to give the reasons why this is the case, that is, transparency. This will help to ensure that parents and communities can better understand why the authority considers closure is the most appropriate way to proceed. Second, Amendment 110 imposes an additional requirement on authorities to explain in consultation reports on rural school closure proposals why it considers implementation of the proposal would be the most appropriate response to the reasons for the proposal. The authority must also set out its reasons in the consultation report. This will ensure that councillors have a clear understanding of the recommendation they are receiving and the reasons for that recommendation. I welcome Amendment 108 in Liz Smith's name. It addresses the third and critical point, at which it is right to require an authority to set out its reasons for proceeding with a school closure. Section 11A of the Schools Consultation Act 2010, which the Government brought forward at Stage 2, sets out the clear test which we expect authorities to meet before they can decide to implement a closure proposal in relation to a rural school. It will ensure that authorities will not be able to proceed with a closure proposal unless they have complied with the additional statutory requirements imposed on them, and that there is no more appropriate means of addressing whatever problem a rural school is experiencing. Section 11A will be further strengthened by Amendment 108, which requires an authority to publish the reasons why it is satisfied that closure is the most appropriate response to the problems the school has been facing. Amendment 111 requires that this information must be supplied to the Scottish Ministers and requires the authority to publish on its website the fact that it has notified ministers of the decision and also the opportunity for consultees to make representations to ministers in relation to the decision. That will ensure that the reasons given in the authority's notice are made public, which is clearly desirable, published within 6 days of the decision being taken, and able to be taken into account by those making representation to ministers and by ministers themselves in considering whether to call in the decision. These requirements will help to increase the overall transparency of the whole decision-making process, which can only serve to increase the confidence of the communities affected in the decisions reached. This transparency and clarity is already successfully delivered by many authorities. That's to be welcomed. I commend them for it. However, we have found, unfortunately, that since 2010, consultation has not always reached the high standards communities deserve, and that's why these provisions are necessary. No one should be asked to support a decision, least of all one which affects the education of their children, on the basis of poor, incomplete, or in some cases plain wrong information. That's why I support Amendment 191 in Liam MacArthur's name, which will require an authority to correct an inaccuracy or omission that it has confirmed when it relates to a material consideration relating to the proposal. And all allegations of inaccuracy and omission must be determined by the authority with reasons given to the person who raised the issue if it is proposed that no action is going to be taken in relation to the allegations. The person who raised the issue is then entitled to make further representations to the authority, and the authority may then make a new determination on the matter. Finally, the authority is required to include information on all allegations or inaccuracies and what action is taken in relation to those allegations in the authority's consultation report. School consultations, we all know, are highly charged. It's essential that a fair debate is promoted based on reliable information. Errors do occur for a variety of reasons, and Amendment 191 provides a clear process to address and resolve these in as transparent a way as possible. That has to be welcome. Presiding Officer, Scotland's schools and the school estate are not set in stone, And the policy that no school should ever close is divorced from reality. Schools in both urban and rural communities must change and develop to respond to the needs of the 21st century, to provide our young people with the best opportunities. A great deal of that change is, of course, very much for the better. For example, with the delivery of impressive buildings, with the bringing together of communities around sustainable, high-achieving schools. But it does no one any good to rush into these decisions on false premise. We need to start with the problem in order to find the solution, rather than the other way round. Therefore, communities need and deserve authorities to be subject to robust, comprehensive processes to ensure that proposals can pass scrutiny. Only in this way will we ensure that higher standards in decision-making are reached and maintained. So, in summary, I ask the Chamber to support Amendments 191, 106, 107, 108, 109, 110 and 111. Thank you.
Thank you. I call on Liz Smith to speak to Amendment 108 and other amendments in the group.
Deputy Presiding Officer, could I begin by thanking the Cabinet Secretary for what has been a very constructive and helpful approach when formulating the amendments relating to rural school closures, something for which I believe it is essential that we secure cross-party support. And could I also acknowledge the unstinting efforts of Sandy Longmuir, who has campaigned passionately on behalf of the Rural Schools Network to change the 2010 Act for the better. His diligence and advice have been very much appreciated. Over the years, we have seen far too many instances when there has been a failure to provide the necessary information, which is an essential part of making a judgment about whether or not a school should close. And as the Cabinet Secretary has very rightly said, no parent should be put in that position. In some cases, there has been a failure to provide complete information. In others, it has been a failure to provide fully accurate information. And in other cases, there have been allegations of deliberate attempts to mislead interested parties or relevant committees. None of these is acceptable, and so it is essential that we do everything possible to ensure that this cannot happen again. Amendment 108 strengthens the duties placed on local authorities so that they must publish on their website both the notice of their decision and the reasons why the Council is satisfied that such action is the most appropriate way forward. They will no longer be able to say that they are simply satisfied. This goes significantly beyond the initial proposals and will introduce much tighter language designed to furnish communities with a fuller knowledge of the decision-making process and, crucially, the logic behind it. Given the sensitivities at play, it is absolutely paramount that stringent checks are in place so as to ensure that all relevant information is disclosed and it is presented in a clear, neutral manner. A school closure can often be fraught and be a very controversial process, so it is very important that high standards of transparency are adhered to throughout. Amendment 108 will strengthen the duties on local authorities to secure just that, and it will give parents, pupils and staff much greater confidence in the process through which a decision is reached. So I hope the Chamber will support Amendment 108, and we also hope that it will support all the other amendments in this group.
Thanks so much. I call on Neil Bibby.
Thank you, Presiding Officer. The amendments today on this issue appear to be minimal and do not fundamentally add or detract from the current proposals. They appear to improve the process that must be followed when considering a school closure and improve the transparency of the decision and make it more accessible to parents, which are positive steps. I agree with the Cabinet Secretary that proposals should have all the complete information. Perhaps he could have ensured the financial memorandum also had all the complete information. Members will be aware that I raised concerns, or maybe aware that I raised concerns at stage 2 on Mike Russell's proposals on this issue. There are still a number of points of concern, particularly on the new unelected Quango that will decide on rural school closures, who the members will be accountable and responsible to, who will pay them, how much will this new Quango cost. It is also regrettable, but unfortunately far too typical, that the Scottish Government ignored the views of local government in COSLA on Recommendation 20. I recognise on such issues we should try to get cross-party support, but surely it is important to have agreement between Scottish and local government who are responsible for the running of primary and secondary education. Don't just take my word for it, take the word of Councillor Douglas Chapman, COSLA Education spokesperson, who said, by not implementing Recommendation 20, the Government has altered the balance brought forward in by the Commission, and we are now concerned that it will actually be far harder for local authorities to take the necessary decisions on the school estate. He also said he had written to the Cabinet Secretary to express concerns that this is the impact that amended legislation could have on improving educational outcomes. And because of this, local government's job will be made all the harder. I'll take that.
Mark MacDonald.
But surely the member must accept, if he looks at, for example, the case in my constituency of Bramblebrae and Middleton Park Primaries, where the educational benefit statements and the response to them by Education Scotland proved that that process was in a complete guddle, shows that the benefit of needing to measure against educational benefit to avoid schools being closed for purely spurious reasons.
Neil Bowett. I'm not aware of the case that Mr MacDonald raises. I think this needs to be done by consensus with local authorities. But the key issue, and I'm sure, hopefully Mr MacDonald would agree on this, the key issue is, however, that nobody wants to close schools, rural or urban. Of course they don't. But if Mike Russell and other SNP members want to keep schools open, not just in his own constituency, but in the other 72 constituencies across Scotland he is responsible for as Education Secretary, then he needs to ensure our education system and local authorities are properly resourced. Rather than doing this, he has chosen to change the law rather than change council budgets. The only new budget created is a limitless one for a new unelected Quango, and for him to abdicate responsibility from making difficult decisions on school closures.
Thank you. Fiona MacLeod.
Thank you, Presiding Officer. Some members may be surprised that I rise as the MSP for Sir Kelvin and Bearsden to talk about rural schools, but I do actually have 3 rural schools in my constituency. But also I think this debate is very important about the standards that we are going to apply for rural school closures we can learn for our urban school closures. The Cabinet Secretary used words like clarity and transparency in the process in the future, and I know that that will be welcomed by campaigners. I do wonder if it will be welcomed by local authorities from my personal experience in my constituency. The Cabinet Secretary talked about having high standards for making decisions, and higher standards in decision making. But he also talked about there must be no false premise when decisions are made about the closure of schools. And Liz Smith talked about sometimes there being perhaps deliberate attempts to mislead. I'm not making these charges against East Dunbartonshire Council in the current divisive campaign that we're going through in closing and merging local primary schools, but I know that the campaigners locally have had to dig deep. They've had to spend long hours forensically going through documents from this council. They've had to use freedom of information requests to try to get behind what this council called facts to find out whether this was really the case or not. This has resulted in a ministerial call-in, and the local people await the decision on that with bated breath. But the local council doesn't wait that decision with bated breath, because just last week East Dunbartonshire Council at their budget meeting preempted the decisions of the ministerial call-in and changed the parameters upon how they were going to make their decisions on closing and merging schools. So I close my remarks by saying I absolutely welcome Liam MacArthur's amendments and all the other amendments in this area, and I hope that it means that no other local school campaigners have to go through what the local school campaigners have had to go through in my constituency. Thank you.
Thanks so much. Now I call on Liam MacArthur to wind up and press to withdraw his amendment.
Thank you, Deputy Presiding Officer. Can I thank Fiona MacLeod, Liz Smith, Neil Bibby and the Education Secretary for their comments in relation to these amendments. I think the Cabinet Secretary was absolutely right in setting the scene in relation to the importance that rural schools play within their wider community. I know that the argument will be made in much the same way by those in urban communities, but I think that as the member for Mortney, you would not expect me to do anything other than acknowledge the specific status that schools in rural communities do play. I think the 2010 Act, as the Cabinet Secretary alluded to, was unanimously supported, but I think it was also quickly evident that the way in which this was being applied was either inconsistent or was giving rise to concerns that it had unintended consequences or local authorities were applying it inappropriately. And I think Liz Smith made some excellent points in that regard. I mean, the responsibility for this has to lie with local authorities. They are best placed to act in the interests of the local communities they represent, and I don't believe that any council does or should enter the process of consulting on a school closure lightly. Nevertheless, I think there is sufficient evidence that there are inadequacies in the way that the current legislation is being interpreted. While I think we all acknowledge this is not about saying that no rural school should ever or will ever close, but it should certainly not close on what Fiona MacLeod referred to as a false premise or on the basis of inaccurate or incomplete information. What we have as a result of the amendments passed at stage 2 and with the group of amendments here we are considering is an opportunity to make the process more transparent, better balanced, subject to proper, effective and well-informed consultation. And while I do share some of Neil Bibby's concerns about the review panel, as I say, that battle I think was fought and lost at stage 2. Nevertheless, the amendments at stage 2 and these at stage 3 do, I think, make a good bill better and clearer, and I would encourage Parliament to support all the amendments in this grouping. Thank you.
Thank you very much. Yes, are you pressing and withdrawing your amendment?
Pressing 191.
You're pressing it, right. So the question is that Amendment 191 be agreed to. Are we all agreed? Yes. We are. Thank you. I now call Amendment 106 in the name of the Cabinet Secretary. Already debated with Amendment 101. Cabinet Secretary to move formally.
Moved.
Thank you. So the question is that Amendment 106 be agreed to. Are we all agreed? Yes. Thank you. I now call Amendment 107 in the name of the Cabinet Secretary. Ready to debate with Amendment 101. Cabinet Secretary to move. Thank you. The question is that Amendment 107 be agreed to. Are we all agreed? Yes. Thank you. Call Amendment 108 in the name of Liz Smith. Liz Smith to move or not move? Moved. Thank you very much. So the question is that Amendment 108 be agreed to. Are we all agreed? Yes. Thank you. I now call Amendment 109, 110 and 111, all in the name of the Cabinet Secretary and all previously debated, and I invite the Cabinet Secretary to move Amendments 109 to 111 en bloc.
Moved en bloc.
And does any member object to a single question being put on Amendments 109 to 111? As it appears no member does, the question is that Amendments 109 to 111 are agreed to. Are we all agreed? Thank you. Now move to Group 18 and call Amendment 192 in the name of Adam Ingram, grouped with Amendment 201. Mr Ingram to move Amendment 192 and speak to both amendments in the group, please.
Thank you. I rise to move Amendment 192 in my name. Presiding Officer, there's been a warm welcome for the First Minister's announcement last month to extend the entitlement of free school lunches to all primary 1 to 3 children in Scotland from January 2015, and that's not least from long-time free school meals campaigners like the Child Poverty Action Group. Now, the Children and Young People Scotland Bill is an opportunity to make sure we have a fit-for-purpose legislative foundation for the provision of free school lunches to deliver on this commitment. The amendments I propose reach, I think, a compromise between the wishes of some to use primary legislation to compel local authorities to honour the First Minister's commitment and the desire of ministers to work with COSLA to negotiate implementation of the commitment. The purpose of Amendment 192 is twofold. It gives education authorities the power to provide school lunches free of charge to pupils who satisfy such conditions as the authority thinks fit. But it also imposes a duty on education authorities to provide certain pupils, that is prescribed by regulations, with school lunches free of charge. So the first purpose removes the anomalous duty for education authorities in most circumstances to charge for school lunches. They will be able to choose conditions as they see fit where they will provide free school lunches. It also allows flexibility and is consistent with other legislative provisions for food or drink in schools. The second purpose, the enabling power, will allow government to absolutely ensure that local authorities provide free school lunches to children in primary 1 to 3. It goes beyond but complements the existing benefit-centric enabling powers which allow ministers to prescribe what benefits a parent or carer or a pupil themselves must receive to be eligible for a free school lunch. It gives ministers the powers required to prescribe circumstances where a free school lunch must be provided. Now, Amendment 201 primarily amends two important duties of education authorities as introduced by the Schools Health Promotion and Nutrition Scotland Act 2007. First, the duty set out in Section 53A2 of the 1980 Act on authorities to take reasonable steps to ensure that every pupil who is entitled to school lunches free of charge receives those lunches. And second, the duty set out in Section 53B of the 1980 Act on authorities to take reasonable steps to protect the identity of a pupil receiving a school lunch free of charge. It is right that these provisions extend to free school lunches provided under the changes proposed in Amendment 192. However, the effect of the amendments means that free school lunches may now be provided to more pupils than those who receive or whose parents receive certain benefits. For example, in the implementation of free school lunches to all primary 1 to 3 pupils, in those circumstances, the potential stigma associated with free school lunches will not arise. In such cases, it will be neither necessary nor possible to protect the identity of pupils receiving free school lunches, and therefore it would be inappropriate for that duty to continue to apply to education authorities. Therefore, I propose that ministers have the power to prescribe, through regulations, circumstances when the duty in Section 53B to protect identity will not apply. Thank you, Presiding Officer.
Thank you very much. I now call Malcolm Chisholm.
Very briefly, Presiding Officer, because of the time, I'd just like to make clear that I and I know my colleagues warmly welcome and support the amendments that have been put forward today, as indeed we support the bill. I know nobody in the Chamber today is going to misrepresent our position on this matter, although clearly a few weeks ago our position was misrepresented because of our passion for childcare for two-year-olds. Clearly, we did think that was a higher priority, but I'm sure every member of the Chamber here today can grasp the concept of good and better. We thought that would have been a better policy, but we certainly think this is a good policy. Can I just make 2 points about it? I think I've raised this with the Cabinet Secretary in other contexts. There is actually a bit of an issue about capital provision for this, because I certainly know some schools, I can think of at least one in my constituency, which will not be accommodated within current dining room facilities, the increased number. So I think that is an issue that will have to be looked at, and according to John Swinney, that is being discussed with COSLA. But I think the final point, and this is a very important one, is that this is an important health policy. Potentially, the main discussion has been about the financial relief it will give to parents, but clearly, potentially, it is a great health policy, and I think an even greater focus on nutritional guidelines would make this good policy even better. Thank you.
Thank you. Now call on Bob Doris.
Thank you, Presiding Officer. I rise to support the amendments in the name of my colleague Adam Ingram. Presiding Officer, I'm delighted to see a political conversion by some in this chamber to free and nutritious school meals. It is, of course, a pro-health, anti-poverty and social equality measure. I'd also like to put on the record my personal view that the end point in the medium term for me would be to extend this to primary 7. That is my personal firm view. I've said before over the years that there are no rich children, there are no poor children, there's just children, and every child should be guaranteed a free, nutritious school meal, no matter their parental income. That is the right thing to do, no matter what others have said in the past. So I have to say that whilst there are no rich or poor children, there can be poor political commitment. And that is why we must entrench within this bill the power to compel local authorities, should they choose to flout the will of this Parliament. Let me finish off by saying, Presiding Officer, that Glasgow Labour Council have been calling for free school meals for P1 to P3. The SNP Opposition Council Group have found the money to deliver those free, nutritious school meals early from August this year. I now hope that Glasgow Labour Council, in the spirit of unity and that political conversion, support the SNP in Glasgow and deliver early on our very, very important, significant free school meals commitment. I urge you to support the two amendments on behalf of Adam Ingram.
Thanks very much. Kezia Dugdale.
Thank you, Presiding Officer. Consensus breaks out and then Bob Doris speaks. Can I say, Presiding Officer, that we're very happy to support Adam Ingram's amendments. The points he raises about flexibility are very important. I think we do need to remind the Chamber, however, Presiding Officer, that we do have no capital assessment of what it's going to cost to provide free school meals. That matters in the context of the debate and the inability of the Government to come forward with the correct financial memorandum that we can assess, but it's also about the reality of how this is delivered. And it's important for two reasons. I know from schools in Edinburgh, as Malcolm has already pointed out, that there will be capacity issues around seating all children at one time to have a school meal. Even if we're going to get close to 75% of children receiving a free school meal, that will be incredibly difficult. But it's not just school halls, school assembly rooms, it's kitchens. We know that kitchens in schools across Scotland cannot accommodate cooking this many meals from scratch. Now, if we don't cook them from scratch, what we're going to end up doing is contracting out making free school meals to private companies which strive in a low-wage economy, that will produce poor food, that will only just meet the nutritional standards of free school meals. And then we have to ask ourselves, what have we actually achieved during this process? So the legitimate concerns exist. They remain, Presiding Officer, around the degree to which that this is resourced, particularly with regards to capital investment. That said, we are very pleased and very happy to support Adam Ingram's amendments this afternoon.
Many thanks. Liam MacArthur.
Thank you, Deputy Presiding Officer. Can I welcome the decision by the Scottish Government to follow the lead set by the UK Coalition Government in delivering what Bob Doris described as a progressive anti-poverty and pro-health measure. I think it's unfortunate the committee did not have the opportunity to scrutinise the proposals in detail, but certainly understand the reasons for that. And I think the reasons are considerably more justified than they are in relation to the substantive changes to childcare provisions that arrived at well past the 11th hour. Nevertheless, as with the extension of childcare for 2-year-olds, I think the Parliament and indeed the Education Committee will want to keep a close eye on how these proposals are rolled out to ensure that they are properly funded, as Kezia Dugdale and others have referred to, and delivered to children in P1 to P3 right across the country. In that respect, I thought Adam Ingram, and the way that he set out the issues and the choices that we are facing as a Parliament, was very fair in that analysis, and I think the amendments that he is proposing in this grouping offer a pragmatic and a flexible way of proceeding, and on that basis we are happy to support those amendments. Thank you.
Many thanks. And I call on the Cabinet Secretary, Mike Russell.
Thank you, Presiding Officer. And can I welcome the position that the Labour Party is now taking, the sensible position the Labour Party is now taking. It was nice to hear Malcolm Chisholm on form. I would think that Malcolm Chisholm is at his most convincing when he's arguing for what he believes in, and clearly he believes this. Unfortunately, he's not been doing that very often in recent days, but it's good to see him doing it today. Let me address the issue of capital provision, which he raised pleasantly. I think Kezia Dugdale didn't raise quite so constructively. There is a great deal of experience on the capital provision required. The SNP pilot that took place in 2007-2008 and the report of that pilot does give some very interesting indications of how this can be done. And together with COSLA, we will work our way through to make sure that this can be done. Now, I really would like to make some progress on this. I did hear the point you made. I just want to make sure it's been long in the day, and although Duncan McNeill is still shouting, Presiding Officer, the rest of us would like to finish this bill and make it happen. I mean, Labour has already tried to stop this bill today. Why don't we just complete this bill today? Now, I would thank Adam Ingram. It's a pity that the outbreak of goodwill is finished so soon, but there we are.
A little bit of calm, please. Calm down, everyone.
Thank you, Presiding Officer. Can I thank Adam Ingram for the amendments lodged today? They follow and support the First Minister's recent announcement to extend the entitlement of free school lunches to children in primary 1 to 3 in Scotland from January 2015. No, thank you. I'd like to make some progress. There are many benefits to extending the provision of a healthy school lunch free of charge in Scotland's schools. Not only will it save families throughout Scotland Don't tempt me, Mr Bibby. Not only will it save families throughout Scotland around £330 a year per child who takes up their entitlement to a free lunch every day, it removes any possibility of free school lunches being a source of stigma and encourages healthy eating habits. As Adam Ingram set out, these amendments do two things. First, they give Scottish ministers the power to place local authorities under a duty to provide school lunches free of charge to certain pupils prescribed in regulations, whether that be by reference to their yearly stage of education or another description. With regard to this announcement, I've been clear from the start. I fully intend to implement the extended eligibility of free school lunches in partnership with local government. Providing that agreement can be reached to ensure their full implementation, there would be no need to call upon these powers, and I would happily say today that I have no intention of invoking them if we can get a clear partnership agreement to take this forward within the timescale about which we are talking. Dialogue is taking place with COSLA to agree how the commitment can be delivered without having to put this duty on local authorities. Sensible and timely to put the powers in place. But I am quite sure that, given that the Labour Party has shown such strong backing for this now, then an outbreak of sense will also take place in COSLA. Secondly, the amendments proposed give education authorities the power to provide school lunches free of charge to pupils who satisfy such condition as the authority sees fit. While these provisions would replace the existing powers to meet the commitment to provide free school lunches to children in primary 1 to 3 via the provision of school lunches disapplication of the requirement to charge Scotland Order 2008, they go further and they allow education authorities the flexibility that they don't currently have to provide free school lunches to children they identify as benefiting from one. The consequential amendments relating to the duties to ensure that every pupil who is entitled to school lunches free of charge receives those lunches and to protect the identity of pupils receiving free school lunches are appropriate. To get the full benefit, it is important that schools promote free school lunches and take reasonable steps to ensure that those entitled take them. That is particularly important where the reasons for entitlement arise from a circumstance which may disadvantage the child. Equally, it is important, where appropriate, to reduce the burden on local authorities. I welcome the amendments which will allow ministers to disapply the Education Authority duty to protect identity of those receiving school lunches where there is no benefit in so doing. These amendments future-proof the legislative framework. They allow local authorities freedom to meet the needs of the children and young people for whom they are responsible through the provision of a healthy lunch at school, and they allow the government to amend or extend, and I note that point, amend or extend entitlement to a healthy free school lunch. I repeat, Presiding Officer, the purpose of this is to provide a power. There is no requirement nor need to use that power, providing we can work together in partnership. That is what I wish to do with local authorities, and to be fair, I think the indication of local authorities that's what they wish to do with the government, in which case we will all be happy, and even the Labour Party is happy now. What more could be called for?
Many, many thanks. Now call on Adam Ingram to wind up. Briefly, if you could, Mr Ingram, please.
Well, thanks very much, Presiding Officer. There seems to be an outbreak of consensus, repentant sinners everywhere. So I'm quite happy to leave the debate at that particular point and urge members to support the relevant amendments. Thank you.
Thanks. And so the question is that Amendment 192 be agreed to. Are we all agreed? Yes. No, we are not agreed. There will therefore be a division. This will be a 1-minute division. The result of the vote on amendment number 192 in the name of Adam Ingram is yes 98, No 15. There were no abstentions, and the amendment is therefore agreed. We now move to Group 19, and I call Amendment 193 in the name of Liam MacArthur, in a group of its own. Mr MacArthur, to move and speak to Amendment 193, please.
Thank you, Deputy Presiding Officer. At stage 2, I moved various amendments prompted by recommendations from putting the baby in the bathwater, an excellent report prepared by a wide-ranging group of expert organisations and individuals. All of these amendments had one thing in common, over and above the fact that not one of them was accepted by the Government, and that was the need for a ruthless focus on preventative action and the earliest possible identification of support needs. That again is the rationale behind Amendment 193. As I made clear at stage 2, I firmly believe that the Additional Support for Learning Act is one of which this Parliament and all parties within it can feel rightly proud. 10 years ago, however, our understanding of the crucial importance of the earliest years to later success at school and more generally was less robust. Prevention was only starting to guide Scottish public policy. As the authors of Putting the Baby in the Bathwater report identified, there does now appear to be a case for addressing shortcomings in the ASL legislation that would not be picked up through revisions of the ASL Code of Practice. Although children are officially covered by this Act from birth, its implementation has not equally benefited children below the age of 3. This is both unwise and unfair. Two things, I think, make the ASL Act stand out. One is that children who need extra help for whatever reason have a legal right to receive it. The other is its broad definition of the types of extra help that can be provided. Both these excellent features of the Act apply to all children and young people across Scotland, unless they are under school age. For our youngest children, the ASL Act can only help them if they qualify under the Disability Discrimination Act. Why deny access to assessment and additional support during the first 1,001 days of life, when young children and their parents could be most effectively and inexpensively helped by genuinely early intervention? Why make them wait until they reach school age before they become eligible? Amendment 193 therefore removes the subsection that has proven to be a major obstacle to some very young children getting what they need, help to which they would be entitled were they older. Let's not forget that many ASL needs, for those such as those associated with communications difficulties, autism and fetal alcohol harm, emerge between the age of 2 months, when universal health visiting usually ends, and 27 to 30 months, when the new universal health checks will start. A waiting period of more than 2 years is a long time in the life of an under-school-aged child. As a result, some preventable problems are not being prevented, and some ASL needs that could have been identified and met through early intervention instead are overlooked and consequently grow worse. Given the fate of my earlier amendments on behalf of the Baby in the Bathwater Coalition, I am realistic about the prospects for Amendment 193. However, while the Minister rejected those amendments at stage 2, she did offer assurances that their policy intentions would be incorporated into secondary legislation, regulation or statutory guidance. I hope that this remains the case and the Minister will reaffirm her intention to engage directly with this diverse coalition and others to assist in the development of all relevant guidance. The devil is in the detail, and the input of this group of experts can help translate good intentions into detailed policy implementation. For now, I look forward to the comments from the Minister and indeed other colleagues and move Amendment 193 in my name.
Thanks. Minister?
Thank you, and I thank Liam MacArthur for the points he has raised, and of course the Baby in the Bathwater campaign for those amendments. But we believe the proposed amendments relating to the Education Adults Additional Support for Learning Scotland Act 2004 is unnecessary, and I'll go on to outline why, but hopefully will at the end provide the comfort that Liam MacArthur might need, as he indicated he would like to hear in my remarks. Amendment 193 seeks to extend the current duties on education authorities under the ASL Act to apply to all children under school age and not receiving school education. As indicated at stage 2, the Scottish Government absolutely supports the principle of prevention and early intervention, especially where it might prevent an additional support need developing or worsening. That is why the Children and Young People Scotland Bill already contains a number of provisions which focus on early intervention and prevention. A child's well-being is assessed from birth during the contacts set out in the Child's Health Programme, which now includes a 27 to 30-month universal health review. Where a child's wellbeing needs require it, their named person will initiate a child's plan in partnership with the child, their family and relevant professionals. That child's plan will take account of learning needs. This will ensure that the learning needs of children under school age are met alongside any other needs which may affect their wellbeing. Indeed, a crucial part of the named person's role is to promote, support and safeguard children's wellbeing. As a result of these provisions in the bill, it's not necessary to extend the ASL Act in the way that has been proposed. The provisions of the Children and Young People Bill provide the necessary protection for these vulnerable children. And as I said at stage 2, the Advisory Group for Additional Support for Learning has agreed that prevention and early intervention through the early years is a very important issue. I indicated that the revision of the Statutory Code of Practice for Additional Support for Learning is already underway, and committed that the Code of Practice will specifically include a focus on prevention and early intervention, and that representatives from the Baby in the Bathwater campaign will be included in that process. As I also said then, the revised Code of Practice will be subject to full consultation and parliamentary scrutiny as required by Section 27 of the ASL Act. This Code of Practice will also be closely aligned with statutory guidance on the Child's Plan and on early learning and childcare to make sure all related guidance is clear and consistent. Now, I believe Amendment 193 is unnecessary and that account has already been taken of the issues that it seeks to address in the Children and Young People Bill provision. Therefore, we don't support this amendment. But in what is now the penultimate group of amendments, I again reiterate my thanks to the Baby in the Bathwater Coalition for their work, not just in this set of amendments, but more generally throughout the course of the bill's progression. Their experience, their knowledge, their expertise will enable us to get guidance right. And I also want to thank Liam MacArthur for allowing committee and Parliament to discuss what is a very important issue.
Thanks. Liam MacArthur to wind up and press withdraw his amendment.
Thank you very much. And can I thank the Minister for her comments and for the assurances at the end of her contribution there. I welcome the restated commitment to prevention and indeed for the confirmation that the coalition behind the Baby in the Bathwater report will be involved in the ongoing review. I have to say I was intrigued by earlier comments that I think the Minister made in relation to Siobhan McMahon's amendments regarding the rights of children and young people with disabilities, where I think the point was being made that we shouldn't be making a distinction between different types of children and young people. I think the anomalies that the Coalition have highlighted in relation to the operation of the ASL Act do appear to suggest that there is a distinction made between the treatment of those at school age and those in the first 1,000 days of life. I acknowledge the point about the Universal Health Review at 27 to 30 months, but it does, to me, appear as if that gap remains. I'm sure this is something that the review group will return to as part of their work, but for the time being, I thank the Minister for her commitment and will not be pressing Amendment 193.
Many thanks. And Mr MacArthur is not pressing his amendment, and does anyone object to him withdrawing his amendment? In the absence of anyone objecting, we'll now move to Amendment 179 in the name of Siobhan McMahon, already debated with Amendment 128. Siobhan McMahon, to move or not move?
Move.
Thank you very much. And so the question is that Amendment 179 be agreed to. Are we all agreed? We are not. There will therefore be a division, and this will be a 1-minute division. The result of the vote on amendment number 128 in the name of Siobhan McMahon is yes 39, no 75, and the amendment is therefore not agreed. which now takes us to Group 20, and I call Amendment 194 in the name of Siobhan McMahon in a group of its own. Siobhan McMahon to move and speak to Amendment 194, please.
Thank you. The Minister's commitment at stage 2 of the bill to ensuring that the distinctive needs of children with speech, language and communication issues will be addressed by guidance and to work with appropriate organisations are welcome. In making these commitments, the Scottish Government has, it seems, already accepted the irrefutable link between speech, language and communication and improving outcomes for all of Scotland's children and young people. Indeed, key policy and initiatives such as the Early Years Collaborative and GIRFEC identify speech, language and communication development and capacity as fundamental to making sure Scotland is the best place to grow up for all children and young people. The Children and Young People's Bill aims to secure equality of outcome for all children and young people, regardless of where they live or their home circumstances. Optimising the speech, language and communication development of every child in Scotland must be at the heart of that process. Significantly, although a lot of the Scottish Government's policy and initiatives recognise the fundamental importance of speech, language and communication development and capacity, Scotland, unlike other parts of the UK, has no comprehensive strategy which focuses local authorities, health boards and other key agencies on ensuring that SLC development and capacity is optimised for all children and young people. A national speech, language and communication strategy would provide clear direction, cohesion and focus for all responsible authorities on how to optimise speech, language and communication development and capacity for Scotland's children and young people. Currently, local authorities and health boards across Scotland pursue different approaches to speech, language and communication development. For example, in some parts of Scotland, health and education and other professionals, from prenatal to secondary school, work effectively together to optimise on speech, language and communication development and capacity. In other parts of the country, however, this evidence-based approach is less apparent. A national speech, language and communication strategy would drive consistent, quality-assured, evidence-based approaches to speech, language and communication development and capacity and help to improve outcomes for all children and young people in Scotland. Linked to this inconsistent approach, there are significant variations in the levels of shared ownership and investment in speech, language of communication development across Scotland. For example, some local authorities have withdrawn funding for speech and language provision, arguing that investment in these key areas of children and young people's development represent additionally or is simply unaffordable. A national speech, language and communication strategy would also help to drive multi-agency ownership and investment in this fundamental life skill. Independent evidence tells us through such effective investment partnerships would be able to enjoy their share of the estimated annual £58 million preventative spend savings which arise out of quality speech, language and communication services. The CYP-Bill aspires to equality of outcomes for all children and young people. A national speech, language and communication strategy would act as a key foundation for the realisation of that aspiration. I call on the Minister to make a commitment to developing a national speech, language and communication strategy, or to enter into a dialogue with interested parties as soon as possible about the need for and benefit of such a strategy and how this can be taken forward. I move Amendment 194.
Thanks. I now call on Mark MacDonald.
Thank you, Presiding Officer. The commitment which the Minister gave at stage 2 regarding guidance followed on from amendments tabled by myself and Jane Baxter around speech and language and communication, and this amendment was one of those amendments at stage 2. And at the time, I said that I had sympathy for the thrust of the amendment, but I didn't feel that the face of the bill was the place for this to be. As somebody who has personal experience in terms of the role that speech and language and communication assistance can play in a family's life, I recognise entirely the points that have been made by Siobhan McMahon and would agree entirely at the importance of ensuring effective speech and language and communication therapy where possible and where necessary. What I would say is that I think that at this stage, I think we need to have further discussion, possibly on a cross-party basis, around this issue, and that was a point I made at stage 2 and I think still stands at stage 3. And I'm more than happy to sit down with Siobhan McMahon, Jane Baxter, others from across the chamber and talk about what the best way to proceed is. I know we've seen success in terms of, for example, the National Autism Strategy, and that has perhaps formed some of the thinking in this, but it may be that there are other means that could be pursued. Some of this could be captured in guidance, some of it could be pursued through other methods, and I think perhaps a broader discussion around this between interested parties on a cross-party basis, I think would yield more than having this amendment on the face of the bill at this stage. But I'll be interested to hear the Minister's views, but I'm seeing indications that that is something that members are broadly agreeable to.
Thank you. Liam MacArthur.
Thank you. Can I congratulate Mark MacDonald, Jane Baxter and Siobhan McMahon for their efforts on this issue through the course of Stage 2 and Stage 3. I think I would hope that those efforts will be rewarded with either a firm commitment from the Minister to bring forward a strategy encompassing speech, language and communications, or at least, as Mark MacDonald was indicating, a process through which these issues can be taken forward. I recognise that Amendment 194 is intended to probe and is not necessarily for incorporation in this bill. I do think, however, it has a relevance to some of the issues highlighted in discussion around earlier amendments. As I said at the outset, this bill should be about putting children's rights front and central, making their voice heard. Self-evidently, this is influenced by a child or young person's capacity to communicate, to understand information and express views. Moreover, it can also have a bearing on assessments of maturity and capacity, key to the amendments I moved earlier in relation to information sharing. So I think the issues raised by Siobhan McMahon and earlier by Jane Baxter and Mark MacDonald, while not appropriate for the face of this bill, are highly relevant to it, and I look forward to seeing a proper strategy being developed and emerging in the near future. Thank you.
Thank you. And finally, Malcolm Chisholm.
Very briefly, I think it would be very helpful if the Minister could make a statement of intent, and if that is done, I'm sure members will not mind if it is not on the face of the bill. As Siobhan McMahon said, there has been a lot of mention in policy about this, but there is no strategy. I don't need to remind the Minister that the stretch aim of the Early Years Collaborative is that all children reach their developmental milestones, including age-appropriate communication skills, by 27 to 30 months. And in fact, it's communication and language needs that are the most common developmental difficulty experienced by children and young people. So this is central to the agenda we're discussing today. It's also very much a social justice and inequality issue, because these speech and language difficulties are very often related to current social disadvantage and disadvantages in later life. So I do hope we will have a statement of intent today.
Many thanks. Now call the Minister.
Thank you. My comments on Amendment 194 by Siobhan McMahon are similar to those about Amendment 254 by Jane Baxter at Stage 2. This bill has been drafted to ensure that the needs of any particular group of children will be supported by different sets of provisions. This includes speech, language and communication needs. Creating additional specific statutory duties and provisions for communication is not, as Mark MacDonald and I think others have suggested, for the face of the bill. In this context, the specific needs of different groups of children are best addressed through guidance, and we've committed to ensuring that the distinctive needs of children with speech, language and communication issues will be addressed by guidance as appropriate. Taking on board the important points that Siobhan McMahon raised around consistency and other issues as well, but certainly around consistency I remember her talking about. Now, we will be drawing, in constructing this guidance, we will be drawing on the expertise and the experience of, for instance, the Royal College of Speech and Language Therapists to help with this, and ensuring that others can contribute to this guidance, and we can draw upon the expertise that's been articulated within the debate so far from Mark MacDonald, Jane Baxter, Malcolm Chisholm, Liam MacArthur and others, to make sure that we can get this guidance absolutely right. So I will make a commitment to make sure that we can speak with others on a cross-party basis to ensure that the guidance can be influenced by the clear desire by others to make sure we get things right around speech and language support.
Thanks. Now calling Siobhan McMahon to wind up and press a withdrawal amendment.
Thank you, and thanks for the members who took part in supporting this probing amendment. I agree with Mark MacDonald in that if we can get this cross-party support for this strategy going forward and for discussions, not only across the parties but with the organisations who have asked for this amendment, that will benefit all young children. Of course, that's all we want, and I welcome the assurance from the Minister at this point, and therefore I withdraw my amendment.
Thank you very much.
Does anyone object?
And does anyone object to Siobhan McMahon withdrawing her amendment? And as no one appears to, we'll move on to the next amendment in the name of Liz Smith, already debated with Amendment 1. Liz Smith, to move or not move, please. Thank you. And does anyone object to that amendment being withdrawn?
No.
Thank you. Right, and call Amendment 195 in the name of Jane Baxter, already debated with Amendment 180. To move or not move?
Not move.
Thank you. So I now call Amendments 112, 90, 113 and 91, all in the name of the Minister and all previously debated. I would invite the Minister to move these amendments en bloc.
Moved en bloc.
Does any member object to a single question being put on these amendments? And as no one appears to, the question is that Amendments 112, 90, 113 and 91 are agreed to. Are we all agreed? We are. I now call Amendment 54 in the name of Liz Smith, already debated with Amendment 51. Ms Smith, to move or not?
Not moved.
Thank you. I call Amendment 114, therefore, in the name of the Minister, already debated with 51. Minister, to move, please.
Moved.
Thank you. So the question is that Amendment 114 be agreed to. Are we all agreed? We are. Thank you. Call Amendment 196 in the name of Siobhan McMahon, already debated with Amendment 128. Siobhan McMahon, to move or not?
Not move.
Thank you. We now call Amendment 115 in the name of the Minister. Minister, to move formally.
Moved.
Thank you. And
yeah. Next question is amendment.
yes. So
yeah, what's this?
I call amendment also. Thank you. 115A in the name of Neil Bibby, already debated with Amendment 51. Mr Bibby, to move or not move?
Not moved.
Thank you. So the question is that Amendment 115 be agreed to. Are we all agreed? Thank you. I now call Amendment 197 in the name of Neil Bibby. Mr Bibby, to move or not?
Not moved.
Thank you. So I could now call Amendment 50 in the name of Liz Smith. Ms Smith, to move or not?
Not moved.
Thank you. I call Amendment now 198 in the name of Liam MacArthur. Liam MacArthur, to move or not?
Not moved.
Thank you. Call Amendment 199 in the name of Liam MacArthur. Mr MacArthur, to move or not?
Not moved.
Thank you. Call Amendment 200. Mr MacArthur, to move or not?
Not moved.
Thank you. Call Amendment 201 in the name of Adam Ingram. Mr Ingram, to move or not?
Move.
Many thanks. And so the question is that Amendment 201 be agreed to. Are we all agreed? Yes. We are not agreed. There will therefore be a division, and it will be a 30-second division. Please cast your votes now. Oh, it's a 1 minute. I beg your pardon. The result of the vote on amendment number 201 in the name of Adam Ingram is yes, 115. There were no, 0. There were no abstentions. And that ends consideration of amendments. And the other piece of good news is that the Scottish men's curling team are through to the final in the Olympics. And before we start the next item of business, I would like to say to Parliament that as a consequence of the earlier decision to extend the debate on amendments by 30 minutes, the decision time will also be moved by 30 minutes, and therefore decision time will now be at 8:30. So, with your approval, if we point of order, Malcolm Chisholm.
On Rule 9.3.2, this has obviously been raised before, but I think it is very important before stage 3 that we do have a statement from the Cabinet Secretary about the issue that was raised by the convener of the Finance Committee this morning. We know that under Rule 9.3.2, the best estimates should have been provided on the capital costs and have not been provided. So I do hope at least we can get some indication from the Cabinet Secretary in his speech of why that information has not been provided and when it will be provided.
I thank Mr Chisholm for his point of order, but I would refer him, as has been said previously, Parliament passed a financial resolution for this bill on the 21st of November 2013. The resolution stated that the Parliament, for the purposes of any act of the Scottish Parliament resulting from the Children and Young People Scotland Bill, agrees to any expenditure of a kind referred to in paragraph 3b of Rule 9.12 of the Parliament Standing Orders arising in consequence of the Act. So, we will now move on to the next item of business, which is debate on motion number 9050 in the name of Aileen Campbell on the Children and Young People Scotland Bill. I'd invite members who wish to speak in the debate to press the request to speak buttons. And Ms Campbell, call on you to speak for 10 minutes, no more, please.
Thank you, Presiding Officer, and for the update on the curling. That was very welcome indeed. Now, I'm pleased to open this Stage 3 debate on the Children and Young People Scotland Bill, and I'll start by thanking everyone who has been involved in the development and the scrutiny of this landmark piece of legislation. In particular, all 3 parliamentary committees for their detailed examination of the bill, and not least following 4 3-hour Stage 2s and a 5-hour Stage 3, the Education and Culture Committee. Their careful and very balanced consideration of the proposals has resulted in a bill that better captures the principles which this chamber endorsed in the Stage 1 debates. I'm genuinely appreciative of all the work from the committee members indeed. I also wish to thank everyone who responded to our consultation and who have been involved in the development of the bill, especially the 2,400 children and young people and 1,500 parents who shared their views. I also want to put on record my absolute thanks and gratitude to all the government officials who have absolutely worked tirelessly and with dedication on this bill. I sincerely appreciate their hard and very fine work indeed. Now, we have listened carefully to all that has been said. Since day one, this collaborative approach has allowed the bill to evolve into an extraordinary piece of legislation, one that will convey our aspirations to improve well-being of our children and to help make Scotland the best place to grow up. This legislation will place our commitment to early years on a statutory basis, as much through our proposals to transform early learning and childcare as through requiring children's services plans to demonstrate early intervention and primary prevention. Through the named person, it will put in place a universal approach to promoting, supporting and safeguarding every child's well-being by working with families. The named person, albeit not supported by everyone, however, will be at the single point of contact that parents told us they wanted, whose job is to ensure that children, young people and their families get the support they need when they need it. In our provisions on care and aftercare, the bill will change the way that our most vulnerable children and young people make that very difficult transition through and out of care when the time is right for them, ensuring that appropriate support is there at every stage on the way. We are placing a duty on local authorities to provide services to families where there is a risk of a child becoming looked after. We are supporting the invaluable work of kinship carers by requiring authorities to provide assistance to carers where the child is at risk of becoming looked after. We are strengthening the impact that corporate parenting can make, and we are helping those children who need to proceed to adoption by making the use of the National Adoption Register compulsory. And for the first time, the bill puts children's right at the heart of the public sector and government. It will ensure ministers assess all future decisions against the rights of children and will require public bodies to embed rights in the frontline services that our children and families rely on day in, day out. These overall intentions have not changed during this bill process, but what has changed is how the bill can achieve these intentions. And we have welcomed and put forward many suggestions for improvement at Stage 2, the result of a shared recognition of the importance of this legislation and our common ambitions. As I've always said, this bill is a starting point for the expansion of early learning and childcare. This is the first time that flexibility and choice have been put on a statutory footing. This bill sets the stage for our longer-term aim to develop high-quality, flexible early learning and childcare that is accessible and affordable for all children, parents and families. We've always intended to open out entitlement through secondary legislation where it is affordable. So I was absolutely delighted that the First Minister announced on the 7th of January that we will increase the entitlement of free learning, early learning and childcare from August this year to those 2-year-olds in families which are workless or seeking work, 15% of that age group. This will be followed in August next year by those 2-year-olds meeting the free school meals criteria, 27% of 2-year-olds, more than 15,000 children. This is a phased, sustainable expansion of early learning and childcare to more vulnerable 2-year-olds. We are focusing first on those families who are most in need and who will benefit most from an expansion of funded hours. Not only will this improve the life chances of children, it will also provide opportunities for parents and families to benefit from support into training or sustainable employment. In the Scottish Government's White Paper, Scotland's Future, we have set out phased plans to achieve 1,140 hours per year for all children aged between 1 and 5, starting with an increase to half of all 2-year-olds. The expansion set out in the bill is a significant step towards realising that vision and that ambition. In addition, on the 7th of January, the First Minister announced that all school children in primaries 1 to 3 will receive free school meals from January 2015. The benefits of this to both children and families are significant, have been commented on as the motion was passed earlier on. Yes.
Could I congratulate the Minister and indeed the Parliament for coming to this sensible decision, particularly with regards to children, the meals being provided universally. Now, let me tell you from experience the benefit that a child will get. A child who is anonymous when getting a free school meal, who perhaps their families couldn't afford it, will actually eat it, rather than going away and not participating because they're likely to get bullied and bad attention by the day. And I can tell you they will withdraw, and therefore, because that this Parliament has decided the way we're doing it, children that really need a good square meal will get it, and they will be healthy for the rest of their lives.
Can I thank Gil Patterson for his intervention? The benefits of this to both children and families are significant, not least because it will tackle some of the issues around stigmatisation around accessing free school meals, which Gil Patterson has outlined. It will also improve the health and well-being of those children, and it will also mean a saving of around £330 a year per child for those families throughout Scotland. Through the amendments put forward at this stage of the bill from Adam Ingram, who has consistently been committed and dedicated to this policy, we intend to give ministers the power to place local authorities under a duty to provide free school lunches. At the same time, the bill's positive impact on those who are or have been in care has grown. Mindful of the Education and Culture Committee's request to give further consideration to the issue of aftercare, we work closely with key organisations, particularly though Who Cares Scotland, Aberlour Trust and Bernardo Scotland, and introduced a suite of new measures in support of continuing care. Members will be aware that on the 6th of January I announced that starting in 2015, 16-year-olds in foster, kinship care or residential care should have the right to stay